My lord, under a compelling circumstances, I am mentioning one matter upon notice to the other side.
No.
The matter has been taken up yesterday, where your lordship was pleased to direct to not to invoke the bank, not to encash the bank guarantee. Ma'am, it is my duty to bring to your lordship kind notice that the bank guarantee has already been encashed prior to the filing of the
Mention
petition.
Thursday. No.
Ma, upon notice to the other side.
No.
Ma, this has
Call
been,
on the list, please. Yes. No mention.
this has been given.
Your lordship, very
No, I've written clearly in the list only Mondays and Thursdays. Oh, sorry.
lordship small, only lordship
No. On Thursday. Come on.
subject to your lordship approval only.
Call on the list, please.
For judgment, item number 1.
In the above circumstances, WPA 16821 of 2022 is dismissed on contest without any orders to cost. However, it is made clear that the above findings are of a tentative nature only to prima facie explore whether the jurisdictional facts were sufficiently indicated by the respondents. The adjudicating authority, while deciding the issue, shall act independently in accordance with law without being influenced in any manner by any of the observations made herein above. The above observations are without prejudice to the rights and contentions of the parties in the proceeding under Section 26 of the Benami Act. Urgent server copies, if you applied
Yes,
for.
my lord, yesterday when you were rising up, your lordships told that by serving the other sides, you can mention the matter on 10:30 today. Because this is related to the recruitment process that will be closed on 31st March.
Oh, yes, I told you to come at
Today
10:30.
10:30.
Other side is there.
Other side, I have already served the copy.
8 at 2 p.m. near you.
2 p.m. already matter is fixed, my lord. Hoichoi matter.
So then 1 p.m. If the other side is present, only then I'll take up
Then
at 1.
you can fix it on next week, my lord, top of the list in updated matter. On Wednesday.
তাই করো Wednesday তে।
Top of
Not
the
top
list.
of the list, upgraded.
Upgradation already, my lord, there. It is in 25 to 30.
Yes, call on the next matter.
Lordship,
Do we mention item number 3 for release?
3 minutes I appear for the petitioner, my lord. Mr.
Personal ground. Release on let the matter stand released from my list on personal ground with liberty to the parties to mention to take steps for assignment before an appropriate bench.
Release.
Has to appear for the Indian Oil Corporation. Just that he has not been served with a notice of.
My cousin's husband is appearing, so therefore I should not take up the matter. I'll be biased in their favor. That's why. Yes.
Lordship,
Next.
10:30 matter. Item number 4.
Yes.
My lord, I've complied the direction of the court regarding last time the rule was issued against the contemptor. You were satisfied with the contempt allegations,
Yes.
and now kindly allow the petition to move forward for justice, my lord.
My lord, I am appearing on behalf of the alleged contemptor, lordship.
Yes. Why didn't you appear on the last occasion?
My lord,
There was a specific direction rule was issued. Direction was given.
my lord, suppose,
Anyway, what is your
my lord, I am handing over the affidavit on show cause, my lord.
what have you said here?
My lord, as per your lordship's order in the.
Please take the microphone a bit closer, ma'am. Yes.
As per your lordship's order in writ petition number 14243.
Yes.
the order dated
14th
order
July.
dated 14th July, lordship, we have supplied all the information by our letter dated 20th July 2023.
You have annexed that here? Yes.
It is annexed here, lordship.
Yes, Mr. Gopher, do say to this. Have you given a copy of the opposition to them?
No, lordship, I am
They did not
handing
give
over
any.
the-
Take the copy, Mr. Gop. I'll give you 1 week's time to file reply, if any, and we'll take up the matter next Friday week.
Finally, the personal appearance of the alleged contemptor be dispensed with. He is present. in the court
No, you should have then given a copy in advance so that he could tell the court what.
This is not the affidavit in opposition. This is show cause only. Copy.
Yes, show cause. What is?
Show cause.
Look into it. There's an annexure there too. Whether
Any
that
time, 1 week time, my lord.
Yes, yes.
personal appearance, why should I dispense with? On the last occasion, you did not appear.
My lord, he could not understand the spirit of your lordship's order. I tender.
He's a responsible officer. He's not a layman.
Yes, lordship. I tender unconditional apology, lordship, on behalf of the alleged contemptor. my lord.
The alleged contemptor is personally present in court today in terms of the rule issued earlier. Full stop. A show cause on affidavit is filed on behalf of the alleged contemptor. Full stop. Learned counsel for the alleged contemptor submits that the order of this court has been complied with. Full stop. Next para. However, no copy of the show cause notice has been served on the petitioner appearing in person. Full stop. In terms of direction of court, a copy is here and now handed over to the petitioner. Full stop. The petitioner shall file a reply, if any, prior to the next returnable date with an advance copy to the learned advocate for the alleged contemner, full stop. The matter shall next be listed on April 5, 2024 for passing further orders, full stop. For the time being, comma, the personal appearance of the alleged contemner is dispensed with subject to further orders.
My lord, I want to say something. Kindly extend it to 11th April. I have to.
11th April. Then whatever I said, instead of 5th April, it's 12th, 11th, no, 12th April. 12th April is the next Friday. 12th April. His services, his appearance is dismissed with for the present. Thank you. Next.
Contempt application. Item 5.
You are appearing, this is contempt is appearing for the first time.
Your Lordship.
What is the alleged contempt? What is the order which has not been complied?
Learned trial court judge dehodes the law as well as your Lordship's order. And not only that.
No, what has been done? What was the order? Just remind me, please.
You have told that if the violation petitioner to take recourse, if the law flouted of 7172.
Have you annexed that order?
Your Lordship.
Where is that?
I am
Which
happy.
page?
I am happy. If you want.
No, in the contempt application, you must have annexed
Yes,
the order.
yes,
Where is
yes.
that? Which page?
That,
The order dated 10th of January.
10th of January 2019.
Let me just check up. What is the order which is under contempt? No direction was given to the trial judge.
No, actually, the trial court judge,
Yes.
which has flouted not only your Lordship's order, that is that you have mentioned that the petitioner to recourse the law in the event the opposite party have flouted the time limit.
I recorded the present revisional application directed against an order whereby eviction suit was adjourned and the matter was transferred. You submitted, your submission was recorded that since section 7, 1 and 2 envisaged time limit, 30 days trial court acted without jurisdiction. You said that.
Your Lordship.
But I recorded that, however, the impugned order does not decide any right or interest of any of the parties,
That's true.
so not amenable to revision. At that
Lordship.
stage, revision was not maintainable.
Lordship.
But it will be open to you to take recourse of law in the event opposite parties have flouted time limit. You
Your
know the recourse 7.3.
No, your Lordship, now I am coming.
What is the what has been done by the
What is done, I am placing the judgment which has been passed by this court of division bench.
that is a legal issue that has to
No,
be
that-
challenged then independently. Contempt does not lie, Mr. Nandi. Contempt is a violation of the court's order. It's a serious allegation. People are
That is
sent to
the
jail for
7172.
that.
That is 7-1 because in the order itself it has stated that
You have been given liberty to take appropriate steps. So how does the trial judge, learned trial judge commit any
has
contempt?
flouted the 7172, your Lordship.
No, that is no contempt lies. That is a judicial, that is a legal allegation you make. And please don't file this frivolous contempt application, Mr. Nandi. This is absolutely frivolous. I'll impose costs on you. You have filed a contempt application against a judge unnecessarily.
No,
There is
your-
no contempt. I rejected. I did not interfere in your revisional application. I left it to you to file any application if you like.
No, these
There is no. What is the contempt committed by the court?
here the judgment which are there. I am
What is the contempt? Tell me first.
Or-
What has been done by the learned civil judge?
civil judge has done that the judgment which has been passed by the division bench of this court, which has also been violated
How violated? What has been done by the civil judge?
because they have the tenant has been lost.
What has been done by the civil judge or not done? Violated
They have,
how?
They have thrown in the bin because this judgment itself told because they have lost in the trial court, and they have
Yes.
come in the appeal and division bench for technical reasons, that is under section 13, it has been goes against my mother position, which has been that it is left open for the judge. But what is the actual fact is that when the tenant is already established, the tenancy is established, how they can flout it? Because 7172 has to be complied. In your statement also, you have written, your lordship.
In your contempt application, I find no mention of the contemptuous
Your
act.
lordship, page 8.
What is the contumacious
8.
act? Yes, 8 I'm there. What is the contumacious? I read it out.
No, plaintiff has not disclosing the date of defaulter 7172 of the West Bengal Premises Tenancy Act, since plaintiff clandestinely through letter dated 11/7/88 duly acknowledged and signed by the defendant.
So what can the civil judge do?
No, because this has been accepted, because in two occasions, one is the judgment of the division bench of this court and another is the acceptance of this. So how they can flout it, the 7172? That is and you have also told that if the flouting of the orders is there, you can take the recourse.
Take recourse under law. Contempt is not the recourse. If 7172 is violated, sir, either you take help of an advocate or you proceed in your matter in your own way. But you cannot implicate judges like this casually in a contempt application.
No, because if the
This is a serious violation. You are guilty of contempt. I gave you liberty to approach the trial court. I did not spell out in the order, but if you took the help of an advocate, you would know 73, if 7172 is violated, 73 is the recourse. You should have taken that.
I bow down.
There is no contempt at all, no contumacious act alleged even. Whatever the plaintiff is doing, how is the
civil judge guilty?
And you have implemented the judge and filed a contempt application?
I bow down and I would.
No, Mr. Nandi, I will impose exemplary costs on you to be paid to the civil judge junior division.
No, I bow down and I withdraw this.
No question of. Even if you withdraw, no, Mr. Nandi, if you withdraw, I'll permit you to withdraw. Definitely, if you want, I'll definitely permit you to withdraw, but you'll have to pay cost to the civil judge for
Your-
this undue act of harassment.
Your
This
lordship,
practice
please
has to be deprecated. No, Mr. Nandi, no.
No, this is because
This
of
is
the
not
two
personal,
judgment.
personally against you. That's a legal argument. Make before the civil judge. If you lose before the civil judge, go before the appellate court. If you lose there, go to the uppermost forum.
So this time at least you pardon me, your lordship.
The petitioner appearing in person has preferred the contempt application. However, the contempt application has been filed against a judge of the trial court, a learned judge of the trial court. Next para. However, a perusal of the entire contempt application and the prayer does not disclose any contumacious act of on the part of the alleged contemptor. Next para. In fact, the order, which is alleged to be violated, dated January 10, 2019, was passed in CO number 4332 of 2018, where the petitioner's prayer for interfering with an order of the learned trial judge was not granted. Next para, it was recorded in the said order that the impugned recorded that, however, the impugned order does not decide any right or interest of any of the parties and thus is not amenable to revision. However, it was kept open for the petitioner to take recourse of law in the event the opposite parties in the revision had flouted the time limit contemplated in section 7 within bracket 1 and /or 7 within bracket 2 of the Act of 1997 in the code below. Next para. In the contempt application, certain legal arguments have been sought to be made by the petitioner. However, no act of contempt whatsoever is found from the allegations. Next para. It may be noted here that such reckless filing of contempt applications, particularly against a judicial officer in discharge of his judicial duty, without any iota of any contumacious act or omission on the part of the said judge, is thoroughly deprecated. The petitioner, upon the court expressing its minds, seeks to withdraw the contempt application, which is appreciated in a sense. However, for the act of filing a frivolous contempt application, which itself could be construed to be a contumacious act, the petitioner should pay costs to the alleged contemptor. Accordingly, CO number 4332 of accordingly, CPAN 8 of 2023 is dismissed as withdrawn on the prayer of the petitioner. The petitioner shall pay costs to the alleged contemptor to the tune of rupees 10,000 within a fortnight for date
Your
for the
Lordship, I am
frivolous
a
application.
pensioner, so please reduce the amount.
No,
I am a pensioner, Your Lordship.
very well.
Please.
No.
Lordship, just humble.
No, Mr. Nodin, no.
At least you make it 5,000. I
Item
am ready.
6.
I am ready. Just make it 5,000.
No,
Your
no,
Lordship.
no. Next.
Item 6.
Yes, please appeal.
My item number,
Yes, Mr. Mukherjee was there, I've seen. Mr. Chattopadhyay,
my
yes.
item number 6, first of all, I am tendering apology on behalf of the alleged contender for delay in complying of the order, subject to correction by the petitioner. Order has already been complied with. Now, the fault on our part is that your Lordship directed that we will issue the separate bill of current consumption. Now, what the problem we faced is that according to the petitioner, against the theft, he preferred an appeal. 50% has been deposited and remaining is sub judice to the appellate forum. Now, your Lordship said the current consumption separate bill has to be issued. Now, the generation from it will be generated from the machine, but sometimes what happened, it has not been properly generated. Now, it has started properly and the petitioner line has been restored. They have paid. Only this is the contempt, and we have disconnected because non-payment, that is our fault. We misunderstand, now it has been done, if your Lordship pardon the alleged contender.
1 month, my lord, kindly have a look in page
They've
32.
restored now and they are raising current bills.
But against that, my lord, again, my lord, he have issued a bill, my lord, for payment of that outstanding, which is subject.
No, my lord, no, subject to correction, my lord, in the subsequent letter.
Order, page
in the
24, my lord, bottom. They are flouting every month. 3 years, they are flouting this. Well, hence, WPA such and such is disposed of.
Separate bills were directed to be issued indicating correct electricity charges payable by the petitioner in lieu of regular electricity charges and outstanding dues.
Yes.
So outstanding they are entitled to this, but separately
Sir,
from the
separate.
current.
My lord,
What are
the
they
last
doing?
3 years, they did not issue.
No, last 3 years forget. Now
They-
recently they are doing, as he said.
After my lord's order for issuing notice, they directed me to pay 31,000 and 25,000 for 2, my lord. My lord, kindly consider, he is a poor farmer. If
He may be a poor farmer, Mr. Chattopadhyay, we are in contempt. His
my lord, kindly
poverty is
come
not
to
an
this.
issue
My
here.
lord, kindly consider pay
No,
30.
just tell me this. Are they raising separate bills for current charges and outstanding?
My lord, one bill, last bill was issued, my lord, the current charges. But my
So
lord,
they are doing it now.
last, after my lord's order, my lord, kindly come to page 32.
So now if they are complying, what can be
My
done?
lord, kindly come to 32. Every month, this bill is being issued. This notice is being issued. That is contemptuous, my lord.
What notice?
Page 32. I have 10
Outstanding
notice.
dues, yes.
My lord, because the
The order does not say they are not entitled to do this.
my
I
lord,
said that they will separately raise current bills and indicate outstanding dues. Separately means
that
there
has
are
not
two
been done.
components.
That has not been done.
This is outstanding only. This does
Yes.
not include current.
My lord, the
And they're including current bill, current charges, showing current charges in a
yes,
different
my
bill.
lord,
So that
page
has precisely
27,
been done.
page 27 onward, my lord, last 3 years, they did not. My lord, for that reason, I could not pay. My lord, for 3 years.
Mr. Chattopadhyay, your client must know where to stop. They are complying with the order of this court. They are issuing this. What you are showing is a separate charges shown for outstanding
My
dues
lord,
only.
may I pray
And
only?
current charges are being billed separately. So they are complying with the
My
order.
lord, may I pray only? My lord, end of justice. My lord, keep the matter,
For the
contempt matter
end or
pending.
ends?
For the ends of justice.
Hmm.
My lord, keep the contempt matter because
No, I won't
after,
keep it.
after that, my lord, they will again, my lord, disconnected because twice disconnected.
Come again, they'll have to buy a new toothbrush then.
So, my lord, can you make it
The
clear?
petitioner, the alleged learned counsel for the alleged contemner submits, upon seeking pardon for the contemner having previously failed to construe the order in proper perspective, that now separate bills are being issued to the petitioner for current charges and outstanding dues. Whose next para, learned counsel for the petitioner contends that the petitioner is a poor farmer and has suffered in the hands of the WPACTCL unnecessarily due to prolonged inclusion of the outstanding charges along with the current charges. Whose next para, be that as it may, since the alleged contemner has sought pardon, such prayer is accepted. Since the alleged contemner is now issuing separate bills for current charges and outstanding dues, I do not find that there is any further act of contempt. Accordingly, CPN 246 of 2023 is disposed of in the light of the observations. It is made clear that in the event the contumacious act is repeated, comma, the petitioner shall be at liberty to bring it to the notice of the court by way of a fresh contempt, in which case the court will take a much stricter view than the present one.
Grateful.
Thank you. I've made it
Grateful
very-
actually.
Thank you.
It will
Grateful.
help my client.
Yes, yes. Mr. Chair. Next.
Item 7 and 8.
This is the contempt application.
Yes.
Your lordship,
Contempt is only one application, one contempt. Yes.
in two separate writ petitions.
But one order and one
Yes,
contempt.
yes,
Yes.
Your lordship's order was that page 15. Kindly come to the last part. I'll show you.
Page 15. 28. No, no, maybe not page 15.
Paragraph 54. 52, having flouted such norms and standard, impugn clause 27.2 of the works manual, page 28, I'm sorry,
Got it.
is as readopted by it in 2019 is patently vitiated, being arbitrary. What had happened, my lord, CPWD guidelines, this manual, they gave certain guidelines for procurement of steel and they laid down certain conditions. But from time to time, Ministry of Steel issued orders saying that these should be only the criteria for selection of steel manufacturers. That there must be certification by BIS
Right.
in terms of Indian standards.
Yes.
And there were no other criteria which was laid down. CPWD,
Adding criteria.
yes,
So that's why it was held that it's an instrumentality of the central government and therefore this was.
yes.
So what
And
have they done now?
thereafter, my lord, the operative part in paragraph 53 is writ petitions are allowed quashing the modified clause 27.2 of the works manual of 2014 as reincorporated of 2019 and consequential memorandum. CPWD is directed to implement the notification of Ministry of Steel dated such and such.
So
Now,
they
my
were
lord,
to put in only the BIS criteria.
that should be the only criteria.
What they did?
Now, my lord, we find that I've affirmed a supplementary affidavit.
Yes, you probably filed it on the last. Yes, it's with me.
There is a further tender which has been issued later
Yes.
after the disposal of the writ petition. Similar criteria has been mentioned, my lord, in this tender document,
Which
which
clause?
goes against, kindly see page 13, additional conditions for steel reinforcement. The contractor shall procure TMT bars of such and such grade from primary producers. This categorization has been done away with, and they are naming there that these are the primary producers. So
But that's a different cause of action, isn't it?
this was there in
What
the
that was-
CPWD manual.
Yes.
This primary producers, naming of primary producers, this was all there in CPWD 14.
There the allegation was regarding BIS criteria,
Yes. So
but
what
here
they
it's
have-
something else.
No, this was also there.
Acha. So you say this is also a violation of the guidelines.
Yes, because
have not changed
here
the
you are actually naming these manufacturers.
That
And you are-
part
you
of
are-
the allegation.
And you are categorizing primary producers, you have to purchase only from primary producers, and these are the primary producers. So you are not mentioning about BIS certification is the only criteria. Even if I am, say, not a primary producer, but I have my product
point
is
has been
BIS
taken, the order.
certified, then
All right. Very
this
well.
is out.
Very well. Let me hear them first then. Yes, Mr.
But,
Mr. Shen,
challenge-
please take your seat. Both of yes.
Lord, challenging the order, judgment passed by your lordship, Lord, appeal has been preferred. The matter is running in the list.
That is not sacrosanct nowadays.
Lord,
Every matter appeal is being
item,
preferred.
item number 82. Lord, I am praying for Lord,
80.
82 today's list.
Don't take it.
So it will
But,
not be heard this year. I'll keep it.
No, Lord, I'll
sign it.
Lord,
You have to mention it, do something.
means
Even
Lord,
if Mr. Chakravarti is there, you have
live
to do
streaming is
something.
going on, Lord. I cannot say so many things, Lord. Kindly, Lord, give me 4 weeks time, Lord. I will come back.
Mr. Shen, I'll give them 4 weeks time.
I only say this, my lord.
Yes.
I am not standing.
So that
with
is
the-
virtually giving time to the division bench. So we say.
No, I'm not on that. I'm only saying this.
Already appearing in the list.
But again,
82.
but suppose, but again, during 4 weeks, they should not initiate any tender with this type of a restrictive covenant.
In contempt,
4 weeks, it is fine. But they must
Mr.
take.
Shen, should I do that in the contempt application? That because they preferred an appeal. On
No.
that ground, if it is
But,
appeal preference of an appeal does not operate as stay, everybody
but
knows.
they can't
But
take
since an appeal-
advantage. They can't take advantage. I am only saying this.
I'll not put that in my order, Mr. Shen. I mean,
But
I
that-
appreciate what you're saying fully. I mean, he's also understanding. They are also understanding. But
Let it be understood
in-
by my learned
in-
friend. I think it should be
in
sufficient.
contempt petition, I cannot say that probably at
No,
this stage.
Contempt of contempt
Because
petition.
contempt is already filed.
Yes.
I mean, that will be an additional violation in a sense.
Yes, that will be an addition. So
In contempt, saying is that don't violate my order is useless because
so
an
your
appeal.
lordship is exercising discretion only because an appeal is pending, not on any law.
No.
So therefore, when you
To cover that, Mr. Shen, my order is already there, which is under contempt. So that order is there. If that is flouted, then this will also be flouted. In contempt, I cannot do anything further.
Right.
Learned counsel, learned ASG appearing for the alleged contemptor submits that an appeal has been preferred against the order under contempt, which is appearing before the concerned division bench. 4 weeks time is sought for the alleged contemptor to move the appeal and or obtain interim orders. Next para, learned counsel for the petitioner expresses apprehension that in the meantime, further tenders may be floated in violation of the order which is under contempt. However, since the appeal is pending at this juncture, a comment in that regard by the court taking up the contempt application would be rather extraneous. Keeping in view the prayer of the alleged contemptors, the matter is adjourned till April 26, 2024, when it will be listed under the same heading.
Sir, can I make a short prayer, my lord?
Yes, yes.
My lord, 23rd February, it was adjourned on this ground for 4 weeks. Can it be 15th April, my lord? Let us in the midway, my lord, between
No,
4
Mr. Shen, I take these matters up on Fridays. That's
in
why
Friday, but
they've asked for. Very well, I'll check it whether it.
4 weeks and 4 weeks.
Very well. April 19th.
Okay.
That is the previous.
Of like,
My learned friend has moved another writ petition for implementing the earlier order passed by you.
yes,
They can do both.
Yes,
Mr.
yes, yes,
Chakraborty,
sir.
you know.
That
You know.
is-
Don't take these points in this court.
No,
You
I'm
at
not
least
taking
don't.
this point.
You don't take this.
I'm just applying.
You are precluded from taking this point.
because but I can't be satisfied with the punishment. It has to be enforced. That is why the
Mr. Chakraborty and Mr. Tiwari's demeanor is not an indicator of their clients. Not
Absolutely.
necessary.
That is why I filed the second writ.
That I always try to assist you, Lord.
Well, that is why the second writ. When I knew Mr. Chakraborty is coming.
Yes, their demeanor may not be an indicator of their client's demeanor.
Yes, so I will.
That I am
probably-
very well aware of.
I will probably not press the contempt because Mr. Chakraborty is there.
Thank you. Yes.
Item 9.
I am for the alleged contempt.
Yes. Should I remove the alleged or not?
No, my lord, your lordship passed this order. There are
Like
two
challenging.
बोलते दो तुम बोलो. There are two fault in your lordship's order. First order is that
Is there preferred an appeal, Mr.
appeal
Appeal has been disposed
What
of.
is the use of this bolte dao? If my order has been set aside, what would this bolte dao will not take you any?
let me make my submission. The order has been set aside. I told you there are two parts of the order.
Hmm.
First of all, the order is the directing the secretary to issue a license within fortnight. Second
Right.
part of the order, if the delay has been got, that's why cost of rupees 20,000 has been imposed.
20,000 has been set aside.
Yes.
The rest has been kept.
Kindly come to page, inner page.
Then comply with the rest. Don't pay 10,000.
Well, kindly page
We
4.
will comply, my lord. Yesterday we got this order, my lord. We
Page
will
4, kindly
comply.
page 4.
And my lord,
I'll
we
give them
have
a fortnight.
my
No,
lord,
Mr.
we have
Datta,
been- Yes.
I'll give them a fortnight only because next Friday is a holiday.
Yes.
Otherwise, I would have kept it next Friday. I'll keep it the Friday after that. And they say they are complying. They have got this order. Let us come back. Learned counsel for the alleged contemptor submits and an appeal was preferred. Why two?
Well, earlier order 15 to
Two appeals were preferred.
Yes.
That two appeals were preferred against in connection with the order under contempt. Learned counsel for the petitioner submits that the appellate court has set aside the cost component of the directions of this court, but has upheld the other portion of the said order, which has not yet been complied with by the alleged contemptor.
A certain modification has also been made.
Learned counsel for the alleged contemptor submits that certain modifications have been made. Since the copy of the order was obtained very recently by the alleged contemptor, the modified order could not be complied with as yet. However, the alleged contemptor seeks some time to comply with the order of this court as modified by the appellate bench. Next para, in order to grant such opportunity to the alleged contemptor, the matter is adjourned till April 5, 2024, when it will be listed under the same heading. The copies of the order of the appellate court filed today be kept on record. Mr. Datta, let us come back after 2 weeks, then we'll see. Thank you.
Item 10.
I appear for the alleged contempt, my lord.
Slips to the other person. Yes.
I am for the petitioner, my lord, led by Mr. Mojumdar, my lord.
Lord, I appear for the alleged contempt, my lord. Lord, no explanation, my lord, no defense. Lord, we have, my lord, preferred an appeal, my lord. Lord, it's delayed, my lord. There
What is the nature of the order?
My lord, your lordship had directed, my lord, amounts to be paid, my lord, and in default interest, my lord, is my lord.
What is the stage of the appeal?
My lord, the appeal, my lord, we mentioned it, my lord. It may appear, my lord, in either, my lord, we mentioned it on
Not
Monday.
even
my lord,
appearing in the list.
No, my lord.
There is a Section
appeal.
5 application, my lord. Appeal preferred only 3 petitioners against the 3 petitioners, my lord.
No, my lord, that has been corrected, my lord. I have taken submission, my lord. There was a mistake in the cost title, that has been corrected.
Section 5 is pending. What is the delay? I'll condone the delay from here and ask. What is the delay?
Lord,
About
100 days, my lord, 100 days.
Section 5 is pending, sir. Right, really have no defense. I mean,
But that's why, my
waited
lord,
for.
my lord, in fact, I have no defense, my lord, but Lord, let me try my luck.
I'll keep it after a fortnight, sir. At least for the section. You move your section 5 at least. Section 5 will be taken up early.
Yes.
And along with that, if you move
Lord,
any
my lord,
step.
effective fortnight, my lord, next week is a holiday. I will not have it, my lord, next week. my
Oh,
lord.
what holiday? 2 days are there.
My lord, 2 days, my lord, his lordship, my lord, doesn't. But
I'll
lordship
keep it
can-
on 12th. 3 weeks after.
Great.
Learned counsel for the alleged contender submits that an appeal has been preferred along with an application for condonation of delay against the order under contempt. Learned counsel for the petitioner points out that there were certain defects in the said filing, which is controverted by learned counsel for the alleged contender by submitting that the defects have been taken care of in the meantime. Learned counsel for the petitioner also submits that there is a delay in filing of the appeal. Next para, be that as it may, comma, in order to give adequate opportunity to the alleged contemners to ventilate their grievance before the appellate court, and at least to move the application for condonation of delay and or any interim order, if any, comma, the matter is adjourned till April 12, 2024, when it will be listed under the same heading.
Grateful.
12th.
Grateful.
Thank you.
11.
Lord, 11, I appear for the petition.
Yes.
My lord, may I submit the rejoinder?
Lord, I am filing my supplementary affidavit as was directed by your lordship.
This is rejoined to supplementary affidavit, Mr. Ghosh.
My lord, my lord.
Lord, they have.
Lord, there is no allegation against us, my lord, therefore we have not duty.
Lord, what happened, my lord?
My lord, I must appreciate, my lord, the continuous courage of the petitioner to mislead the court, my lord,
Why?
and to get his civil issues resolved by way of this contempt
Mr. Ghosh,
application.
let him mislead first, then he will.
Yes. Lord, what happened, my lord?
Yes, Mr. They first mislead.
The
Take the
contempt,
mic closer to you.
contempt application
Take
was,
the mic closer to you, you are going away.
Oh.
Yes.
my lord, contempt application was filed because at the time of making construction of the meter board shed, the private respondent objected. One of the petitioners was mercilessly beaten. He was hospitalized, and that is why the contempt application was filed. Now, my lord, we came to the contempt application, moved with your lordship. Lordship passed 3 orders. I have annexed these 3 orders. And your lordship's direction, my lord, the private respondent was made as one of the alleged contemptors. Number 3. Now, my lord, what happened, my lord? Lordship directed us subsequently to deposit the cost. The cost of police help. That was on 1st of March. 24 hours time was given. On 1st March, I went at the office of the officer in charge at Pujali police station. He said, I cannot do anything. You meet superintendent of police, Diamond Harbour Police District. On the very next day, the petition number 1, he went at the police district with a forwarding letter of the learned advocate and your lordship's order. That was received. That was on 2nd. And they informed me, Lord, you come on the 4th because 3rd was Sunday. On 4th, I went and I prayed for give me the challan to deposit the police assistance cost. On 4th, they said the challan is not ready, you come on 5th. On 5th, I went, they gave me the challan and I deposited. And on the very next date, on 6th, I deposited the police assistance cost. And they have taken the stand that there is a delay of 6 days. This is the reason. Secondly, my lord, after then, they have taken 2 days police assistance cost. 7th and 8th. On 6th, my lord, after making the payment, I again went at the office of the officer in charge, Pujali police station, and say, give me police assistance, because 7th was the date fixed for doing the work. Police said, my lord, that is in my affidavit, that I will not give any police assistance because there is no such order to give police assistance for the purpose of construction of the meter room. Then I came back. On 7th, my lord, I, through my learned advocate, sent a mail to the officer in charge that you please help to give police assistance at the time of construction of the meter room. On 7th, they said nothing. On 7th, my lord, what happened? On 7th, we with our laborers and the mason to construct, we attempted to construct the meter room. The police resisted us by saying that there is no court's order to give police assistance at the time of taking the meter construction. Only, my lord, that is their affidavit. Only for the purpose of assistance to the CSC person. Not unless.
What was my order originally?
Yes, Lordship, original order.
Your lordship kindly comes to page 7 of my
Sir,
rejoinder.
let him complete.
Lord, your lordship's order, your lordship comes, page 29,
Yes.
and below the,
Page 29 of the contempt application.
yes. And the operative part, below, page 31.
Yes.
Hence, in the middle of the paragraph, hence WPA number 4601 of 2022 is disposed of by directing the CSC Limited to install a fresh service connection for the petitioners in the name of the petition number 1 as prayed, subject to compliance of all the formalities by the petition, including the identification of a location for the purpose of installing such service connection. It is the positive case, and the CSC person.
Let us read it.
Lord, in the event respondent create any obstruction to installing such service, it would be open to the petitioners and the CSC personnel to approach the local police authority, that is the respondent number 4, the officer in charge of the Pujali police station, to adequate police assistance in that regard. And if so,
They are saying that there was no specific direction to
yes,
build a meter room.
police assistant at the time of construction.
CSC has given you, has written to you that you need to construct a meter room. They have written to you.
Yes, yes.
And they stand by that.
And their cases, my lord, without construction of the separate meter room,
Connection cannot be given.
cannot be. And they have repeatedly saying so. But
now the last position is that police refused to give help on the ground, according to you,
yes,
on the ground that there is no specific direction to construct meter room and give police help.
Grateful.
You tried, but the police resisted.
Yes, of course.
Resisted.
But we will not allow you to construct.
Let me hear the police.
Yes,
yes, Mr.
And that is on the they have
I understand.
admitted.
Let me hear.
Lordship kindly comes to page 7 of my rejoinder, my lord. The parent order. Third page, my lord. Third para. Page 7 of my rejoinder, my lord.
Yes.
In the event, my lord, hence WP number so and so is disposed of.
This is the order which was placed just now.
No, my lord. This is the parent order.
Yes.
Passed on November 10th. This is not the order under contempt.
Oh.
My lord.
And this is the grandparent order.
My lord. By direct.
No, this was placed just now, 10th November 20.
My lord.
That this order was placed just now.
Any obstruction to installing such service.
You are reading the same order from a different document.
And my lord,
What is your stand on this? You say that there is no specific direction to.
My lord. My lord, we have neither encouraged nor obstructed them while they went to construct the.
Police is absolutely neutral, Mr. Ghosh, we know.
My lord,
When they need to be positive or negative, they become neutral.
if
And vice versa.
If your lordship so directs me, lord, that to accompany the CSC person.
Mr. Ghosh, it is very clear. They cannot create any obstruction in installing the service connection. CSC says for installing, you need to build a meter room. They're building that.
My lord, we have.
Why did the police resist them?
We haven't resisted, my lord. Absolutely a false allegation, my lord.
No, sir.
You say you have not resisted.
No. We have neither encouraged. My lord, they insisted us to be there while they will construct the meter room. We have said them that this the place where the meter room is being constructed is a subject matter of a title suit. So,
Mr. Ghosh, they will construct the meter room tomorrow. I'll give them liberty.
Yes.
And you will provide police help with the cost which has been given.
The cost given, we have taken cost only for 1 day. It is
Not
also
2
there in
days.
my rejoinder. Your lordship kindly comes to page 12.
No.
Page 12 of my rejoinder, my lord.
No.
And on 7, we have duly accompanied the CSC personnel. But the work could not be done because the
22,210 for
my
1
lord,
day.
my lord, this is the challan. And my lord, page 13 is the receipt. On 6th.
Where do I find this is for 1 day?
Yes.
My lord, because my lord, your lordship kindly comes to page 11, my lord.
Yes.
Or 2. My lord, here is the estimate. I would like to inform you that 2
Sub-inspectors, 6 constables, 2 lady constables will be required for taking over possession. It is requested to deposit rupees so and so. Each alarm head and send a copy of the same for taking further necessary action from this end.
You
What-
went there for nothing. You did nothing.
We were directed to
Why should
accompany,
they pay police help cost again?
we were directed to accompany the CSC personnel, which we did.
Not to accompany. You are not their friends. You have to accompany to see that the order is complied with.
CSC personnel went there and
Let them accompany whoever their own friends, but to accompany this CC personnel, they have to implement the order. That is the purpose of accompanying.
Your Lordship, so
They have
direct-
taken cost, they have not done it.
Milord,
The
two
police.
things.
Milord, there was no scope for us, Milord, to assist them while they will construct the meter room.
I'll make that very clear.
Milord,
Yes.
Milord, one thing, page 20, Milord, page 20. that
Of
is
what?
that is the challan of my supplementary affidavit. They are saying one day, that is.
Yes, they are saying one day. What
But
is
I'm
that?
saying I'm saying 2 days. Milord, Lordship, can you say page
Show me,
20?
show me, show me.
Page 20, left hand bottom, ekdam. Period from 7/3/24 to and 8/4.
Yes,
24. Then
within a day.
is it a Milord over 1 day or 2 days?
This challan was.
No, from to miss
Yes.
there, it's like a hotel. 7th to 8th is the booking, police booking. You have booked the police for that.
22,000.
So they'll,
Milord,
that 24 hours they'll roam around and accompany the police. That's it. You may not say anything. You're the alleged contemptor.
No,
You're lucky that you're behind, not behind bars.
I am not the contemptor also, my lord. My lord,
You are the
Who is
person
the
who is
contemptor?
resisting.
I have not raised any objection.
I'll record that. I'll record that.
My lord, lordship has
And I'll
stated-
permit the police to thrash you up if you resist this time.
My lord,
Yes,
if they
my lord.
want to make construction in their own.
Yes, their own, forget that. Learned counsel for the petitioner
Madam,
contents by placing reliance
Lordship,
on
kindly hear me.
Mr. Mitro. No further hearing to you.
Only one.
You are absolutely recalcitrant, your client. No further hearing to you.
My lord, we have filed an application under order 26 rule 9, my lord.
Very
But that is pending, my lord.
Let that be pending.
My lord,
Learned counsel for the petitioner
my lord,
places.
to construct in my plot, my lord.
Boshoto? Yes. I'll impose exemplary costs on your client now. Yes, Mr. Mitro.
No, no.
Complete your submission. Complete your submission. Complete your submission. Cost not for argument. Putting it up as a prop. You are violating the court's order, Mr. Mitro, day after day after day.
Sorry, my lord, if I have.
And your client will be present personally in court on the next occasion.
My lord, I'm-
Absolutely, yes. Order 26 rule 9. Don't teach the court order 26 rule 9. A specific direction is given every time you violate. The police don't give assistance. What will this poor person do? We are here for these persons, not for people like you.
my lord, I will not make any.
Order 26 rule 9. What else have you done? Let me hear you. Order 26 rule 9, apart from filing that, what other law have you resorted to? Tell me. Tell me, make your full submission, Mr. Mitro. Since your client will be here in any event on the next day, explain his conduct. Yes, what has he done?
My instruction is only that, my lord. My client has no objection if they get a meeting.
That I can understand. You no objection.
But, my lord,
Ridiculous.
But with the help
No
of the
objection.
police, my lord, they may try to make a construction on my plot, my lord.
Come.
That is the only, my lord. Otherwise,
Learned counsel for the
nothing to say.
petitioner by placing reliance on the supplementary affidavit filed in court submits that when the petitioner went to the police station to deposit the police help costs, the petitioners were relegated to the superintendent of police, which they did on the next day, full stop. However, after being delayed for 2 days, a challan was given to the petitioner for deposit of police help costs. Accordingly, the petitioner deposited police help costs
On 6th, Milord, on 6th.
to the tune of rupees 22,210 on March 6, 2024. Full stop. It is contended by the petitioner that the police help cost was for 2 days assistance. Full stop. Next para. Such contention is controverted. Now, it is further submitted by the petitioner that ultimately, when the petitioner sought to construct the meter room for getting the connection as per order of this court, no assistance was given by the police on the pretext that there was no specific direction to give police help to construct a meter room. Full stop. Next para. Learned counsel appearing for the state by placing reliance on the rejoinder to the supplementary affidavit filed today by the state, contends that the police help cost was paid only for 1 day, full stop. Learned counsel places reliance on the challan in question which indicates that the period for such police help was from March 7, 2024 to March 8, 2024. Full stop. Next para, it is submitted that the police duly accompanied the CAC personnel in compliance with the order of this court, but since there was no specific direction to grant assistance to make a construction of a meter room, the police could not grant any assistance on such in such regard. Full stop. However, learned counsel categorically denies that the police resisted the petitioner from making such construction. Full stop. Next para, learned counsel for the mission B3 for which alleged container number
3 minutes.
Learned counsel for the alleged container number 3 submits that the petitioner is trying to make a construction on the petitioner's property of the alleged container number 3, and the alleged container number 3 has already filed an application under Order 26, Rule 9 of the Code of Civil Procedure in a pending civil suit. Full stop. Unless the issue is decided, it is submitted that the said the said construction would be violative of the rights of alleged container number 3. Full stop. Next para. It transpires from the previous orders of this court in the contempt application and in the order under contempt that the circus is going on for quite some time and need not be prolonged further. Full stop. Next para. The petitioner was being made to move from pillar to post for depositing the police help costs. Full stop. Huge costs of rupees 22,210 were taken by the police. Although learned counsel for the police is justified in submitting that the said cost was apparently for 24 hours only. Full stop. Next para. Although the 24 hours encompasses 2 days, that is March 7, 2024 and March 8, 2024, the police help, which was apparently granted upon taking such costs, was absolutely toothless as can be. Full stop. Next para. The police were mere spectators on the ground that there was no specific direction to make any construction of a meter room. Full stop. Next para. The alleged container number 3 has a common refrain every time the matter is taken up, being that the petitioner is trying to make a construction on the property of the alleged container number 3. Full stop. Next para. I do not find from record any injunction order by any civil court restraining the petitioner from making such construction, or any decree of a civil court adjudicating that the property where the construction of the meter room is to be made is owned by the alleged container number 3. Full stop. Next para. That apart, irrespective of such considerations of title, the order dated November 10, 2022, which has been flouted in the present case, clearly reiterated that the electricity connection being given to the petitioners shall not create any special right or equity in favor of the petitioners in any manner, and shall be without prejudice to the rights and contentions of the private parties before the competent civil court or any other forum, if moved. Full stop. Next para. It was clearly recorded in the said order while disposing of the writ petition that the connection shall be given by the CAC Limited to the petitioner number 1, subject to compliance of all formalities by the petitioners. Full stop. Next para. In the present case, such formalities, as per the CAC itself, includes the construction of a meter room to enable the CAC Limited to give such connection to the petitioner. Full stop. It is common knowledge that unless there is a meter room, no new service connection can be given to a person. Full stop. Next para. Thus, it was well within the purview of the order under contempt that the petitioner was to be permitted to comply with all formalities. Full stop. The direction on the CAC Limited to give such connection to the petitioner implies that such connection shall be given upon completion of formalities, which according to the CAC itself includes the construction of a meter room. Full stop. Hence, there is no reason for any misapprehension on the part of the police authorities regarding the construction of the meter room being a part of the act of giving the service connection to the petitioner. Full stop. Be that as it may, since the police is not supposed to interpret the law comma, nor are they equipped to interpret the law, comma, the benefit of doubt is given to the police authorities for failing to understand the purport of the order. Push up next para. Insofar as the alleged container number 3 is concerned, comma, the most caustic remark against the said alleged container would be little justification to condemn the act of the said contemner. Push up. The alleged contemner number 3, comma, it is noticed, comma, from the inception of the matter, comma, has been resisting the petitioner from getting service connection on the frivolous plea that the construction of the meter room is being made on the property of the alleged contemner number 3. Full stop. In view of the specific rider in the order under contempt, that the electricity connection, if given, shall not create any special right or equity in favor of the petitioners, and will be without prejudice to the rights and contentions of the private parties before the competent civil court, comma, there could not be any iota of doubt regarding the construction of a meter room merely to enable the petitioners to get electricity connection could not tantamount to creating any right in favor of the petitioners. Post up. In any event, comma, whatever rights are sought to be created by the petitioners will be adjudicated in the civil suit, which was kept open in the order of this court, comma, leaving no manner of doubt in the mind of the alleged contemner number 3 or anyone else that the petitioner is required to make such construction to get the electricity connection in compliance of this court's order. Push up. Hence, comma, for clarification of any doubt, comma, although there is no need as such for the same, comma, it is made clear further that the giving of electricity connection to the petitioner by the CSC Limited includes the component of the petitioner constructing a meter room for getting such connection. Full stop. Hence, comma, the police help costs paid by the petitioner is not for the police to be mere spectators, but to assist the CSC Limited to give the connection, as well as the associated act of the petitioner in constructing the meter room for getting such connection. Push up. Thus, comma, in the event there is any further doubt in the mind of the police authorities, comma, it is made clear that it was included within the fold of the order dated November 10, 2022, passed in WPA 4601 of 2022, that the petitioner shall construct a meter room, comma, to which no special right will be created in favor of the petitioner, but which will be subject to the adjudication of the civil suit pending between the parties, comma, and upon making such construction, the electricity connection shall be given to the petitioner. Push up. Next para. Hence, comma, the police shall render assistance at the costs which have already been taken and utilized by the police authorities, comma, for enabling the petitioner to make the construction of the meter room. Push up. Next para. However, comma, if the construction and the giving of electricity connection are not possible in a single day, comma, the police will be entitled to take further costs for the second day, comma, if it spills over to that. Push up. Next para. However, comma, the police authorities who will be present on the date when the meter room is constructed shall make it clear to the petitioner, and within 24 hours shall issue a challan indicating the further cost which is to be borne by the petitioner in such case. Such question will, comma, however, comma, not arise if the entire act of making the construction and giving the connection takes place in the same day. Next para. The construction shall be made by the petitioner on, give a particular date, I'll give that.
Tomorrow? Day after. On a Monday.
It will be difficult for the CSC personnel to be there.
Actually, what will happen, my lord, for construction of the meter room, 1 day is required. And for giving injection, service connection on the,
then I've made that clear.
on the same date is not possible.
Not possible, then we'll pay for the
Another
cost.
date
I've
is
made
required.
that clear. Yes.
Another date is required.
No. Do it consecutive dates. At least 1 day after each other.
Yes. 1 day after. And the construction is to be waiting.
Very well. You make the construction. I'll give you today we are 20. Take time. Take time.
Yes.
Remain construction will
Now outside laying cables you can do.
we'll have to know where the meter shed is, Lord. And one more thing, Lord, instead of meter room, Lord, meter board shed. That is what.
যেখানে এখানে রুম বলেছি না বোর্ড শেড হবে
Board
মিটার
shed,
বোর্ড
yes.
শেড বেরোল তাহলে then you'll make the construction when should you make the construction not tomorrow tomorrow the police
But
also,
when next Wednesday, next Wednesday,
27th
next Wednesday.
the construction shall of the meter board shed shall be made by the petitioner at on March 27 2024 comma commencing such work on and from 10 a.m. on the said date
Yes.
when police help will be assisted granted by the will be granted as per the above direction full stop upon such construction being made comma the CSC personnel shall assess the time which will be taken for giving the service connection and intimate the same to the police authorities for the police to give such assistance appropriately. Full stop. It is expected that after the construction of the meter board shed is made, comma, the connection shall be given to the petitioner within an outer limit of 1 week thereafter.
Lord, he shall
Ma-
inform
Lord.
us, Lord, about the construction.
Yes,
of
yes,
the
I
meter
will,
shed, Lord, he will inform
the
us.
petitioner will inform them about the
construction
construction of the meter room.
Needless to say, immediately upon making the construction of the meter board shed, comma, the petitioner shall intimate the CSC Limited in writing of the same.
But I have one more prayer. Rashid, kindly keep this matter pending. Because the private
Yes,
responsibility-
obviously.
private responsibility is a political club, Lord. So they
Maybe political may not be, I am not
no, no, so
interested.
Lord, they have creating make it
The
legal
matter
object.
shall next be listed on April 12, 2024
Yes,
for filing of a comprehensive report by the CSC authorities.
yes.
You file a report because you are the only neutral one.
Grateful, chef.
Grateful, my lord.
Next.
My lord, I tender my unqualified apology. My lord, if I have
Hey,
covered-
nothing about you, Mr. Mitra. I make you have
My lord, I
seen
have
me for
great
so long.
respect for your
Mr.
lordship, my
Mitra,
lord.
you are a window for me to see your client. You are nothing intended against you. I don't
I am
intend
very sorry,
none
my
of
lord,
these
if I have annoyed
sentences.
your lordship anyways, my lord.
You have not annoyed me at all. Your client's conduct has, Mr. Mitra. Still, I stand by that. You are not responsible for that in any manner whatsoever. My comments were not for you at all. You means your client, obviously. What have you done? You poor advocate, you have come up and argued the case for
My
your
lord,
client.
whatever I have been
But
instructed,
you have
my
to
lord.
suffer the wrath because you are representing your client. But it is meant for your client. Next matter.
Grateful, my lord.
12. Yes.
My lord, I am for the petitioner, my lord.
I am for the contempt
The last
contender number
occasion, my lord,
2.
lordship directed me.
Container number 1.
I am for number 3 and 4.
You are so
Lordship,
proud about it.
on the last occasion, your lordship directed me, my lord, to serve a copy on the chief electrical inspector once again. My lord, I have done that.
Inspector for direction আছে কি আপনারা তো কি বলার আছে হ্যাঁ
Yeah, what has he done?
my lord in contempt number 2 my lord the thing is I had filed an appeal. Unfortunately, that appeal was defective and thus it couldn't be heard all this time, my lord. I understand your lordship, lord, it's not an excuse, but lordship kindly grants me a couple 2 weeks time. If the appeal is not heard out by then, I will direct my client to comply with the order, even if under
My lord, no copy has been served. No, no, CI part টা stay হয়নি, demolition টা stay হয়েছে।
Fair enough.
Demolition has been stayed.
my lord, challenging my lord's last order, my lord, dated 23rd of February. My lord, my clients, my lord, have filed
Your
an
client is not his client.
no, I respond number 3 and 4.
You have also preferred an appeal.
Yes, my lord.
Which is also
No,
defective.
challenging my lord's last order passed in this contempt proceeding, my lord.
You have challenged that
Yes,
also.
alleged
That
contempt number
challenge is
3 and
immaterial. I will not wait for that. But
no,
the
my
parent
lord,
order
the
challenge
division
definitely.
bench was pleased to stay my lord's last order, my lord.
Oh, side
Yes.
Only one thing, my lord, on
Yes.
5th, we have gone for.
What was my last order?
February 23, my lord, was,
What did I do in that order?
when the corporation was directed to, my lord, make demolition, my lord.
That demolition, we have went on 5th and again on, police did not help us. On 7th, we again went, but the demolition has been stayed. Because they are.
Very well. You are not on contempt for this, my last order. It is submitted by learned
My lord,
counsel.
only one more thing, my lord. My lord, demolition had been stayed, my lord. Usage of lift is continuing, my lord. Kindly, my lord, take some action, my lord, regarding that.
I will take no action unless that appeal is some order is
My lord,
brought. by
my lord, appeal is regarding the cost of 50,000. That is another issue.
Regarding to
My lord, appeal is regarding the cost, my lord. The with my lord.
There is no ground in the appeal regarding the main order.
thing going on, your lordship
How?
has been misled into passing this order.
How?
The basis of the lordship's order was that the chief electrical inspector had had jurisdiction over home lives. It is not the case.
My lord, kindly see the conduct of the chief electrical inspector. My lord, repeatedly not appeared.
Learned counsel for the alleged container numbers numbers 3 and 4 hands over a copy of a stay order passed hands over an order passed by the appellate authority appellate bench, by which the order dated February 23, 2024 inter alia directing the corporation Howrah Municipal Corporation to demolish the elevator in question has been stayed. Full stop. The said copy is kept on record. Full stop. However, the fact remains that the parent order under contempt is has not been stayed by any bench. Full stop. At this juncture, learned counsel for the alleged container number 2 submits that the said alleged contemner has also preferred an appeal against the parent order under contempt. Full stop. The said appeal is defective, but learned counsel for the appellant therein, in his usual fairness, submits that unless the said appellant, that is alleged container number 2, can bring an order from the appellate court upon curing the defect on the next day, the alleged container number 2 shall be advised by counsel to comply with the order of this court. Full stop. Next para, in view of such fair submission on the part of the alleged container number 2, the contempt application is adjourned till April 5, 2024. Will be very well. April 12, 2024. Full stop. Next para, insofar as the order dated February 23, 2024 passed in connection with the contempt application is concerned, since the same has been stayed and no application for contempt of that order has been passed, the stay order is merely kept on record. Come back on 12th.
We have fixed 2 dates because already stay order was there.
No, even if that order is finally set aside, no difficulty. Parent order remains. But we'll wait for their appeal. Container number.
I think we cannot go immediately for demolition. Only 7 days wait time to do.
Should not. Yes, obviously.
This time.
My lord,
You just mentioned that when ultimately.
My predicament is that demolition has been stayed. Usage is
My
still.
predicament is that an appeal has been preferred against my order. So I cannot implement. That is absolutely against judicial propriety. Let the appeal be. Let them test their luck in their appeal. If they win the appeal, yes.
13.
Yes.
My lord, I beg to appear on behalf of the alleged contempt.
My lord, I
Yes,
appear
Mr.
for the
Farban, yes.
petitioner.
Yes.
My lord, this is my affidavit of service. My lord, they have given an hearing and.
This is my report, my lord. My lord, we have complied, my lord. There is a there is a delay, my lord, as because the previous SDO he got transferred, my lord, as the new incumbent, my lord.
The direction was to give a hearing and decide.
My lord, I have given a flag, my lord, upon on my instruction, my lord. That is the order, my lord. If your lordship will please come to para 4, my lord. My lord. After consulting the office record, my lord, the last portion.
You have decided in your own way. Whatever you have decided, I am not going into the merits of the decision.
My lord, only one prayer, my lord, the only direction upon the my lord, SDO to maintain the houses. My lord, this is the.
How can I get past that?
The contempt application by the government,
maintain houses.
We are occupying the portion of the Patta. The count of Patta is pending. My lord, he has directed.
My lord,
let them maintain their own houses.
Notify, my lord.
Let them maintain their own houses. I'll not direct them to maintain your house. In contempt. Learned counsel for the alleged contemptor hands over files a report indicating that the order of this court has been complied with by giving a hearing to the petitioner and deciding the issue as directed by this court. Full stop. It is further argued that submitted. It is further submitted that the delay occasioned in doing so was due to the previous subdivisional officer having been transferred in the meantime. Full stop. Next para, accepting the reason for such delay and in view of the order of this court having ultimately been complied with, CPAN 1483 of 2023 is disposed of in the light of the above observations by keeping on record the report filed today.
Deeply obliged.
Next.
14.
Yes, Mr. Sinhala.
My lord, I have received some bills, but not fully paid as yet, my lord. This is Shonamukhi Hospital bills from.
Mr. Sinhala, what was the direction of this court to pay the bills?
To pay the bills.
To pay all the bills? Was it
Yes.
unqualified?
Admitted bills, my lord.
Oh, then there's a
My lord, actually, my lord, last
whatever they
occasion,
say they admit
they-
they'll pay.
yes, my lord, last occasion, there is a direction, my lord, that the certain signatures are required to be made by me, my lord, and
You have done that.
your lordship directed to comply with, and payment to be made by 27.
What was done? They made payments by
They
27.
made part payment and rest still.
Mr. Sinara, if you have any dispute regarding the quantum, then you have to prefer a.
I don't, this is not in relating, my lord, today the contempt advocate
You
is
are
also-
there. You are fair enough to say everything. So why should I
My lord,
wait for
my
that?
instruction is that one
They
house,
have paid some amount,
some
but
amount
not
still-
all.
Not all.
That the rest is disputed, obviously.
No, not disputed, my
How
lord.
do you say that?
My lord,
Where
one
have they admitted?
hospital-
Show me the admission.
One hospital bills paid, my lord,
Oh, the other hospital has not been paid.
has not been paid.
Give a notice, come back on 5th. I'll record your submission. Then counsel for the petitioner submits that pursuant to previous direction of this court, comma, the petitioner has put his signatures on the concerned bills. However, comma, the dues of the petitioner has been paid in respect of one of the concerned hospitals, whereas the dues regarding the other have not yet been cleared. Next para, since none appears for the alleged contemners at the time of call, comma, it is to be ascertained as to what is the stand of the alleged contemners regarding non-payment of the bills in respect of the other hospital. The learned advocate on record for the petitioner shall give a notice to his counterpart appearing for the alleged contemners indicating that the matter shall be listed under the same heading on April 5, 2024. Let the matter stand adjourned till the said date for passing further orders. Grateful. ঠিক আছে, শুভেন্দু? Next.
15.
Yes, Mr. Banerjee.
Coming back after service of copy, they filed an appeal. They've currently lost the appeal.
Why did you lose the appeal? How dare you?
But we'll file our affidavit of compliance on Wednesday. We'll file that. Kindly gives us 3 weeks. Next week is a holiday.
Wednesday means 1
This,
week.
no, this Wednesday, the matter was taken up and it was dismissed. Appeal was dismissed.
No, whatever.
I
So you say you'll take 1 week.
3 weeks. I prayed.
Wednesday you said?
No. This Wednesday matter was taken up.
The 3 weeks takes us to when? Today we are on 22nd, 12th. I'll keep it on 12th.
We'll file our affidavit of compliance.
Learned counsel for the parties submit that the appeal preferred against the parent order by the alleged contemner has been dismissed or dismissed. Full stop. Learned counsel for the alleged contemner in his unusual fairness submits that the alleged contemner shall accordingly comply with the order of this court. Full stop. 3 weeks time is sought for such purpose. Full stop. Granting such prayer, comma, let the matter stand adjourned till April 12, 2024, when it will be listed under the same heading. Full stop. The alleged contemner shall file a compliance report on the next returnable date with an advance copy to the learned advocate for the petitioner. Thank you.
Deeply obliged.
Thank you.
$16.
Yes.
I applied for the alleged contempt.
Yes.
Your worship kindly.
Madam Writer.
Dated 1st of March. 1st of March, my lord. Where is my lord?
1st of March?
March
Order.
order.
Yes.
Lord, especially, my lord, paragraph 3. Paragraph 3 of the order.
The matter where your lordship directed to disburse.
Mr. Bhattacharya, please take the microphone. Yes, Mr. Bhattacharya, yes.
The lordship kindly peruse this matter. This is a matter your lordship directed the MH matter to disburse the amount matter subject to rectification of name of the petitioner.
Yes.
My lord, they have written to the and your lordship directed the state government authority to clarify and rectify. To that, my lord.
So the Joint Secretary State of West Bengal is to reply to it.
Yes. They have not yet. They have given.
This is your communication.
This is not my. This is their communication to me. Copy to. Your lordship in the bottom will find copy to Vikram.
Copy of has been given to.
Your lordship kindly peruse this. Your lordship directs.
This is after my order. Yes.
Yes.
No, we have, sir, my lord, I am filing.
Yes. Let me just check up.
Daily Joseph. ওরা রেক্টিফিকেশন করতে বলেছে, চেয়েছে, এখন ওরা যায়নি।
No.
That has been, copy has been.
Lordship, I am appearing for the
No, no.
state, Lordship.
Yes, what is
In
your
this matter, we have received the order on 4th. Immediately, we complied with the order. We directed the superintendent of police to take details of the name. He has done his work and the name has been correctly spelled, Lordship.
what has to be done now? You have to forward this to them.
We have received it, Lordship. Kindly see, we have received it on 21st, Lordship.
21st. You received it on 21st of April.
Yes, Lordship. Just
How could you?
21st of March, Lordship.
The
21st
date
of
is
March.
21st of April. Oh, it's 21st of March. Yes, but
That could be
beneath it is written 21st of April.
No, Lordship, in the.
You're ahead of time, no difficulty. State is always ahead of time. But we think today, India thinks tomorrow. So therefore, it has to be.
This has to
But
be-
anyway, the email is dated 21st of March. Today we are on 22nd. Yesterday you received. So what has to be done by within a week.
That this is to be communicated, madam, to the Ministry of Home Affairs by them, madam, so that.
Yes,
the
we will,
pencil papers can-
we'll do it
Do it
today.
today. Today, yes, yes, absolutely, absolutely. They'll do it today, Mr. Bhattacharya. How soon can we expect you to implement?
Yeah, that is already there.
Very well. Learned counsel for the. You are for which alleged contempt, Mr. Bhattacharya?
Undersecretary, one point-
Acha, very well, I'll check up. Learned counsel for the government of India submits that the requisite communication was made to the joint secretary within bracket freedom fighters pension cell bracket closed state of West Bengal full stop next para however comma the said authority has not yet taken any steps thereon to the knowledge of the Union of India. Full stop next para. Learned counsel for the state hands over a communication indicating that due steps were directed to be taken by the concerned authorities and the rectification of name of the petitioner has been carried out in the meantime. Full stop. However, comma, the communication of such rectification was received by the state, received by the Joint Secretary Freedom Fighters Pension Cell only yesterday. Full stop. It is submitted that the due steps shall be taken for communication of the same to the Ministry of Home Affairs within 24 hours. Full stop. Accordingly, comma, the Joint Secretary Freedom Fighters Pension Cell is directed to comply with the is directed to make the communication to the MHA within 24 hours from now. Full stop. The MHA shall thereafter take steps in terms of this court's order at the earliest. Full stop. The matter be placed in the list on April 12, 2024 for final orders. Thank you.
And let this
Character line,
communication
the communications filed today be kept on record. Thank you.
আবিরটার একটু নামটা নিয়ে নেবেন।
17. This matter, Your Lordship kindly come to my Lord's order dated 8th of March 2024, especially paragraph 9 at page C, internal page of C of my Lord's order. Paragraph 9.
Yes, what happened, Mr. Galib?
My lord, may I file my lord affidavit of compliance today? We have passed, my lord, taken a decision, my lord. His case could not be recommended. My lord, this is a decision, my lord, the authority has taken. May
Please hand over a copy to him also.
Yes, certainly, my lord. Today, my lord.
Mr. Manna, I'll dispose of the contempt application. I'll
This
give you
is para,
liberty to challenge.
para 3 of the, my lord.
I'll give you liberty to challenge this.
Sorry, my lord, para 2 of the affidavit, lord.
Instead of today, would Your Lordship keep it on any other?
Oh, sure.
So that I can.
Sure.
Para 2.
An affidavit of compliance is filed today by alleged contemner. So a copy thereof is handed over here and now to learned counsel for the petitioner. Full stop. It is submitted by the alleged on behalf of the alleged contemner that that a decision has been taken as per direction of this court, and it has been decided that the petitioner's name cannot be recommended for the freedom fighters pension scheme. Full stop. Next para, learned counsel for the petitioner seeks some accommodation to take instructions on the affidavit of compliance. Full stop. Accordingly, let the matter stand over till April 5, 2024.
Lord.
Thank you. Mr. Manna, Mr. Manna, I indicate to you, whatever order they have taken, you will be at liberty to challenge that and drop the contempt application. This is an indication, but go through that. Castigate Mr. Galib if you can.
I will
Yes.
not pay anything which cannot be paid.
Lordship.
So, Lord, if required, I will take.
And I will not grant any order which cannot be granted.
I know that, Lordship. Look, one thing astonished me personally.
Astonished you?
Astonished about my lord's dictation. Lord, upon hearing how fast my lord can dictate the order, such a long order.
You have made my day, Mr. Manna. I am elated actually.
I could not understand how it is possible for.
Thank you. Next matter, but this will not reflect in the next content. Next matter, call. Tumi
18 and 19.
Yes. Yes. You are for the alleged contemner. You look like that. Your attitude is like
Formidable.
formidable. Yes. Oh, Mr. Bose is the culprit. Mr. Mukherjee, what is the matter? This is a contempt application, right? Oh, that bar council.
We have been served with the reply
Yes.
yesterday night.
Opposition,
Yesterday night it was served.
My lord, maybe, my lord.
yes. Opposition you had filed previously in court.
Yes,
Yes,
I did. My lord, only one.
Extended the time, my lord, for
Yes.
the reply till today.
Right.
My lord, we have, my lord, filed that reply.
So don't have a copy of the reply. If it could be taken up any other day. My lord, only one more indulgence, my lord.
Yes.
The affidavit that has been filed by us,
Yes.
my lord, I was unaware of this, my lord, appears to have been affirmed.
My lord, not by the contempt, no respondent.
Constituted attorney. And I'm
My lord, you've
completely
taken
appalled.
that, my lord, as a
Contempt, Mr. Bose, you should have.
I was completely unaware. I just, when I was given the copy of the affidavit, I realized this.
I'll direct the constituted attorney also to be implemented as a party to the contempt application and give you liberty to file.
Kindly give us that liberty, my lord. Just, we will not, well, we've already served upon them. My lord, we will
But
not.
that will
change
drag the matter, Mr. Bose, unnecessarily.
What I was.
But I require an opposition from the.
Absolutely. All we'll do is that we'll keep the entire text the way it is, the way it has been served. The affirmation, my lord, it has to be affirmed by the alleged contempt. Why, it is so elementary, I don't know, my lord.
Do that within a week. I'll give you.
Absolutely.
Otherwise, this will be, I mean.
No, absolutely, within a week.
Mr. Mukherjee, I'll give them time for a week. They'll have to do it by 27th, 28th. They'll have to give you that whatever by email. And the reply probably will be the same verbatim, but just, I mean, I'll give you.
My lord, the only thing is, my lord, my lord, when the contemnor affirms, my lord, there is more responsibility.
Yes, absolutely.
Has to be, my lord, under Rule 29, which is why it's
Correct,
insisted upon.
Yes, yes.
So, my lord, 28 or 29, my lord. So, my lord, I don't know, my lord, whether we'll need to file another affidavit in reply, because, my lord, if he's actually made a false statement somewhere, my lord, we should be able to point that out. My lord,
The constituted attorney?
No, if the constituted attorney knows nothing.
Has no locus in.
Yes.
Absolutely.
The affidavit in reply filed today, there are affidavits in reply. Two affidavits.
Two matters.
Two matters.
There are, my lord, 18 and 19.
Right. The affidavit.
But in item 19, I'm led by Mr. Abhijit Mitra.
Learned senior counsel appearing for the alleged contemner submits that there has been a serious omission on the part of the alleged contemner, inasmuch as the affidavit in opposition filed on the last occasion was affirmed by a constituted attorney and not by the alleged contemner. Next para. Accordingly, learned senior counsel seeks some time to get an affidavit of opposition affirmed by the alleged contemner himself. Himself or herself, I'll just himself. Himself. Next para. Accordingly, the alleged contemner is directed to file his affidavit in opposition afresh by March 28, 2024 and serve a copy thereof on the learned advocate in record for the petitioner prior to affirming the same. Reply, if any, shall be filed on the next returnable date upon giving an advance copy of 2 days to the alleged contemner. Full stop, the matter shall be listed on April 5th, 2024, 5th April. So 28th, they give a copy and affirm it. You get a little more than 7 days for your reply. 5th, any difficulty, Mr. Mukherjee?
My lord,
You have to-
somebody will be there, my lord.
Somebody has come also.
My lord, he's in the next matter.
Well, I'll keep it on 5th, let us see.
One.
No, he's there, my lord, he's there. My
I'm
lord.
assisting him, he's ignoring me. Very sad.
Yes, Mr. Bose, you were saying something?
Yes, my lord, I am told that the contemner is out of station and
No, not this
I
time.
complete. That's what I was saying.
So, Mr. Bose, you convince him. I mean, they'll know the repercussions. They don't know, but they will know the repercussions. If
No, I completely.
Mr. Bose,
Your lordship has said 28th. Could it be 1st April? Just one more day.
No.
28th, your lordship has said.
Very well. Then 1st April, ওটা 28th যেটা বললাম শুভেন্দু, ওটা 1st April 1 হয়ে যাবে। আর যেটা within 1 week thereafter, বাকিটা একই রইলো। The matter shall next be listed on April 12th, 2024.
Great.
So that all of us can be here. Yes. Next.
Grateful, Lordship.
Thank you. Oh, you are appearing also. Mr. Sharkar is also there. Yes.
Lordship, I'm assisting Mr. Mukherjee and Mr. Mitchum.
No, I understand the connotation of that grateful.
20.
Yes.
My lord, presence felt.
Yes. I was in the bar a few days back, Mr. Mohan. Yes. Yes, Ms. Ghosh, what is your contempt?
Lordship, there is no compliance of the last order also. Lordship, there was a specific direction in the order passed on 28th of June 2023 with regard to paying of the balance amount. That is, the rates were decided at the rate of 5.69. Thereafter, the enhanced rate was ₹8, and they were to pay with regard to the only balance amount of 2.31 rupees per day per bed. That has to be paid. And the list of hospitals is also with them. The number of sanctioned beds is also with them. Your Lordship, no payment has been done, and there was a specific direction to submit the bill on 11th March.
You have spent your force, Ms. Ghosh. I'll go to Ms.
Lordship. And they were I was supposed to submit the bills pursuant to the last order
You have
of
done
8th March. I have submitted on 11th of March. All the bills.
Very
No compliance.
Mr. Dotto, yes.
Well, 7th of March, we request them to submit their bill. Where they have submitted their bill, Milord, on 11th of March. On 13th of March, Milord, we have written them a letter saying that please submit the bill in the manner you used to submit it. What is the manner? Manner is that hospital-wise, bed-wise, month-wise, Milord, the bills are to be submitted in the respective hospitals. Now, what they have done is they have given us a consolidated bill in the addressing the additional secretary.
Ms. Ghosh, give the breakup within 24
Lordship,
hours.
Lordship,
Within 24 hours.
Lordship, that is not the issue, Your Lordship. Lordship, what has just been submitted by the alleged contemner, that the direction was of 8th of March, not of 7th of March.
No,
And Lordship,
7th of
there
March
was
was my
specific
letter.
direction was to submit by 11th of March. And Lordship, may kindly
That
take
you have complied with. I understand that.
and
No, Ms. Ghosh, since they're asking for the breakup, give the breakup within 24 hours. They'll pay by 28th.
Yes.
Lordship,
Let them pay it.
we have already given the breakup. Your Lordship, we have already submitted.
Where is the
and
bill?
those are part of the annexures.
Which
Milord,
annexure?
The document that I have given to your Lordship, Milord, the first one, Milord, it is dated, Milord, 13th of March. The first letter.
Lordship,
No,
may
this is
kindly
the letter. Where are the
one-
bills?
Yes. Kindly take, Milord, the third document.
Lordship, page 180, page 182 of the
No, Ms. Ghosh, please first, have you given a copy of this to them?
Milord, that was sent by registered post. I can give a
Even then, you just check up Ms. Ghosh.
Lordship, I have received it, Your Lordship.
No, you have received it.
Lordship,
Then
I have received it.
this is the bill you have submitted.
Lordship,
Is this the bill you have submitted? Is this the document you have submitted?
Lordship is looking.
The annexure to their the document they handed over today.
Given me the annexure.
Page 8.
They have not given me the annexure.
Page 8 is not there in that. Mr. Chakravarti, what are you handing over?
I know. Milord, please have a look to Milord, page number 7. I'll come to page number 8. But this is one of the sample bills which was given, Milord, contemporaneously.
This is what it should be.
It should be.
What has been given now?
Milord, the next page, page number 8.
But these bills were given to you, Mr. Dotto. This is only the balance.
Milord,
Why should they give another bill?
Milord, I have to, Milord, comply with Milord, my records, Milord.
Lordship, may
Dotto, the bill has already been raised previously.
No.
this has been
Milord,
raised.
bills have been raised, say, at the rate of 8 rupees.
Yes.
Now, Milord, pursuant to a tender, Milord, Milord, the rate had got enhanced, say, to 13 rupees. 8 rupees we have paid. Now the balance I have to pay. For the balance, Milord, our requirement is that you raise hospital-wise bills month-wise. That will take them, Milord, 10 minutes.
Do that, Ms. Ghosh.
Lordship may kindly.
Because let us not waste time over these frivolous things.
Lordship
Do that.
already
Do that.
submitted. Lordship may kindly takes their document which has been handed over today.
Yes.
Lordship may kindly takes 13/3/2024.
Which is the page? Page number?
Lordship, the second page.
Yes.
The
second page.
continuation of the document. Lordship, at the very top, they have stated.
Second page of the annexures.
No, Lordship, the
second page of the letter.
Letter, yes. The basis of determination.
Determination. Lordship, the basis of determination is in their corrigendum. 5.69 rupees. And enhancement and assessment, that is 8 rupees. Lordship, thereafter at the functional beds, that is also in their corrigendum of 2019. Lordship, may kindly seize their corrigendum.
No, they want a hospital-wise breakup.
Lordship, that is the hospital names are in this bills in the corrigendum only. A fresh copy ta din. Sorry, rough copy ta chale geche.
This is what you have handed over now.
Lordship,
No, this is their corrigendum.
Lordship kindly takes the annexure A and annexure A.
No, Ms. Ghosh, there should be transparency. Give the bill as they're asking for.
Lordship,
do that. Give the breakup and give the bill.
Yes, give it.
Lordship, we can give it today and they can disburse the payment today itself.
I'm asking for that only. Do it today and they'll disburse not by today, but by 27th. 27th is the next. Let them play holy in the meantime and then be holy on 27th. Learned senior counsel appearing for the alleged contemner submits that the bills raised by the petitioners were deficient in detail. First up, it is submitted that the petitioner has been asked to furnish bills for the balance amount payable in the format as per the contemporaneous bills, copies of which have been annexed to a bunch of documents which is handed over in court today by the alleged contemner. First up, next para, learned counsel for the petitioner submits that in the corrigendum itself, the breakups were evident. First up, be that as it may, the matter need not be stuck up on flimsy grounds. First up, since the petitioner is very well capable of giving the breakup of the current, the bills regarding the balance amount in the format as previously submitted, merely by giving the due breakups regarding hospitals, beds, etc. The petitioner is directed to give their submit their bills afresh in the format as asked for by the alleged contemner by 24 hours. Full stop. If such bills are furnished as per the above direction within 24 hours, the due payment in terms of the same shall be made by the alleged contemner by March 28, 2024. Full stop. The matter shall be listed on April 5, 2024 for passing final orders. The documents handed over in court today, including the corrigendum handed over by the petitioner and the bunch of documents handed over by the alleged contemner, be kept on record.
Lordship, may I make only one submission, Your Lordship? Within 24 hours, Your Lordship, after 5 o'clock, they might not accept.
Very well, I'll make it 48 hours.
Lordship.
48 hours, 48 working hours, I'll say.
Lordship.
Then they cannot pay on 28th.
Lordship,
48 working hours will take you to 27.
Lordship, I may be allowed to submit it by today at least 7 o'clock, because by 5 o'clock when I'll go.
That will create complication. You
Let
submit
them
your bills.
submit it, my lord,
You submit the bills by 27th. Within 24 hours, you can file it today also.
I'll file it today. Lordship, let the order
By
remain.
Lordship,
Let it remain.
by March 27, 2024, within 24 hours, March 27, 2024 হয়ে যাবে। আর payment shall be made by March 28th বলেছি। ওটা না করে ওটা by April 3, 2024. Payment by April 3, 2024. Matter shall be listed next on 5th. Since we are coming back on 5th, let us come back. They'll pay in the meantime.
Lordship.
I'm
Grateful to you, Lordship.
I'll take up the next matter in 5-6 minutes. CL raised the quotation and thereafter took due steps to give such connection upon compliance of formalities by the petitioner. Full stop. However, thereafter the connection could not be given due to resistance put up at the locality. Full stop. Next para. Accordingly, the WBACTCL informed the matter to the police authorities and have ultimately referred the dispute to the concerned district magistrate. Full stop. Next para. It transpires from the order under contempt that the purport of the order was for the WBACTCL to give such connection to the petitioner, and in the event of any impediment, to take recourse to the provisions of the Works of Licensees Rules, 2006. Full stop. The WBACTCL, having faced such impediment, have approached the concerned district magistrate in terms of Rule 3 of the 2006 rules, thereby complying with the order of this court. Full stop. Next para. As the matter is now sub judice before the district magistrate, it cannot be said that the WBACTCL is guilty of contempt of court, having taken the recourse as given in the order under contempt. Full stop. Hence, I do not find any instance of contumacious act on the part of the alleged contemptor. Full stop. Accordingly, CPN 226 of 2024 is disposed of in the light of the above observations. Next.
22.
My lord, I am happy, I think, my lord.
Yes.
So the petitioner, my lord. My lord, this is, my lord has directed, my lord, the respondents to take cashless facility to the petitioner, my lord, for a health insurance, my lord. My lord, after that, my lord, they have repudiated the second claim, my lord. And my lord, after, my lord, the service of this contempt application, they have preferred an appeal, my lord, which is, my lord, is item number 86, my lord, before Honorable Chief Justice's bench today, my lord. My lord, now, my lord, I leave it to my lord, my lord.
But you cannot wait indefinitely for the
My lord, let me submit first. My lord, I do not want to unfold the earlier arguments because I have already stated. My lord, there is an IRDA health regulations.
No, you have preferred an appeal. I can appreciate it will be decided in the appeal.
No, yes, my lord, but
not on the merits of the order.
No, I'm not going. But whatever my learned friend has stated that they have repudiated the second claim, that is not correct.
Why?
We have said that we have even told them to supply blank KYC because they were advised to settle this immediately as your lordship has directed. But they have found that the judgment has become a judgment in rem. It is not a particular for this case, my lord. Now, this will unfold a flood of...
No, you need not give any grounds for preferring the appeal.
Yes.
Obviously, you are right
I'm
to
sorry,
prefer.
my lord. But
rightly, you have preferred an appeal rightly, but how long should we wait for?
My lord, we are trying our level best. Even we are trying to upgrade the matter.
At least any interim order you
My
can
lord,
seek.
next, because
I'll give you
Monday, Wednesday,
I'll give you 3
Friday.
weeks time. I'll keep it
Yes,
on
my lord, please.
12th April.
My lord.
I'll give them 3 weeks time, Mr.
Yes, my lord.
Learned
my lord, only, my lord, only one, my lord, thing, my lord, this person is the main bread earner of the house.
I know, Mr. Dev, but nothing doing. And it is submitted by learned counsel for the alleged contemptor that an appeal has been preferred against the parent order, to enable the alleged contemptor to bring an order from the appellate court, the matter is adjourned till April 12, 2024. However, keeping in view the fact as contended by the petitioner that the petitioner, which petitioner is the sole bread earner? There are 2 petitioners.
My lord, petition number 2, my lord.
That the petition number 2 is the sole bread earner of the family, and the non-compliance of the order of this court is hurting the petitioner financially, it is made clear that in the event the alleged contemptor fails to obtain any order from the appellate court by the next returnable date, the contempt application may be taken up for hearing on April 12, 2024. This will help you to mention the matter there.
Yes, my lord. I'm so grateful.
Thank you, Mr. Yes.
23.
In
Yes.
this matter, my lord, I beg to appear on behalf of the alleged contender, my lord, the
Yes.
order has already been complied with, my lord. On 19th March, through e-bill, my lord, the payment has
So
already.
you deprive the
That is not-
deprive yourselves from further arguments. Yes, what is, you do not agree to that?
No, according to my instruction, my lord, that payment has not been made till date, till time, my lord. So, my lord, you should kindly keep it pending for.
No, what does the complaint report say? You are
only, my lord, e-bill.
E-bill has been
no check or other, my lord, amount, my lord.
e-bill?
E-bill, my lord. I don't know e-bill. Whether, my lord.
Drawn on e-bill number means where is the payment?
My lord, e-bill has been submitted on 19th March.
That is, go to
They have submitted.
My lord, the
Who has submitted to whom?
whom,
E-bill means?
in favor of the beneficiary Osim Kumar in the treasury. It has been
Treasury,
submitted
my
to
lord.
the
Executive engineer.
No,
treasury.
they have to see the color of the money.
Yes, my lord.
Treasury or not will not.
Treasury, my
I'll
lord.
give you 1 week, 2 weeks time
Yes,
because you don't get the next week.
My lord, that has been issued in name of the beneficiary, the petitioner.
How does he get the amount?
My lord, they will, my lord, within 2 weeks, my lord. They have to withdraw.
They have to?
My lord,
They have to get the money, yes.
they will get the money.
You will keep it pending, for 2 weeks, my
No,
lord.
I'll keep it pending definitely. How can I dispose it of? Learned counsel for the alleged contender hands over a copy of a communication along with certain annexures indicating that e-bills have been raised on the treasury in the name of the petitioner.
Number 516. Yes.
However, since the petitioner has not yet seen the color of the money, the matter is adjourned till April 12, 2024 as a last chance to the alleged contemners to comply with the direction of this court to pay the amount in question to the petitioner. It is expected that by the next returnable date, the money shall be transferred / paid to the petitioner. Next para. Further orders will be passed on April 12, 2024 when the matter shall next be listed under the same heading. 2 weeks time, Mr. Mahatma.
Every service keep it kept.
Affidavit of service filed to be kept on record.
24.
I am for the petition.
Yes, please. What is it?
My affidavit service. So my application is all about the order was passed directing the alleged contemptor
yes
to look into the complaints of the petitioner. Now the impugned order.
Who is the alleged contemptor? The competent authority?
Yes, competent.
Anybody appeared for them on the last week?
No. It was admitted on that day. Direction was given to South.
Oh, right. Can you give them a last notice? I want to give them a last chance. Otherwise, I'll issue a rule of contempt. Because before issuing a rule of contempt, I think I should. The affidavit of service filed today be kept on record. Stop. Although served, none appears for the alleged contemptor when the matter is called on for hearing. As a last chance to the alleged contemptor to be represented and place their version before the court, the matter is adjourned till April 5, 2024. It is made clear that in the event the alleged contemptor is not present, represented on the next returnable date when the matter is next called on for hearing, a rule of contempt may be issued by this court. Thank you. If you may communicate this order, I have not directed you, you may communicate this order to ensure that they.
$25.
I appear for
yes.
Lordship's order complied.
But ultimately, with the help of police, we have complied.
Very. Learned counsel for the petitioner submits that the order of this court has been complied with. Learned counsel for the alleged contemptors also submits that the compliance was with the help of police authorities. The affidavit of service filed in court today be kept on record. In view of the above submissions, no further contumacious act remains. Accordingly, CPAN 366 of 2024 is disposed of in the light of the above observations. Thank you. Grateful to you. Thank
26.
I am for the petitioner.
you. Yes, Mr. Chatterjee. Yes.
Now, here,
Yes.
every service to the. On the last occasion,
Yes.
your lordship was pleased to direct me to sub. I have subbed.
Right.
Now, the contempt has been alleged. Your lordship kindly come to your lordship's order. It starts from page 33. Your lordship kindly come to the operative portion of the order at page 42. In view of the above discussion, the explanation fits in the agreement in toto. The said proposition cannot be deviated from. However,
42 you are saying, page 42?
Page 42, paragraph 35.
Oh, yes, I'm sorry. Got it. In view of the above, please continue.
Your lordship kindly come to paragraph 41 straightway.
Absolutely, yes.
Keeping in view of the above observation, WPA 4744 of 2023 is disposed of by directing the concerned collector to reassess the stamp duty at the rate as prevalent in the year 2006, taking the agreement and the amount reassessed now. No, sorry. Taking the agreement
in question
to be classified under item 5D, that is an agreement for sale under Schedule 1A of the Stamp Act as amended of West Bengal. The penalty thereupon shall also be calculated accordingly, taking the stamp duty to be assessed at the rate prevalent in the year 2006. Such exercise shall be completed by the collector within a fortnight from date, and collector shall intimate to the petitioner in writing the re-evaluated stamp duty and penalty thereupon, as well as the deficit stamp duty to be paid by the petitioner. Upon such intimation being given to the petitioner will be liberty to apply for a refund of the excess amount paid by the petitioner in terms of the impugned assessment dated February 20, 2023 by deducting the fresh assessment from the deficit stamp duty already deposited with the register of this court in terms of the impugned assessment by the petitioner. Upon such application being made, the Registrar General of this court shall refund the excess amount to the petitioner at the earliest thereafter, preferably within a month from the application being made by the petitioner. Now, this is the text of this direction.
Yes.
Accordingly, the order was communicated. As per your lordship's direction, they are to do it within 15 days from the communication of the order. Nothing has been done. Finding no other alternative, after serving 2 notices, we filed this contempt application.
Yes.
When the contempt, there are some other
stories also, yes.
When the contempt application is pending, last week, they did not appear. Also, of course, they were not aware that contempt application is there. Now, when we have served the notice, they have sent one application for clarification to us. Taking that, wrong submission has been made before lordship. Well, may I put this question to myself? Even if the wrong submission has been made by both the sides, myself and my learned friend, can it be a ground for clarification?
When was the clarification filed according to this copy?
1st February, my lord.
1st February.
When did you communicate?
Last week.
No, oh no, communication was after that. No, not that communication. The contempt application.
Last week.
When did you file the contempt application?
27th February.
So at least before that they have done it.
Yes.
So I'll direct that clarification to be
it is appearing in your lordship.
Oh, which item?
Can two, yes.
According with this?
Yeah.
Along with this?
Yes.
So let me hear can 2 first.
Yes.
Yes, can 2. Move it.
My lord, the submission was made, wrong submission was advanced by both the learned advocates, my lord, by me also, my lord.
Yes.
My lord, at that point of time, my lord, the stamp duty was 8%, my lord. And for that, my lord, I have annexed.
That time is 2006.
2006, my lord.
8%.
8%. Which
I have
was,
not stipulated any percentage in my order.
my lord, it was, my lord.
Because the direction, the portion read over by Mr. Chatterjee does not contain any percentage. It says that at the rate prevailing at in 2006, probably something like that. Let us revisit that, come back to that. To reassess the stamp duty at the rate as prevalent in the year 2006. So whatever was the rate, where does the question of 8% come?
My lord. My lord,
Very well.
page,
Complete your argument.
my lord, para 40, my lord. para 40 of the order at page 8, my
It
lord.
was incumbent upon the collector to calculate the stamp duty at the rate of 7%.
My lord.
And what have you calculated? What is the rate you have calculated?
My lord, 8%, my lord. Because at that point of time, the rate was 8%, my lord.
So you say you have calculated in 2006 rates?
My lord.
Show me from the Stamp Act.
My lord,
Act.
I have annexed for
Which page?
My lord,
Stamp Act একটু বার করবে ততক্ষণ। West Bengal
two. হ্যাঁ।
32, yes.
My lord, from 21/10/2022, second last.
Yeah. What
to
was that? 8%.
8%, my lord.
This is a municipal area.
This is the municipal area.
All right. So you said this was the rate at which it was calculated in the first place.
My lord.
So the entire direction was unnecessary because the 2006 rate was this.
It was 8%, my lord.
This is your contention in the.
So we are ready to comply with the order.
There is a question of complying because you have already assessed at 8%. You say. At what rate have you assessed now?
Lord, we have assessed.
What is the current rate?
My lord, current rate is 6%, my lord. But this will be assessed at the time of 2006. Because your lordship has already decided that as the agreement was of 2006, therefore the
2006, yes.
My lord.
So what do you propose now? If I make this rectification in my order, then you will calculate at 8%, and do the rest.
My lord.
Mr. Chatterjee, there is bona fides in this submission.
No.
Why not?
Your lordship has seen page 32. Page 32.
I'm still there, in fact.
Yes. Now, from 1/4/2002 to 20/10/2002, 6% of the municipal area. Then from 21/10/2002, 6% has been changed to 8%. Correct?
Right.
Now your lordship can come to page 31. 23B, bottom.
B, yes.
B. 6% term of market value in case of market value of property does not exceed rupees 25 lakhs. And 7% term of market value in case market value of the property exceeds 25 lakhs. Now, my lord, these 6% has been changed to 8%.
My lord, may I?
1 minute,
Let him
please.
finish. Yes, please take your seat. I'll come back to you, definitely.
6% has been changed to 8% from, your lordship, can you see the date? 1/4/2002 to 20/10/2002. Then 21/10/2002. And this will be more specific if your lordship kindly come to page 63, the Stamp Act, the amendment of the Stamp Act itself.
No, Mr. Chatterjee, please just, I'm getting mixed up in this. First, let us complete this page 31 thing.
Yes.
So,
My lord,
6% term, yes. Conveyance, on conveyance, 6% term.
6% term in case of property market value does not exceed 25
Your
lakhs.
property is below 25?
No, more
above.
More than. So I will come 7%, not 6%.
All right.
That has been done.
Right.
That was prayed. That has not been done. That has been prayed. Your lordship is allowed because 7% is my appropriate rate.
Yes.
Now my learned is showing this. Yes, this is in respect of 6% up to 1/4/2002 to 20/10/2002. That is in respect of property of
below.
Aha.
So this 6%.
This is the mistake, and that mistake has been rectified by them in 2006 amendment of statute.
Let us come to now page 63, you said.
Yes. Your lordship kindly come to 2.
2, yes.
2. The Indian Stamp Act 1899, hereinafter referred to as the Principal Act, shall in its application to West Bengal be amended for the purpose and in the manner herein as follows. In Schedule 1A to the Principal Act in Article 23, in the column under Property Stamp Act, clause A, the word 8%, the word 6% shall be substituted.
8 A is not applicable. B.
No, 8 is applicable.
No, B is applicable. B.
Oh,
B.
then
Next.
clause B, the word 8%, the words, the word 8% term, the word 6% term shall be substituted.
For 8, it will be 6.
6. So from 2002.
No, where is 8 in?
This is the 8, page 32.
Oh, achha, very good.
Page 32. So, this comes from 21/10/2002 to 31/7/2006.
There were 2 slabs. One slab was
This is the date. Up to 31/7/2006. Now, your lordship kindly see this amendment has taken into effect from 31st July 2006, page 62.
No, Mr. Chatterjee, as per page 63, the 8% will
be 6%.
6 will be read as 6. Where is the 8%? The one they pointed out.
This is 8%, 21/10/2002, last but once.
This will become 6 according to the amendment.
And your lordship kindly see the date. This is valid up to 31/7/2006, page 32.
Yes.
Your lordship kindly see.
31/7/2000. Your deed was executed before that, in 2006. Yes.
Now,
before 31st July.
Now, from page 62, the effect come from 31st July 2006. Revert back to 6%. The excess which have been made wrongly, that has been rectified now.
31st July 2006, right?
Page 31, page 62.
So this 8% has to be 6%.
8% has been 6%. But
that is not applicable to you in any event.
My rate has not been changed. And I am agreeable to 7% itself.
Yes, otherwise it would be 6%.
Otherwise it will be 6%. If I do it now, it is 6%.
But you are charged at 8.
Charged at 8.
My lord, at that point of time, when that agreement was made, executed, at that point of time, which was before 31st July 2006, my lord, and also before April 2006, 1st April 2006, because as per 32, page 32, 21/10/2002 to 31st July 2006, that was 8%. And my lord, may kindly be pleased to take up the page 61, my lord, once.
61.
My lord.
Yes.
Along with 31 and 61, my lord. Substituted by the West Bengal Finance Act at 69.
My lord, they have to make clarification because.
My lord.
No, let me hear. Yes.
69.
60?
69, my
yes,
lord.
item 69.
Item 69, substituted by the West Bengal Finance Act with effect from 1st April 2007. Page 61, my lord.
Yes.
My lord finds.
For the words. So this is the 2007
Finance Act.
Finance Act, that is. Page 62 is not that.
61, my lord. Page 61, my lord.
61 I've seen, you're 69. But page 62, this is not the 2007 Finance Act. This is a different.
West Bengal Finance Act 2006, my lord.
Yes, I understand.
So the 8% has been substituted to 6% on and from and after April and July, my lord.
2007.
2007.
Which comes after page 62, page 63.
Page 63. So as in any case, their agreement was signed before April 2006. So in any way, they will come under 8%.
No. 6% has been changed to 8%.
My lord.
Not 7%.
8% has been changed to 6%, my lord.
By what?
By, it was 8% was previously till 31st July 2006. It was 8%, which was changed and substituted to 6%.
Yes, because it was previously 6%.
Mr. Chatterjee, let him finish. He did not disturb you.
My lord, from 21/10/2000
yes, to 31st July, 8%.
It was 8%, which was substituted to 6% as at page number 31, and that has been clarified at page number 61, my lord.
No. No.
Even the page number 60.
No, what page 61 says is previously it was 6% per annum of the market value only. This distinction between above and below rupees 25 lakh, that was not there. That is what had been done by page 61. Page 61, see, the previous phrase was only 6% of the market value.
6%.
6% blanket
of the
below or above 25 lakh. Now, by virtue of this amendment, the substitution made is 6% if below 25 and 7% above that.
My lord,
They come above that.
above that. But
So then 7%, this does not have any bearing on what you are saying.
but that is, my lord, after April. After April, that has been substituted. He doesn't come under this, my lord. Because this is from effect from 1st April 2007, my lord. With effect from
আমাদের রেজিস্ট্রেশনটা কোনো
26 চলে যাচ্ছে।
No, you're wrong there. I'm telling you why you're wrong. First, this page 62 comes. 62 comes in. Mr. Chatterjee, take your seat. I've taken your seat now for the time being. Subject to your learned friend satisfy me otherwise. Please come to page 62. I'm sorry, I forgot your surname.
Devapriya Chatterjee.
Devapriya Chatterjee. Mr. Chatterjee, please come to page 62. Page 62 is of 31st of July 2006, right? So as on 31st of July 2006, forget about page 32 for the time being. We are only on page 31. This entire, both the things covered page 31, not page 32. Now, 62, don't agree just because I am saying. Say if I am wrong. Page 62 says it's effective from 31st of July 2006. So as on 31st of July 2006, as per 22B, for the previous words 8%, it becomes 6%. 6% term instead of 8. So let us come back to page 31. Before this introduction of this, I mean, what is there in 31? It was, then come to page 61. This was the previous thing. Come to item 69. Rather, after page 63, you have to look into page 61 to see what was there previously. Page 63 says it was 6%. Instead of 8%, it had been made 6%. That 6% is reiterated in item 69 at page 61. It says that for the word 6%, that means by page 63, by the 2006 amendment, it was made into 6%, which 6% is again amended on 1st of April 2007. How amended? This 6% term, it was only that. Now it has been divided into two categories, 6 and 7. So the last position is page 31, which says 6 and 7, 7% term of the market value for over rupees 25 lakh. So it is 7% term as on even after 2007 amendment. Now let us come to page 32. Page 32 speaks about the exemptions and the notes. Please explain this page 32 to me.
My lord, first, this 2006 at page 62 and 63, and also page 31.
The last position after 2007 is this, what you have depicted at page 31. So the last position was this, page 31B prevails, which says 7% if it is above 25 lakh. When the property is situated in the areas of any municipal corporation or municipality.
But none of this apply to them, my lord.
Why?
Because this act came on July 30th, this amendment at page 62. That is from
came on 31st July 2006. 2006, by virtue of this amendment, 8 became 6.
8 became 6.
And thereafter, page 61 takes place, that Finance Act of 2007.
My lord, may I? So from on July 31, 2006, 8% became 6%.
Absolutely.
As on June 30th June,
it is 6%.
8%, my lord.
Come back to page 63.
63, my lord.
Page 63, 2B says in clause B, for the words 8, the word 6 shall be substituted. So 6 is substituted for 8. There is a confusion of prepositions in your mind.
For 8, 6 will be
For 8, 6 will be substituted. 8 thrown away, 6 enters. So it becomes 6.
Exactly, my lord.
6. Then what comes? Page 61.
My lord, if we take pause here, my lord, then
it's 6.
On 31st July.
June.
31st July 2006, my lord, it came.
31st July.
31st July.
It's 6%.
6 entered, 8 thrown away. So
forget 8 then.
On
6.
30th June, it was 8, my lord. On 30th June, it was 8.
But the amendment takes away that.
My lord, they come before June 2006. That's my case. That is my case.
No.
No, but you charge the stamp duty after this amendment came.
No, my lord.
Yes.
In Article 23, when was the assessment done?
Assessment done as per when the agreement was executed. And the agreement was executed.
When was the stamp duty assessed?
This year, 23. Last year.
2023.
Yes.
So as on the date of assessment, that amendment has already come.
My lord, but the agreement your lordship.
You say that the agreement time should be taken into consideration.
Which your lordship has also recorded in the order, my lord.
So it's 7% then.
But 7%.
As on July 2020, as per page 61, as on 1st of April 2007, which is after the execution of the agreement.
My lord.
You say then that becomes right. So what was the position? We have to see up to 30%. Oh, you say 8%, right? I was wrong.
So as per 2006 rate.
The entire thing you say comes after 30th of June. And their document was dated?
26 June.
Oh, very well. You have a point there, Mr. Chatterjee. I'll come back to Mr. Chatterjee. He says the relevant date, as per my judgment also and as per the law, has to be the date on which the document was executed.
Document was signed.
Executed, a document can be executed only signed. It cannot be executed. Mr. Chatterjee, so 26 June. 26 June, we have to see the rate as on that date. All these, page 62, page 61, all these came after that date with prospective effect. So, as per page 63, from 31st July, it became 8 became 6, meaning thereby previously it was 8. Previously means as on the date of your signing of the agreement, it was 8. So why should 8 not be calculated as the rate?
1 minute. Because your lordship kindly come to page 61, 68, column number 68.
68, yes.
2006 Finance Act, 6%. What has been changed to 2007 Finance Act?
That is 68.
68.
But 68.
68.
We are speaking about 69.
I'm coming.
Small letters.
I'm coming.
Yes.
Well, it's 68, 2006 Finance Act, 6%. Correct. Then 69, substituted by West Bengal Finance Act 2007, with effect from 1/4/2007. For the word 6% of the market value was not there. It has been included in 2007. This 2006 Finance Act came into force from 1/4/2006. If we take Finance Act to be considered, so 1st April 2006 is the date. Then
from that date onwards, it was
6%. But mine rate cannot be come under 6%.
Your rate will be 8%.
My rate is 7%.
Why?
Because of page 31.
31, this amendment itself came into force from 1st of April 2007.
2007.
And
So-
your document was executed before that.
Very well. So 2006, let them show what is the rate in 2006.
That is given in your page 63 itself.
No.
For 8%, it becomes 6.
No.
So as on the previous date, that
But
is 30th of June.
Page 61 says from 2006 it is 6%. From 2006 it is 6%.
Page 61?
Yes.
No, it says from 1st of April 2007.
No. Prior entry substituted by
Prior entry is immaterial. That is on a different aspect. We are concerned with the small letter 69, Mr. Chatterjee. That refers to the small superscript. It's called a superscript. Please come to page 31. There's a small superscript. That is 69.
Yes. Now,
that superscript 69 is referred to here.
If that is be there.
No, the other Mr. Chatterjee was all along right. I was wrong.
No. If that is be there, then 69 is 6% of the market value in case the marketable property does not exceed 25 lakhs. And 7% of the market value in case market value of the property exceeds 25 lakhs. That has not been changed.
That was changed after your deed was executed.
No, now your lordship, now if your lordship kindly come to page 32, that was changed prior to that.
32 need not be gone into at all. I go by the columns, the
Yes.
columns which we rely.
No, if your lordship go by the columns, then see, then it was in 2006. It was in 2006.
This is in consonance with what Mr. Deopriya Chatterjee is saying. Because if you take page 32 also, up to 31st July 2006, it was 8%.
8%.
And from 31st July, this amendment came.
Now, what is 8%?
No, he's
what was 6%? That has been made 8%. Nothing has been taken into consideration in respect to 7%. Because the property which is valued less,
yes,
that will be assessed more. That will be given more stamp in order to earn the government more. But
this came into being on 1st of July.
Which?
On 1st of April 2007.
No. Your lordship can come to page 22.
22?
22. This original schedule. This is 1/7/1988.
Hmm.
1988. This schedule has come.
Yes.
This was 1988. This was first time changed in 2006.
Page 32 was never changed. Page 32 is as it is, 8% for municipal area.
No. 8% for the municipality. This is 8% for not for the municipality. 6% has been changed to 8%. 6%.
Changed to 8%.
Not the 7%, which was in counts from 1988. It was continued till, if I say so, 30th June 2006. 7%. From 1st July 2007, 31st July 2006, it's changed to this, page 63. Am I clear to your lordship?
Mr. Chatterjee, I am extremely clear to you. I am not clear to you.
Now,
he wins.
Now, what I am saying, your lordship kindly come to page 22 first.
I am at page 22, yes.
Yes. This amendment has come into effect from 1/7/1988. Correct? So 1988, it's continuing. My case is of June 2006. So it covers in that.
Whatever was the rate on that date?
On that date, that is the rate 7%, which property exceeds 25 lakh.
No, the 7% came in only from 1st of April 2007 as per the Finance Act.
No.
Oh, no.
No. Your lordship kindly come to page 31 first, then I am going there.
I've been roaming around 31, 32, 61 and 63.
Page 31
for
first.
last half an hour.
Page 31. This is 25, above 25 lakh, 7%. Your lordship kindly.
I'm clear in my mind, Mr. Chatterjee. Satisfy me otherwise.
Now, 25 lakhs. Above 25 lakhs, 7%. Now, page 32, it says what was 6% up to 2002. That has been changed to 8% from October 2002 to July 2006. In respect of 7%, nothing. Now, your lordship can go to page 61.
I remember what is there in page
61. Page 61, 69 column says 6% from 1/4/2007. What was 6%? What has been made 6%? Which was made 8% from 21/10/2002, 31/10/2006.
Mr. Chatterjee, let me pass my order now.
That has been changed. And one second aspect of the matter, that this clarification is not maintainable in view of the recent Supreme Court judgment delivered by Malaysia on
It's a patent error on the part of the court. Court can always rectify. And arithmetical error at that. Clerical or arithmetical. I'll put it as clerical. Or arithmetical, whichever you prefer. I give you that choice.
No. Clerical error is all right. Only clerical error can be done.
Arithmetical also.
Arithmetical error. Clerical error is nothing but arithmetical error.
Palpable mistake, court can all. Mr. Chatterjee, you have taught us this. Court can always rectify its own mistake. Even no application is.
Your lordship kindly appreciate that thing. 6% has been changed to 8%, not the 7%.
That I've heard you. Yes. Can tutor, huh? Learned counsel for the alleged contemner, who has preferred the present application for modification of the parent order, submits that at the relevant juncture, contrary to 7% as recorded in the parent order by this court, the appropriate rate chargeable as stamp duty was 8% for municipal areas. First up, it is contended that the writ petitioner's document was executed in the month of June 2006 and as such, falls under the note annexed to the Schedule IA of the Stamp Act as amended in West Bengal, which enumerates that from October 21, 2002 to July 31, 2006, the rate was 8% for municipal area. Pushed up. On and from 31st July 2006, the West Bengal Finance Act 2006 came into force, which amended the 8% to 6%, which again was substituted by the West Bengal Finance Act of 2007 with effect from April 1, 2007, which introduced a line of distinction between properties worth rupees 25 lakh or less and those above the said amount. Full stop. For properties above rupees 25 lakh, the 6% was reworked to be 7%. Full stop. However, the said two financial acts of 2006 and 2007 are not applicable, since it is clear from the 2006 Finance Act itself that the rate immediately prior to 31st July 2006 was 8% for municipal areas. Push up next para. Learned senior counsel appearing for the writ petitioner controverts the contentions made by the applicant. Push up. Learned senior counsel places reliance on Article 23 of Schedule IA of the Stamp Act, in particular clause small b within bracket thereof, which clearly distinguishes between properties not exceeding rupees 25 lakh and those exceeding the said amount. So for the latter, the percent of stamp duty payable is 7 of the market value, which applies to the case of the petitioner, since the deed was executed in the month of June 2006. Push up next para. Learned senior counsel places reliance on the 2006 Finance Act, which reduced the amount of 8% to 6%. Pushed up. However, learned senior counsel submits that on a composite reading of the 2007 and 2006 Finance Acts, the amount payable as it last stood was 7% per annum, 7% of the market value per annum. Push up next para. A careful reading of the relevant provisions as placed by learned counsel for the parties reveals as follows, colon the next para. As on 30th July 2006, comma, now as on 30th July 2006, comma, the rate of stamp duty payable for municipal area, comma, as per the note supplied immediately after Schedule IA was 8%, full stop. In fact, comma, as per the said note, comma, from October 21, 2002 to July 31, 2006, comma, 8% was the stamp duty chargeable for municipal areas. Full stop. It is only by the West Bengal Finance Act 2006, comma, with effect from July 31, 2006, that the said 8% was reduced to 6%, which again was subject to an amendment by the West Bengal Finance Act of 2007, which came into effect on and from April 1, 2007, comma, substituting the expression double inverted 6% term, double inverted close, to 6% for properties of value of or below rupees 25 lakh and 7% for value for properties worth above that amount. Full stop, next para. However, comma, the said change came only on and from April 1, 2007. Full stop, next para. There are two indicators to show that in June 2006, comma, when the writ petitioner's document was deed was entered into, comma, the stamp duty payable for market areas was 8%. Full stop. The first such indicator is the mention in section 2 within bracket 2 within bracket small b of the West Bengal Finance Act of 2006, that for the words 8% term, comma, the word 6% term shall be substituted, which necessarily implies that before July 31, 2006, immediately before July 31, 2006, comma, the stamp duty was 8%, which was reduced by the 2006 Finance Act to 6%. Full stop, next para. The second indicator is the note which is annexed to the Schedule IA of the Stamp Act as amended in West Bengal, which enumerates that from October 21, 2002 to July 31, 2006, comma, the stamp duty payable was 8% for municipal area, comma, which was never amended. Full stop, next para. Thus, comma, the present applicant stroke alleged contemptor is justified in arguing that it was wrongly mentioned in the order of this court dated August 29, 2003, that the stamp duty payable at the relevant point of time was 7%.
23.
Full stop. What was the date of the order?
20th February
20th?
February 23, my lord.
Oh, I'm sorry.
29th August 2003.
No, we gave.
Your lordship's order.
Yes.
Your lordship's
20th
order is 29th August 2023.
Assessment actually 20th February.
That is what I said. That is under contempt.
That is under contempt.
Full stop. তাহলে ওই অগাস্ট যেটা বলেছি। Full stop, next para. In view of the above observations, comma, the expression within double inverted, which was the paragraph, Mr. Chatterjee?
Page para 40. Para 40 at page 8, my lord.
The expression within double inverted at the rate of 7%, double inverted close, used in paragraph number 40 of the order of the said order dated August 29, 2023, passed in WPA 4744 of 2023, shall be read as 8% of the valuation of the property. So you have to recalculate according to that.
My lord.
Full stop. There is no discrepancy in the rest of the said order. Full stop. The following paragraphs in the said order shall be read in the context of the above correction as incorporated hereby. Full stop. Since there was justification in the delay occasioned by the alleged contemner, comma, the alleged contemner should be given a further chance to comply with the order of this court dated August 29, 2023, and to reassess the stamp duty at the rate as prevalent in the year 2006, that is at 8% of the valuation of the property, taking the agreement in question to be classified under the relevant items of the stamp act. Full stop. Next para. In order to give some time to the alleged contemner to do the same, comma, the Mr. Chatterjee, then no contempt lies because
Contempt lies, and that portion of the order is also not required because they have already assessed 8%. It was under challenge before your lordship.
oh, acha. Then there is no necessity of reassessment.
No question of reassessment. They have already assessed, and according to their assessment, we have already deposited the
Oh,
amount.
so then I'll recall the order.
Yes, your lordship
Very
recall the order. They have already assessed.
Very.
And only thing I'm praying, subject to lordship's kind consideration, my lord, initially when the order was passed by my lord Justice Moshui Bhattacharya, was pleased to direct that he will deposit, register will invest the same short-term fixed deposit, and after this matter is over, the amount will be decided by the appropriate court at the time of final disposal. Now, my lord, they have calculated the amount that will be sent to them.
They will send it to?
No. That will be sent to them by the register because it has been deposited.
Yes, the rest will be refunded to you.
Yes.
That was the previous order. And that is my order also in terms of Justice Bhattacharya.
Yes.
Who's up next para? No, next para. Last কি প্যারাগ্রাফ হলো? এটা কেটে দাও তার আগের সেন্টেন্সটা।
ওইটাই তোমরা পাবে। সলক্ষ 32
যেটা ইন্টারেস্ট ওটা আপনি
এটাও কেটে দাও, এটাও কেটে দাও। তার আগে কি বলেছি?
There is some discrepancy in the said the final correction in the said order shall be read in the context of the above correction as incorporated here.
Next para. In view of the above correction, comma, the entire of this code dated August 29, 2023 is required to be recalled, comma, since in the first place the authorities had assessed the stamp duty to be 8%, which was impugned in that said writ petition. Push up. Accordingly, the order dated August 29, 2023, passed in WPA 4744 of 2023, is hereby recalled, and accordingly, Can 2 of 2024 is allowed. Pushed up. Next para. Contemptual issue. In view of the order passed on Can 2 2024 recalling the order under contempt, comma, there is no scope of keeping the contempt application alive, comma, full stop. Accordingly, CPAN 389 of 2024 is dismissed in the light of the above observations. Full stop. Next para. However, comma, it is made clear that in terms of the order under contempt, comma, you have to make an application, Mr. Chatterjee, to the register for that. I gave you that liberty.
Yes.
Do it as soon as possible. Accordingly, comma, the petitioner shall make an application before the Registrar General of this code. Oh, then no question of any refund is there.
No.
Oh, you had given excess.
Interest also.
Part.
So then everything remains. There is no scope of that refund.
No. Interest first will come to me. They will get 6,32,000 what they have assessed. Beyond that,
no, that interest was apportioned according to that 8%.
No. The amount which I have deposited,
delayed deposit.
No, deposit with the Registrar General High Court as per the order of
that interest on that.
Interest. That their entire calculation is delayed deposit, surcharge, everything is 6,32,000.
Yes.
The
to the Registrar General of this court for refund of excess amount to the petitioners, comma, upon disbursal of the amount of stamp duty which was assessed in the first place by the respondent authorities.
This is the stamp duty, 6,32,900.
632,900 shall be refunded to them.
Yes, shall be sent to them, not refunded.
632
900.
950.
950.
950.
900.
900.
50 rupees.
No, it is 900. It is not 50. Your lordship, can take it.
Accordingly, it's all right. Accordingly, comma, the Registrar General of this court shall disburse the amount of rupees 6,32,900 to which authority in particular, Mr. Deopriya Chatterjee?
My lord,
The collector.
collector.
To the collector. To the collector, comma, North 24 Parganas, comma, in lieu of stamp duty, which was payable by the petitioner for in respect of the document in question within 3 weeks from date. Full stop. Next para. Insofar as the interest component on the same, which has accrued on the said amount in the meantime, comma, the Registrar General shall refund the same to the petitioners, comma, within also within. No, that will I'll give a little bit further time. Also, within 4 weeks from the date of the application made by the petitioners in that regard, upon deducting the official charges. Upon deducting the official charges.
But that was in original order. Official charges will be shared both of us. That is the original order.
Because they were not at fault, then I should also pay a part of it.
The original order was this.
Yes.
You kindly leave, my lord.
Next.
27.
27, who is appearing? Yes, Mr. Sinha, what is the matter? State Sentence Review Board.
My lord,
The entire jails will be vacant soon for you.
my lord, they are not happy with it. My lord, despite your lordship's order dated 26 February 2024, page number 24, para 29 is the operative part.
Para 29?
Para 29.
24, para 20, yes.
Lord,
To be released, they have not released?
my lord, they have not released. They are. I have talked with the alleged contender number 2. They are saying I have sought for the convicting court NOC. These things required to be done within 7
This
days.
is appearing for the first time.
My lord, I have served the advance copy because
Advance copy is not valid in a contempt application. A sufficient prima facie contempt has been made out as allegedly, comma, the he was the petitioner or whom?
my lord, he was the petitioner along with his wife.
Which petitioner? Number 1?
One, my lords.
The petitioner number 1 has not yet been released from prison, thereby prima facie flouting the specific direction of this court dated February 26, 2024. Push up. Accordingly, the petitioners shall serve copy. How many contemners?
My lord, 3.
Serve copies of the contempt application on the alleged contemners, indicating that the matter shall be listed on April 12, 2024, when the petitioners shall file an affidavit of service.
My lord, liberty to add present incumbent alleged contender number 1.
Should have said that at the beginning, Mr. Sinha. Why do you complicate things?
My lord.
প্রথমেই করে দাও, এটা প্রথম paragraph হবে. On the prayer of learned
apologize.
counsel for the petitioner, comma, the present incumbent in the post of alleged contender number 1 be impleaded as the alleged contender number 1, whose necessary consequential amendment to the cause title of the contempt application shall be carried out by the learned advocate for the petitioners during the course of the day. যেখানে copy service এর কথা বললাম, serve copies of the amended contempt application. Do the correction immediately. Yes.
I
next.
apologize.
No, it's all right. Next.
28.
In this manner, I am appearing on behalf of the
No, the order has been complied with, PPO has been issued, money has been withdrawn. Possibly my land friend is not aware.
Money has been withdrawn, but not yet.
Not till now.
Yet channelized to
Let
him.
a copy be given to me so that I can.
8th of March, they have withdrawn the money from the bank.
Don't quarrel with your learned senior friend. Give a copy to him.
Well, let a copy be given
He
to
should
me.
be having this information, my lord. His
Give a copy. Have some mercy.
Well,
Give a
bank
copy.
is, anyhow, bank won't.
Do you have an extra copy of this?
Well,
Oh, Mr. Chakraborty has.
I don't know whether.
No, Mr. Chakraborty
Copy
just
of the same
asked
given.
Mr. Theory to give a copy to him during the course of the day. Should I return this to you? Further.
Well, even on 19.
Learned ASG seeks to hand over a document which is relied on and submits that the order has been complied with. Puts up the
And
PPO.
communicated to the petitioner on 1st March 2024.
The PPO has been issued and the money has been withdrawn, comma, the communication having been made to the petitioner some time back. Full stop. The alleged contemptor shall file a copy of the written communication relied on by learned ASG during the course of the day and hand over another copy of the same to the learned advocate for the petitioner also during the course of the day. Full stop. The matter be listed for orders on March 27, 2024 at the top of the list.
27, kindly do not keep it.
Very well. Then
After 27 or 20.
then I'll keep it on 5th April for orders on April 5, 2024 at the top of the list now. Normal course I'll just but give those copies, file those copies.
I'm for the bank, my lord.
You have to pay. That's why the shoe pinches.
Against non-issuance is the PPO. But now I have not come against the bank.
No. That will
So if it is paid me, I got nothing to say. Rather, I should take.
you have
task
something to
my
say to your client.
Yes, I should. Because on 19 he has appam. There's nothing has
And vanished. That is what happens, Mr. That's not unusual.
That's if that be so, it is the fault on my client that I had come before.
Faults of clients are not unusual.
fact.
That is what I'm saying. Thank you.
Application, item 29.
Yes, what is the application about?
An execution application has been filed. My lord, we have prepared an appeal, my lord. We had mentioned it and it is item number 4 today.
4?
Yes. So,
My lord keeps it, my lord, on 5th of my lord April, my
Well,
lord.
I'll keep it in any event after 2 weeks because learned senior counsel appearing, you are for the state.
Yes.
Learned advocate general appearing for the alleged contempt, learned advocate general appearing for the state submits that an appeal has been preferred against the order which has been sought to be implemented by the present application. First up, the said appeal is appearing as item number 4 of the daily list before the division bench. First up, for the hence, comma, for the sake of judicial propriety, comma, the matter is adjourned for a fortnight and shall next be listed on April 5, 2024 under the same heading. The item number regarding
3, item number 3, not 4.
as a 3 item. As item number is appearing in the days list before the division.
Grateful, my lord.
Come back on 12th. Not 12th, 5th. I'm sorry, 5th April.
5th of April.
30.
Yes.
My lord, I appear. Item 30 and 34 are connected matters. My lord.
30, 34 dekhe da, we filed it. I'll take up both together then.
As your lordship directs. Your lordship may remember that this is the matter regarding the disbursement of funds from the HDFC Bank that were in which your lordship passed an order.
Traveling HDFC and all the other banks regularly, so I don't remember actually. Literally, I don't remember. So let us come back after the recess. It's 1:15 now. 14.
Very well, madam.
We'll come
As
back.
your lordship directs.
We'll continue with these matters. After recess, could you fix that? Probably if I complete that, then I'll take up this.
Lordship.
Great.
Great. 30 for action.
To be mentioned item number 2 for filing written notes of argument.
Sure, for the petition. So may I file your lordship?
My lord, the note is,
Yes, Subhachi.
my lord, one, my lord, forgiveness, my lord, I have to, my lord, seek, my lord. Came to me for settling, my lord. I have added, my lord, 3 lines by pen. My lord, I have asked for a, my lord, printout of, my lord.
Yes, yes. You,
My lord,
just
I'm-
get it filed during the course of the day. Or just...
No, it's here, my lord. I have
Okay.
it. If your lordship doesn't mind, my lord. But otherwise, my, it's come or no? It's come.
No, it's all right. Then ask her to file a proper one if you have any.
No, I thought your lordship might appreciate my handwriting.
Has to be better than mine, whoever's.
And it's in green ink, my lord, so that, my lord, it's done rather than, my lord.
Yes. You are colorblind.
I'm grateful, Your Lordship.
Written notes of arguments filed by learned counsel today be kept on record. The hearing is concluded in the matter and the matter is reserved for judgment.
Obliged.
Thank you.
Item 65 fixed at 2 p.m.
Yes. Mr. Rai was probably
Yes,
arguing. Yes. Outside.
He must have come now.
Yes.
এসছে?
এই আগেরটা পিটিশনারটা ফেরত দিয়ে এটা নিন। Yes, sir. Please.
On the last occasion, my lord, I was dealing with this point
Yes.
that apropos of the yards or the siding yards, my lord, becoming public, the writ petitioner, my lord, loses its control. And that's why they are affected. They say the promise is to give me only. Now this onlyness is going out. Now, my lord, I will deal with this point in 2 stages. One is what is now, after I say public, what is happening in public. And it was my endeavor to present the case, my lord, from the admitted documents. Because after all, writ petition, my lord, I will try to do it as far as possible on the admitted position first. Admitted position is, my lord, today, the so-called third party cannot come in without the active connivance, in my humble submission, of the writ petitioner. So the question of public may be public in the level, but in fact, my lord, this is absolutely private, because unless the writ petitioner says yes, nobody can come in. But what is happening is, my lord, that it is not the whims and caprice of the government officials also that whosoever can come and take it. It has to be, my lord, on a chart. The printed names has to be there, and the printed name will only be there provided it is recommended by the writ petition. This is first point. Now, my lord, well, I was trying to assist, my lord, on this question. The question fell, my lord, and which was very, in my humble submission, my lord, pertinent. That what was the position earlier?
Yes.
Now, my lord, in that context, my lord, I'm just kindly come to, my lord, page 73 of the writ petition.
Yes.
Kindly see, my lord, page 73 is the 2016 circular.
Right.
And Mr. Banerjee's client did not have any objection so long as this was there. Now, my lord, kindly see page 73, 2.5. Co-user refers to the permission given by the rail user other than the owner of the private siding by railway administration for using the siding for handing over this own goods traffic at that siding subject to the provisions of the siding agreement. So, my lord, earlier the co-user concept was there and the co-user was directly under the railway administration. So, what was labeled as private was in fact public. Because here the owner of the private siding did not have any control. Now he has got all the control. But he says it was private, now it's public. But if we just go beyond the level stage, beyond the index stage, we will find that in substance, in reality, what was happening was earlier, the railway administration had absolute control. That the railway thought, my lord, is not conducive, because one person may do something, one person may do, but the administration thought, my lord, it has to be transparent. Anybody cannot come and grease a pump somewhere or somewhere down the line and take a indent and put it. It has to be all documented. So first you decide with whom you will give it. Yes, but there the question arose, my lord, and here I was ended last time, that suppose he doesn't give, theoretically speaking. So what happens? On that context, I was referring to the provisions of, my lord, the Competition Act, Section 3 and Section 4. Now, my lord, we have given a copy of the Competition Act, my lord, the
ওদের কপিটা আমাদের কাছে রয়ে গেছে
probably valid, because I wanted to.
Yes.
Here, and probably, my lord, I have shown, my lord, what is the dominant position at Section 4 and how one can abuse the dominant position. Probably, my lord, I have shown after in 4, my lord, after explanation in E, there is one A, which is the dominant position, my lord. And my lord was observing very prima facie, my lord, that this is in respect of a particular geographical area. And I said, yes, it is in respect of a particular geographical area, but it is applicable. Prima facie, it's applicable, that dominant position. And kindly see, my lord, D, no enterprise or group shall abuse its dominant position. There shall be an abuse of dominant position under subsection 1 if an enterprise or group, kindly straight away, my lord, comes to C, indulge in practice or practices resulting in denial of market access in any manner.
No, this is C of
4C, my lord, 4.1C. Sorry, 4.2C. 4.1 says, my lord, I come.
4.2C, right, yes. Yes.
First, it says no enterprise or group shall abuse its dominant position. And then it explains that there shall be a dominant position if it indulges in practices resulting in denial of market access. Now, here what he says, my lord, he says that control, exclusive control. That's his argument. So, today, his own argument, with all humility I submit, is going against the law.
But that depends on the initial agreement between you. I mean, under what conditions you had given them.
No, there is no agreement, because
I'd rather the previous circular. And if you gave that right to them, if it was there, then they cannot be guilty of Competition Act violation.
Probably not, my lord. Why I say so?
Achha. Yes.
Because suppose, my lord, I have given them, take a theoretical example where I have given them every monopoly. Then what will happen, my lord? Kindly come to anti-competitive agreements, which is 3.
Yes. This had retrospective effect.
Not when this is 2002 Act.
Oh, this was 2016, right?
2005. It
came. So the first one was given in 2005.
2005.
Well, yes. So therefore, this comes within this.
What I'm submitting is, when I want to assist, my lord, in a bit different way. Suppose I have given it. Take it, my lord, for a theoretical plane, just to test the correctness of this proposition. Suppose the railways have given a monopoly thing. Can that continue after the policy of 2021 or 22? In my humble submission, no, because kindly consider this Competition Act, my lord, 2002, which came in stages, 2003, then 2005. What is it against? Previously, it was Monopolies Electricity Practices Act, my lord. What are we aiming at? We are aiming at, my lord, as a state, we have to have, my lord, the maximum utilization of the resources. And monopoly, my lord, is an antithesis of this fundamental principles of law. Today, why can't we have monopoly? The reason being that it will negate growth. it will negate growth. And that is the reason, my lord, with all humility, I submit that any agreement entered between the enterprise or association or by and between any person, which, my lord, kindly see, my lord, here, section 3, first it says, my lord, no enterprise or association or enterprise shall enter into agreement in respect of production, supply, distribution, storage, acquisition, or control of goods or provisions of services which causes or likely to cause an appreciable adverse effect on competition within India. So, my lord, my first proposition is, if suppose what their understanding of law under the old regime is to have a monopoly, this is today an admitted position. So they want to enforce that monopoly. So I say, my lord, this is anti-competitive by their own admission. And that's why, my lord, this is having an adverse effect on competition. They say what? No. I was given a right to have adverse competition, to negate adverse effect on competition. So I must continue with that right. I say, first of all, there is no right. I will come to that. But even if there is right, for the sake of argument, after the provisions of this act is there in the statute book, after all, there cannot be any estoppel against law.
Good.
Then, my lord, kindly see, any agreement entered into contravention of the provisions contained in subsection shall be void, not voidable. Suppose, that's why I said, my lord, with all humility, that probably the situation. Then, 3, any agreement entered into between enterprises or association or enterprises or persons or association of persons or between any person and enterprise or practice carried on or decision taken by any association of enterprises or association of persons, including cartels engaged in identical or similar trade of goods and provisions of services, which, my lord, here kindly see, B, limits the control production, limits or controls production, but then, my lord, supply, markets, or other provisions of service. So here, my lord, it is affecting the supply word.
Right. Yes.
Then, my lord, kindly see 4. 3.4. Any agreement amongst enterprises or persons at different stages or levels of production can, in respect of production, then, my lord, supply, distribution, storage goods, and B, my lord, exclusive supply agreement shall be an agreement in contravention of subsection 1 if such agreement causes or likely to cause any appreciable adverse effect on. So I submit, my lord, on the admitted position here, by virtue of their own argument, this is against law. This is my lord, pith and substance of the argument so far as, my lord, the control aspect is concerned. Then, my lord, my learned friend, in his usual fashion, my lord, have said that, look here, not only they were charging land licensing fees under the old regime, after I have instituted the proceedings, after an order was passed, even then today they are charging me under the old regime. So once they are charging me under the old regime, their entitlement, if any, under the new regime goes. This is the crux of the matter. Now, my lord, kindly see whether legally speaking, whether there is any substance in this apparent attractive argument. Kindly come to, my lord. आगे 279 টা দেখিনি 279 my lord, 274 is the first amendment of the circular of 2021. 274, my lord, has got probably Mr. Banerjee has.
Yes.
Kindly, my lord, straight away comes to 279.
Yes.
For the sake of clarity, on migration of an existing, my lord has got it, my lord.
Yes.
Sorry. On migration of an existing terminal of railway on railway land to GCT policy, land licensing fees, lease charges as per the license lease agreement prevailing before migration shall remain applicable, and the prevailing system of levy, sharing of terminal charges and terminal access charges, if any, at the specified terminal shall also continue. So, in case of migration, my lord, old will continue. Now, next. This provision shall also be applicable on under construction terminals where leasing licensing of land was approved before the issue of GST policy. Sorry, GST policy. So, under the first amendment of 2021, what was introduced was, I have to calculate under the old land licensing charges. This provision, which came in, my lord, 14th of June 2022, is also there in the new policy which came on 6th of December 2022. Policy starts from page 319. Kindly come to, my lord, 344.
Yes.
Now, 3, my lord, note 1 to 3. 3, kindly consider, my lord. For avoidance of doubt on migration of an existing terminal on railway land to GCT policy, land lease charges, license fees as per the lease stock license agreement prevailing before migration shall remain applicable, and the prevailing system of levy and sharing of terminal charges and terminal access charges, if any, at the specific terminal shall also go. Then, my lord, the provisions shall also be applicable on under construction terminals where DPR was approved before the issuance of GCT policy. So, in my factually, my lord, my hands are tight. Just because I have charged them under the old policy doesn't mean, with all humility, in law, that A, I'm stopped from saying that you are covered under the new policy. B, since they have paid, that's what I probably, my lord, has indicated that nothing will turn on that, because if my submission, my lord, is accepted by the court, then whether they have paid under the old policy when I have charged them or not, nothing will turn on that. Either I am successful in my submission, that the only way I could have charged, because you are there in the land admitted position, you have to give me certain land, is under the old regime.
Good.
On the admitted position. So, my lord, so far as the control aspect is concerned, I have indicated. So far as the land licensing fees, my lord, estoppel and etc., my lord, that also I have indicated. I have also indicated as to the dominant position and anti-competitive, competition. Then, my lord, the vital, the sheet anchor is, my lord, the question of promissory estoppel.
Yes.
There 2 cases have been cited. I will take the second case first and the first case later, my lord, if my lord permits. Yes. This is, my lord, Bharat Sanchar Nigam Limited versus Tata Communications Limited.
Yes.
Here, my lord, paragraph 5 and 30 has been relied upon. I am also relying upon paragraph 5 and 30, my lord. Kindly see the distinction. First is, my lord, in my humble point, this judgment, my lord, probably is an expression of thought by the Honorable Supreme Court, my lord, probably without laying down any law. These are certain directions which the Supreme Court gives, my lord, under the special provisions, because only probably, my lord, Justice Hansariya, when he was a judge of Guwahati High Court, lamented that High Court doesn't have something which Supreme Court had. He went to Supreme Court, he said, no, High Court will have. And that judgment, my lord, has been has been reversed by other judges of the Honorable Supreme Court. So what the Supreme Court can do, my lord, sometimes, probably the High Court may not do. But be that as it may, there are certain other points which I wanted to say. That is, my lord, this is a case of retrospective operation, which an expression probably, my lord, was also pleased to observe, my lord, when it was first cited. The dispute in the present batch of appeals pertains to the charges of infrastructure facilities which were being provided by the appellant to the batch of respondents, which were increased by a circular of 12th of June 2012 with effect from 1st April 2009. The question that arose was whether the applicant was justified in raising charges of infrastructure facilities with retrospective operation from 1st April 2019, more so when the yearly charges were paid by the service providers upfront every year. So, my lord, after accepting for 3 years the charges, they wanted to, my lord, correct it retrospectively. Now, my lord, with all humility, I submit, my lord, this is not the factual position here. And there also, the Supreme Court said, my lord, that notionally you can kindly see 30. The power to make retrospective legislations enables the legislature to obliterate an amending act completely and to restore the law as it existed before the amending act, but at the same time administrative stroke executive order or circulars, as the case may be, in the absence of any legislative competence, cannot be made applicable with retrospective effect. Only law could be made retrospectively if it was expressly provided by the legislature in the statute. Keeping in mind the aforesaid principles of law on the subject, we are of the view that the applicability of the circular with retrospectively from 2009 in revising the interest is not legally sustained. And to this extent, we are in agreement with the view expressed by the tribunal under the Impunity Act. So, there are two things. One is from 2009, I cannot do it, but from 2012, it is done.
Yes.
And number two is, my lord, so far as with regard to the notional increase is concerned, my lord, submissions have been made. And it says, my lord, that such notionally increased charges can indeed be leviable on the services provided, and to that extent, the order passed by the tribunal is not sustainable in law and deserves to be set aside. That is paragraph, my lord, 31, last sentence.
Yes.
So, my lord, this partly. So, my lord, kindly consider this. So, today, if I make a law saying you are not entitled to the rebates, that is accepted. Even by this judgment or expression of my lord thoughts is not applicable in my humble submission in the facts of circumstances of this case. Now, Mr. Banerjee, my lord, there is no written note submitted, but he said that it is also, my lord, retrospective, because retrospectively I was given certain things. They are now taking it out because of making of public and private. That probably, my lord, may not, my lord, cut any ice in this factual case. This is my humble submission. Now, my lord, the Brahmaputra metallics, my lord, have been cited, my lord, in great detail. Before I deal with Brahmaputra metallics, my lord, I must indicate that Brahmaputra metallics has not considered the case of VVF, Union of India versus VVF. I am handing over a copy, my lord. This is I will come to Brahmaputra in a moment. Kindly see, VVF is a judgment, is a 3-bench judgment. Irrespective of VVF, my argument is there, but I am taking, my lord, the easiest one first. VVF, my lord, is a bench of 3, and it is decided on, my lord. Kindly see, April 22, 2020. Absolutely in middle of COVID, probably. Those frightful days.
Yes.
April 22, 20, that is at page 59, my lord. Now, this Brahmaputra metallics have been decided in, my lord, December 1st, 2020, after, my lord, VVF is there. And kindly see, my lord, the copy that Mr. Banerjee, my lord, has handed over to my lord. Kindly straight away comes to page 646. 646. Here, my lord will find
646.
646 of Brahmaputra. Sorry, they have 2023 volume 10 SCC.
Right. Yes.
VVF, my lord, subject to correction, was not considered.
No. No, not considered.
Now, my lord, kindly see what Brahmaputra is saying, and thereafter I will come to VVF, my lord. Now, my lord, kindly come to my learned friend probably has referred to paragraph 22, 23, 40 to 51.
Yes.
Yes. My lord, may I just
7 probably.
Sorry, ma'am.
40 to 47 probably.
40 to 47.
51. 51.
That's we may have. Good, thank you.
51 was.
No,
51 was
51, my lord. 48, my lord, is when they apply, my lord, expectation
up to
reached by the
51.
state
Very
of
well. Yes.
Jharkhand.
Very good. Yes. Listen.
In fact, my VVF has made a distinction between promissory estoppel and legitimate expectation. I will come to that in a moment and why VVF may not be applicable straight in a straight jacketed formula. But let us deal with Brahmaputra once, my lord. Paragraph 22. The High Court has justifiably referred to this as a case of bureaucratic lethargy. As a matter of first principle, there can be no gainsaying the fact that when a statute such as Bihar Act of 1948 empowers the state to grant an exemption from its position, the state has the discretion to determine the date from which and for the period over which the exemption will operate. An individual or entity cannot compel the state to issue notification provided an provided an exemption or to insist upon the terms of the government done so. Whether an exemption should be issued and if so, the terms of exemption have to be determined by the state. But this case does not rest on that principle, nor did the claim of the respondent require High Court to make a departure from it. The industrial policy of 2012 containing a representation that a rebate stroke deduction would be granted. It held out a representation that a notification would be issued in a month. These were solemn commitments made by the state of Jharkhand. What remained was their implementation by issuing a notification which was to be done within a month. The state government evidently intended to implement and act in pursuant of its commitment, for ultimately did issue a notification, but it did so on 8th of January 2015 after a period of 1 month envisaged under the has dragged for nearly 3 years. This is the factual position. Well, how does it fit in, my lord? With all humility, Mr. Banerjee probably, my lord, could not explain in this case. Kindly come to, my lord, paragraph 23. It is time now.
Yes. Can I take 5? Yes. 5 to 10 minutes, not more than. I'll be back. I'm grateful.
It is a time for the state government to take notice of the observation of the High Court in regard to administrative lethargy. It is the time for the state government to take notice of the observation of the High Court in regard to administrative lethargy. If the object of formulating an industrial policy is to encourage investments, employment, and growth, an administrative lethargy of the state apparatus is clearly a factor which will discourage entrepreneurship. The policy document held out a solemn representation. It contemplated the grant of rebate stroke deduction from the payment of electricity duty, not only to new units, but to existing units as well as who had or could set up captive power plants. The state in the present case held out inter alia a solemn representations in terms of clause 32.10 and 35.7.b of the entitlement of the exemption for a period of 5 years from the date of production. Besides this, it's also contemplated under clause 38b that a follow-up exemption notification be issued within a month. That period, 1 month, stretched on interminably, with the result that the purpose and object of granting the exemption would virtually stand defeated. The net result was this belated attempt on the state government issuing the notification. It was prospective. As a consequence, by the time the exemption notification was issued, a large part of the term for which the exemption was to operate had come to an end. So exemption was for 5 months. They had to issue the notification within, sorry, 5 years. Exemption was for 5 years. They had to issue the notification within 1 month. They issued the notification after 3 years. In that context, Supreme Court said that you were supposed to do it. So you cannot say that I am issuing the notification after 3 years and they had to pay for 3 years and only they will get the benefit of 2 years. Here, since he has said 40, 42, 48 or 51 mark, I just kindly go refer to this. We shall, so far as my lord, the promissory estoppel and legitimate expectation is concerned, my lord, there, in my humble submission, is certain difference, which I will definitely try to assist in my own way by this 3-bench judgment decision and otherwise also. But here, it says, my lord, we shall therefore attempt to provide a cogent basis for the doctrine of legitimate expectation, which is not merely grounded on analogy with the doctrine of promissory estoppel. The need for this doctrine is to have an independent existence, as articulated by Justice Frankfurter of the United States of Supreme Court. Now, my lord, here, kindly come to 41. However, before we do this, it is important to clarify the understanding of the doctrine of legitimate expectation in the previous judgment of this court in National Building versus S. Raghunathan. The 3-bench of the court, speaking through Honorable Justice Sagir Ahmed, has held that the doctrine of legitimate expectation has its genesis in the field of administrative law. The government and its department in administering the affairs of the country are expected to honor their statements of policy or intention and treat the citizen with full personal consideration without any iota of abuse of discretion. The policy statements cannot disregard unfairly and applied selectively. Unfairness in the form of unreasonableness akin to the violation of natural justice. It was in this context that the doctrine of legitimate expectation was evolved, which has today become a source of sensitive as well as procedural rights. But the basis of legitimate expectation have been held to require reliance on the representation and resulting detriment to the claimant in the same way as the claims based on promissory estoppel. I pause here for a moment, my lord. The apparent impression given by my learned friend that private taken to public, in my humble submission, my lord, cannot hold good. And so the question of represent, what did I represent? I represent that you will be given something, I will label it as private, but I can have the exclusive right of giving it somebody else for the purpose of.
Was that the same position in 2005? No.
Yes, sorry, 2000, after
2016, you were relying on
2005, my lord, it was all silent. What was happening, my lord? You see, it's at one point to criticize someone, but it's another point to realize, my lord, that the rail officials are not always above board. There may be variety of reasons why. Now, what were we doing? In 2016, we introduced that he doesn't have any problem because he was quite happy with this. Why did we introduce this? The answer is very simple, my lord, because it was not possible to keep something on idle. Idleness, laziness, my lord, lethargy, as they say in this case. So today what is happening? I will take something. I will fix my own rates for other candidates. And I was doing that. In 2016, Railway said nothing, doing whatever I will say, you have to do it. Then Railways also thought that, no, this is maybe arbitrary. So you
say you traveled between the two ends of the spectrum and then came to the middle by this present one.
Well, what wrong have I committed? What is his legitimate expectation is something I can go to moon. But what is the legitimateness? What is the legitimacy in this expectation? That I will not have any control in the middle. Then, my lord, as we have discussed earlier, there was a substantial confrontation or overlap between the doctrines of legitimate expectations and promissory estoppel, even under the English law, since the former was often invoked as being analogous latter. However, since then, and since the judgment of National Building Construction Corporation, the English law in relation to the doctrine of has evolved. More specifically, it has actively tried to separate the two doctrines and the situation of doctrine of on the border footing. Then, my lord, several cases have been cited. Then 44, highlighted the different considerations that underlie the doctrine of promissory estoppel and legitimate expectation. The learned judge held that the application for doctrine of there has to be a promise based on which the promisee has acted with prejudice. In contrast, while applying the doctrine of legitimate, the primary considerations are reasonableness and fairness of the situation. Then, my lord, promissory. So here I pause for a moment. They have pegged their case on the question of promissory estoppel. I will not only try to destroy that, I will try to say, my lord, that even they are not entitled under these principles of legitimate expectation, because that assistance I have to provide to the court because I am appearing for Union of India. Then, my lord, several quotations have been made, and 51, my lord. Kindly see the last sentence. In my humble submission, this is the task of the matter. Since the state has offered no justification for delay of issuance of the notification or provided reasons for being in public interest, we hold that such a course is arbitrary and violative of Article 14. So, my lord, it comes down to the point that it is the lethargy without any cogent reasons, and what is more important in my humble submission, my lord, that it was not in public interest. Suppose there is a delay. If I can justify the conscience of the court that it is in public interest, in my humble submission, that's the end of the matter. Here, my lord, kindly see the public interest involved.
Other way around. Good.
No. My lord, yes. In the case of VVF, kindly come to, my lord, several things have been discussed, but for our point, my lord, kindly come to 24.4. Right? And 25.
21.5.
21?
Yes.
21.5. Sorry, my learned junior wants me to cite 21.5. Yes. 21.5, my lord. Kindly see, it has been quoted from Sri Steels Limited. Sorry, this is at page, my lord, 92.
Yes, got it.
Yes. 33 from the old.
Yes, previous.
Normally, the doctrine of promissory estoppel is being applied against the government, and defense based on executive necessity would not be accepted by the court. However, if it can be shown by the government that having regard to the facts as they have subsequently transpired, it would be inequitable to hold the government to a promise made by it, the court would not raise an equity in favor of the promisee and enforce the promise against the government. Where public interest warrants, I repeat, where public interest warrants, the principle of promissory estoppel cannot be invoked. The government can change the policy in public interest. However, it is well settled that taking cue from the doctrine, the authority cannot be compelled to do something which is not allowed by law or prohibited by law. There is no promissory estoppel against the settled proposition of law. Doctrine cannot be invoked for enforcement of a promise made because none can be compelled to act against the statute. Thus, the government cannot be compelled to make provision. Now, Malal, I pause here for a minute. That's what I said, Malal. Suppose I have made everything under the sun. But if I can show that it is contrary to law, it is contrary to Competition Act, it is contrary to the fact that I cannot utilize the resources for the maximum good for the maximum people, then, my lord, I am through. This is my humble submission. Thus, as held by this court, where public interest warrants, the principles of promissory estoppel cannot be invoked. It is held that the rule of promissory estoppel, being an equitable doctrine, has to be molded to suit the particular situation. It is not a hard and first rule, but an elastic one, the object of which is to do justice between the parties and to extend an equitable treatment to them. My lord, what is happening was, my lord, in respect of each and every cases which involve taxes and etc. or the revenue, I am paying a particular revenue to the government. There was an exemption or a sort of a benefit. That benefit was tried to be taken out, either, my lord, retrospectively or by some other means. There the court has intervened, whether under the level of promissory estoppel or legitimate expectation says no. But this was one-to-one between the government and a private party. Here, my lord, it's a policy decision. Here, my lord, if today, my lord, our contention is, my lord, we cannot do anything after the Gati Shakti has come without the Gati Shakti, my lord, of 21, thereafter 22. If the court wants to interfere, my lord, courts have got every power to. But court's power also is circumscribed by reasons. Now, what reason my learned friend has submitted, my lord, so that the court to intervene is the question of promissory estoppel on the basis that I was given particular benefits under the old policy. Now that benefits are taken. I have tried to show, my lord, is just reverse. In fact, some of the benefits which were not given under the old policy, we are giving it under the new policy. So the question of, my lord, and secondly, which has fallen from my lord, is that it's a policy decision after all. So one has to attack the policy. Now there, my lord, it's all humility, my lord, I submit, the fumbleness appears. He says, no, you have to interpret the word construction as if de facto construction, not de jure construction. There is some problem in my humble submission, because when we say either it is constructed, either it's operational,
Commissioned.
Either it's commissioned or not commissioned. Construction or no construction, either commissioned or not commissioned. Admittedly, my lord, it's not commissioned. Now, they want to interpret that no, although it is not commissioned, but there's an implied term, if I may use that expression, my lord, saying that this should also be treated as commissioned. There I say, my lord, there is no scope of any implied term in this policy that it is commissioned. Then they say, because it is not being interpreted that way, that's why the policy is bad. Yes. Sorry, my lord. If what they have said, if I can summarize, well, why is it bad? Why is it bad? On what reason it is bad? The only purported reason was private, exclusive, public for all. I have shown the other way around, and I have shown also the law, my lord, that today I cannot do it. I will be against the law. And courts usually, my lord, will not direct the government to do something under the new environment, my lord, so that a monopoly is created, so that, my lord, competition goes, so that, my lord, the dominant position is abused. Because he says, I have a dominant position, I will abuse it. So what? I could have abused it earlier, so I will abuse it now. $20. 24.4. 21. 24.4 and 25. Page 97, my lord.
Yes.
As observed earlier, the subsequent notifications to industrial policies do not take away any vested right conferred under the earlier notifications to industrial policy. Under the subsequent notification, the persons who establish new undertaking shall continue to get refund of excess duty. However, it is clarified that by subsequent notification that the refund of the excess duty shall be on the actual excise duty paid on actual valuation made by the manufacturers undertaken. Therefore, it cannot be said subsequent notifications are hid by the doctrine of promissory estoppel. The respective high courts have committed grave error in holding that the subsequent notifications impugned before the respective high courts were hid by the doctrine of promissory estoppel. As observed and held, the subsequent notification policies which were impugned before the respective high courts can be said to be clarificatory in nature, and the same has been issued. This is in larger public interest and the interest of revenue, and the same can be made applicable retrospectively. Otherwise, the object and purpose of intention of the government to provide excess duty exemption only in respect of genuine manufactures carried out areas concerned shall be frustrated. Here also I rely upon, my lord, two phrases. One is, my lord, that is to larger public interest is there, interest of revenue is also there. And why was this given? Because so that the genuine persons can come forward and do business. It is not a case to continue the fight or to keep it something close, because I also don't gain anything.
But here it was clarificatory to explain.
Huh.
And subsequent notifications only introduce the method of calculating. I mean,
Yes.
in
Here,
your
my
case,
lord,
it's not a clarificatory thing or just to explain. It's a different concept.
It's a
Which
different-
what they are arguing.
yes, what they are arguing. I say, my lord,
Not a clarificatory notification.
that's
The-
their argument. I say, my lord, these are all as has followed from lots with cliches. Whether it is clarificatory, whether it is explanatory, what is the, if the purpose is for the public good, is the larger public interest and in the interest of revenue, my lord has to consider these two aspects. Whether it is in the larger public interest or not, whether transparency is in the larger public interest or not, and whether it is interest for the revenue or not. I am not saying, my lord, I will take away something. What they're saying, you are taking away something from me, which you have, what is that which you had? You had a situation where the railways would have dictating that who is your co-user. And you are quite happy with 2016, no challenge admittedly. And in 2021, I am giving you something, and 2021, I am giving you something that you decide. But let us have this transparency so that even the railway officials cannot go wrong.
You have actually shifted the pivot, Mr. Rai. Mr. Banerjee's arguments were based on 2005. You have shifted the pivot to 2016, which is valid. I mean, and they have not challenged 2016. You are taking advantage of that. Because if 2016 remains, 2022 is an improvement for in their favor.
Absolutely.
Maybe.
But what was happening in 2005?
His argument was primarily on 2005.
Yes, yes, I understand. But what was there in 2005? Nothing. It was, if I may use that Bengali.
No, in 2005, Mr. Rai, others could not have come up.
What
There was a provision for others coming up.
My lord, that's what I explained in, by taking greatest of indulgence from my lord. It was Matshadnai of Bengal in this before Shenel.
Yes, no, that's a different argument. I mean, definitely there may be logic behind this public interest also you are arguing.
There was not what was happening. Kindly see, my lord, now with all humility, when the person from Bihar became the railway minister, he did what? Kindly take judicial note. The wrecks were going on with a particular, they say, I cannot load more than that. He came and said, no, because I know. Because that minister knew, the railway minister knew that no, in reality, people were overloading it.
Yes.
So he said, there's no, but whatever you load, you measure, you give the revenue. This, after Harshad Mehta came, then we realized the need of certain things.
Yes.
We were not that intelligent. The government, by the learning process, you get
Right.
a better intelligent person to show you that what you should do with law.
Absolutely.
Here, my lord, what is the moot point is that where is it in public interest? In 2005, what advantage were you getting? You were saying I was having the monopoly. Very good. I take it to that. Can you have it after the Competition Act of 2002? My answer is no.
Yes, that argument is always. Yeah.
So, my lord, whether it is clarificatory or new, my lord, in my humble submission, these are jackets which, if the court wants to wear, the court usually wear, because what is after 2016, we may say it's clarificatory. We may, but what is the pillars are 2 points. One is, my lord, the larger public interest and the legitimate interest of the revenue. If those two things are satisfied, my lord, and 24, 4, then my lord, 25. This is 26, my lord. Under these circumstances, the respective High Court have committed a grave error in quashing and setting aside the subsequent.
25 says, Mr. Rai,
yes,
that they do not take away any vested rights conferred under the earlier notifications and therefore cannot be said to be hit by the doctrine of promissory estoppel.
Yes,
So, but in your case, Mr. Banerjee is arguing that you have taken away vested rights,
Yes.
and which you are labeling as monopolistic rights.
Well, vested rights, when we say vested legal rights, that's the implied understanding of law.
Definitely.
It can't be, suppose I give them a monopoly right, by either I can give it without knowing law, or I can commit a fraud as against law and give them, provided is when a court is scrutinizing it.
Yes, at the relevant juncture, even in 2005 when you gave it, the Competition Act was there. So it was in the teeth of the Competition Act.
Yes. Now, kindly see, I have given them something. In 2016, I have taken away something completely that they are not challenging.
2006 is a big pillar of your argument. 2016, I'm sorry.
This is one.
Absolutely, legitimately also, yes.
And number two, kindly see the Competition Act also. Suppose I have
Yes,
given
that
them.
is there. That is there.
Suppose
3 and
I have
4 are
given
there.
them. Even then, will the conscience of the court, suppose something is done by way of a mistake, or something is done against the law, that is no estoppel against the law.
And there is a larger argument also, probably there cannot be any vested right against the law. I mean, in that, no vested right can be granted against the law, which is against the law. Or larger public principle also. So even if they had a vested right and public interest and law demands otherwise, you can take it away.
Yes. That's
Taking the best case in their favor.
Yes,
They
that's
had
the-
that right.
Yes.
Very well.
Suppose, suppose they have everything under the sun. Even then, question is whether they can continue before a court of law or not.
Yes, yes. Get your point.
আরেকটা কেস ছিল প্যারাগ্রাফ কত? হ্যাঁ, আর একটা কপি আছে। জাস্ট পড়ে দিয়েছি আমার কপিটা। সরি মালক। Yes, I'm doing. Malad, this is 2006. This is a slightly old case. 2016, my lord, volume 4. Volume 4, Supreme Court cases 134. This also, my lord, again subject to correction, has not been referred to in Brahmaputra Metallics. This is also a 3-bench judgment. Now here, I am relying upon paragraph 10 to 14. At best, they are saying the question referred to the bench as noticed is whether the state would have stopped from altering stroke modifying the benefit of concessional traffic by means of impugned government order number 861 dated 30th of April 1982 on the principle of promissory estoppel. So far as the caustic soda unit of Kothari subsequently taken over by Southern Petrochemical is concerned, strictly speaking, the above question would not arise inasmuch as at the time of unit was set up and started commercial production, the act has not yet come into force. The promise, if any, was made by the letter on the terms noticed above, namely the tariff payable was to be at a rate less than what is applicable to other 2 units of the state for the first 3 years and thereafter at the rate equivalent to what was being paid by the said units. Be that as it may, the question referred to squarely was answered by in Maladius, Sri Steels versus State of UP, where this court has considered a similar question with regard to the withdrawal of concessional tariff rebate in the industry carrying on business in the hill areas of State of UP. After an in-depth consideration of the provisions of Section 48-49 of the Electricity Act, under which concessional tariff and rebate was granted, and the provisions of Section 21 of this General Clauses Act, as well as the principles of UP Electric Reforms Act of 1999, under which the concessional tariff stroke rebate was later withdrawn, this court in paragraph 51 came to the following conclusion. From the discussions above, it is clear that the petitioners cannot raise the plea of estoppel against the notification reducing hill development rebate to 0%, as there can be no estoppel against the statute.
Yes, there cannot be. Settled, yes.
Paragraph 12. In paragraph 47 of the report, this court has considered and thought it appropriate to extract the views expressed in the case of JK Udaipur Udyog. An exemption is by way of definition of freedom from an obligation which the exemptee is otherwise liable to discharge. It is a private granting an advantage not available to others. An exemption granted under the statutory provisions in a fiscal statute has to be a concession granted by state government so far as the beneficiaries of such are not required to pay the tax or duty which were otherwise liable to pay under the statute. The recipient of a concession has no legally enforceable right against the government to grant a concession except to enjoy the benefits of during the period of grant. This right to enjoy a defeasible one in the sense that it may be taken away in exercise of the very power under which the exemption was granted.
But these are regarding concessions and rebates, which is a little different from here. Here they were given rights to operate a railway siding exclusively. That is what they argue. But it's not a concession or a rebate as such. They built that siding also.
No, why I was citing this
Yes.
is because of Brahmaputra. They said that 3 years later it came, that's why retrospective. But the power to reduce or to increase is still there.
That is regarding a concession or a rebate.
Rebate. Brahmaputra was also concession and
Oh,
rebate.
yes.
That's
All
why I
right.
said
Very good. This is same analogy.
yes.
Very
This is limited to that only.
All right. All right.
I kindly take it's up to 14.
Up to 14, yes.
Yes.
Para 12 is concession, 13 rebate and concession, and 14 is the crux, the conclusion. Rather.
This is the how. There's a copy of the thing to class. Well, these two cases are 3 bench judgments.
Yes.
Both of them.
Whereas Brahmaputra is 2.
Apart from that, well, I am tempted, my lord, to cite one judgment if my lord permits, because I am on one proposition, my lord, usually good doctors only give one medicine because they can identify the problem so well that they don't require, my lord, more than one medicine for a particular.
Then don't give them. If you acknowledge the doctor being good, then don't.
But this is again a very lucrative judgment to read.
On what proposition?
This is on judicial scrutiny and principles of legitimate expectation. Because I have to make, because what is passing through my mind is, my lord, in my humble submission, promissory estoppel, I think in my humble submission, I have tried to assess the
So
why even legitimate expectation will not come in? Why even legitimate expectation will come in? Because I have indicated that legitimate expectation means legal legitimate expectation. It has to be based on law.
It has to be legitimate.
Yes.
To be legitimate, it has to be legal.
Yes. And subjective legitimate is the objective legitimate expectation. The court will scrutinize on the basis that is whether it's reasonable or not.
So when can a court say that that expectation is legitimate?
Yes.
I mean, on the yes, you can cite this.
Right.
Yes.
This is, my lord, a case where legitimate expectation was allowed. Why I am citing this, my lord, with hesitation is because of the complete assistance I can provide. This is also not considered. Here, my lord, promissory estoppel goes out, legitimate expectation comes in. Here, what is legitimate expectation, my lord?
And legitimate expectation cannot override public interest, which is very para 52.
Yes,
I mean, from the head note sense.
Absolutely. This takes care of, my lord, the cases cited and the cases I have cited.
So paras 51 and 52 probably.
51 and 50. Yes, yes. This is, my lord, an I wanted to assist in the all comprehensive way. That's
yes, yes,
otherwise,
absolutely. Yes.
Legitimate, and why will it not applicable? I have also indicated. Now, my lord, I come to that compilation thing because what they have said is.
Mr. Rai will continue tomorrow because 3 in our original set.
Well, instead of tomorrow, maybe on 2nd of
tomorrow is very difficult for me also.
Second or first?
Second then. Second, no difficulty. Mr. Banerjee and Company. Heard in part for further hearing on April 2, 2024. Let us come back on that. Oh, এটা 2 PM ছিল। 2 PM কিছু আছে? At 2 PM.
Well, it made me on 3rd, 2nd April, Mr.
I
Banerjee.
waited for you for a long time.
Well,
Let it be on second. No. Let it be on second. Yes, we cannot wait for your senior's clerk to consult his diary forever. No. I asked you also.
I apologize.
Sorry,
for
no.
it.
Second 2 PM. Next. Yes.
Original side mentioning. Today's list. Contempt matter, item number 1.
And I'm the petitioner, my lord. The order on the content appearing for the very first time, my lord.
What is the content?
Page 220 is the order under contempt, my lord. Page 224, I can read out. That is the operative portion.
Right.
This is the third paragraph from the top. As such, the writ petition, this is the number is there, is disposed of by directing the petitioner to furnish bills of fresh, indicating the dues payable to the respondent number 2 bank for services rendered by the petitioner number 1 in favor of the respondent number 2 bank or its predecessor bank, that is UBI. I've done that. Such bills shall be submitted. I've already done that. I've complied this. Upon such bills being raised, the respondent number 2 bank shall immediately process the same if necessary, giving an opportunity of hearing to the petitioner in the event any doubt arises in the mind of the concerned official of the respondent number 2 regarding the veracity of the amounts claimed by the petitioner. Thereafter, the respondent number 2 bank shall disburse the admitted dues to the petitioner number 1 bank. The entire exercise as indicated above shall be concluded by the respondent within 4 weeks from the date of the bills being submitted by the petitioners to the respondent number 2 bank. Admittedly, my lord, the bills were submitted within this period, no hearing given within 4 weeks thereafter. So they have virtually admitted the bills, but
no, hearing was not if they felt necessary.
If they felt necessary, if
they might not have given you the hearing also. Might not have given you the
might not have given me the
might
hearing.
not have given you the hearing, might have held that nothing is admitted. That was also there.
Yes,
but they have not communicated anything to you.
Not specifically communicated. No order.
Vaguely, what has been communicated?
Vaguely also nothing has been communicated. Vaguely also nothing much has been communicated. I have been told to give the bills of fresh.
Are you sure it's a contempt or a new cause of action for a new?
No, my lord. Subject to correction. This is a contempt.
After you submitted the bills, did you inquire?
I have inquired. I've been told.
Hesitant on that.
No. I've been told to do a lot of things. I'll show.
Show those.
My will kindly. My will kindly come to page 173.
Yes.
I'm sorry, my will kindly come to page 168. This is 18 January 2024. Much after that 4 weeks have expired, but still this is there. In response to your representation dated 24th October 2019, we have verified our records and observed that the bills against security cards for 15 months has not been paid by the bank. However, from the peripheral records, it is observed that notice has been served for discontinuation of service since October 2019. In view of that, you are entitled to bills raised for 14 months up to September 2019, amounting to rupees 6,72,000 plus GST. The pending bills for 14 months have been approved by us.
Then,
so this is approved.
Let us read on.
However, we are unable to pay GST on the basis of old bills pertaining to the years such and such, as no input tax credit will be available to the bank. You are therefore advised to raise fresh invoices for the relevant period. The same has already.
So they have admitted an amount,
yes,
but not paid.
This has not been paid. This has not been paid.
Very well.
They
A
have
prima facie case of contempt has been made out inasmuch as the alleged contemners have apparently not complied with the direction dated August 10, 2023, passed in WPO 1481/2023 to disburse the admitted amounts to the petitioner. Full stop. Accordingly, the petitioners shall serve copies of the contempt application on the alleged contemners, indicating that the matter shall be listed on. How soon can you serve? 3 weeks?
more than enough.
Not enough.
More than enough.
More than enough.
More than.
Shall be equivalent listed on April 12, 2024, when the petitioner shall file an affidavit of service. Serve and come back. Let us see.
Deep levels.
Code application under Article 26. Item number 2.
Lordship, this is my application, Your Lordship. Lordship, if Lordship recalls, this is that matter, Your Lordship. On the last occasion, I had moved.
Yes.
I had filed an application to obtain incentive under the MSME Act, Your Lordship.
Yes.
And my application was rejected only on the ground that it has not been filed online, and Lordship has passed an order, Your Lordship, wherein the respondents were called for a report asking for 2 particular queries, Your Lordship. May I read out Your Lordship's last
Online is mandatory. They have to show.
Your Lordship. The second last paragraph, Your Lordship.
Oh, portal was kept open for applications. Yes.
Lordship.
Hand over a report.
Lordship, to my respectful submissions, these particular 2 queries have not been at all, Your Lordship, addressed in their report. I shall indicate, Your Lordship.
Yes.
Well,
Please take your seat, ma'am. Yeah, I'll hear them first. Yes.
Well, first of all, the report contains several issues. What we'll have to address on the last occasion, that was there was no report, as I have already placed before Your Lordship.
These 2 aspects had to be.
Yes, these aspects and others too. What has happened with respect to the second point, as has been pointed out by my learned friend right now, portal was admittedly not open at that point of time. It was not. But an opportunity was granted to them, as because normal portal, there was a time limit. After that, opening of that time limit will ultimately open the floodgates for all. That cannot be done. There was a time limit within which the portal was open. They have been given a specific notice that within 7 days you come online. They ought to have approached with their numbers. We would have generated that particular opening for only for them, not in general for the public.
Why are they special?
Because they have been given an opportunity, because they already applied offline when there was no online mode. Thereafter, certain queries were made. I'll demonstrate from the.
Sir Ganguly, if they had applied offline when there was no online portal opened, so why didn't you accept the offline application simply?
That cannot be.
Why resort to this technical?
Yes,
this reason business is being stalled in our.
No.
State.
They have not availed that opportunity. They have been given an opportunity for 7 days. Window was granted.
Online.
Yes, they could have come, because what is there? The first query of Your Lordship, whether it was made mandatory or not. That I am addressing the first.
That is a stronger point.
That has to be good. Now, if we don't get it online, all others, we cannot distinguish between everyone.
You can insist, but just show me that it was mandatory.
Yes,
You have every right, Mr. Ganguly, to have a policy decision that everything has to be online.
That is the difficult.
I don't disagree with that. Definitely, you are the state, you have that right. But show me that it was in place.
Yes. If Your Lordship kindly takes up page 11 directly, that is annexure 4 of the report, my lord.
Yes.
There, at the 7th minute of the General Managers Conference, my lord, this was decided, where I'll take Your Lordship directly to page 13.
You have not taken me directly there, but I'll go to page 13. Yes. You went via page 11.
We every day learn, my lord.
Wrong things. Yes, Mr. Ganguly, where is that clause? 6.
The last point of the 1, 2, and 3.
Yes,
that is 6.
It is very clear.
For submission of incentive applications through online is mandatory from 1st of January 2018. That is number 1. Number 2, the next page. that is also very important. The very first paragraph, my lord. For continuous benefits, that means whose applications have already been accepted. They falls within this category. Continuous benefit of approved cases. GM, DIC, sub-DICs have been requested to enter previously available benefits in newly launched online system under the same scheme.
That is from your end.
From our end.
Yes.
But their application was not complete at that point of time. Why, I tell you, Lordship? Well, if you
They had to comply with this only.
on their own, because we cannot do it as because this is.
But if the portal was not, first point, I appreciate that it was mandatory.
It has to be.
And let us proceed on that premise, Mr. Khan.
On that 14.
Yes.
Inadmissibility of energy.
I'm sorry, which one?
B, on that page 14 itself. 7B. 8B, I'm sorry, 8B. Same page, 14.
8B, yes.
Inadmissibility of energy charges due to discrepancy in the date of commencement of commercial production and obtaining of consent to operate. A gap is being created between date of commencement of production of the unit and obtaining certificate of operation COO of WBPCB, and according to AG West Bengal, payment of any type of incentive to the unit in this gap, that is in absence of COO, that is certificate of operation, is irregular. In this present case, there is a huge gap.
This does not take a decision on that. It will be referred to the cell.
Yes, that's why these were the queries that has been addressed to them. But my lord, if I may take your lordship to now, the letter what we have issued initially, page 19 of the report, my lord. That is also annexed with the writ also.
Anyway,
page
for
19.
the sake of convenience, 19.
My lord, this is dated 21st October 2022. With reference to the above, you are requested to apply your claim in online portal as per WBIS 2013 and submit the hard copy within 7 working days to this office of the undersigned. Now, my lord, that point of time, lordship's query was on the last occasion that whether portal was open or not. Had it been open, then they could have on their own done it. What we were on, we asked them this: if they only come with UDDYAM Aadhaar number and registered phone number that is required, we could have generated only for them their purpose. That's why we have given a 7 days window. Now, when they are replying to this, my lord, they are replying to this letter. That is at page 17.
17, we'll go back.
Not 17. My lord, I'm sorry. My lord,
There's only one page after this. That is not their reply.
Lordship, my reply is at page 97 of the writ petition, your lordship.
Let me just indicate the reply to Kobe.
Thank you.
10, 18, 2019. Yes, page 17 again. Let me take back 17 again. 17 is dated.
Yes.
17. Well, their reply was page 97. Yes, their reply of the writ petition, my lord.
So we didn't have 7 days, 28th.
Well, their reply is 28th October 2022.
21 plus 7 is 28.
Yes, on that last date.
Rightly so. So what?
My lord, now they had to come through online to consider. My lord, if your lordship kindly takes up that page. We refers to the above to this to inform you that we have submitted our subsidy claim in hard copy only on 28 March 2017 at the time when no online portal. These are not we are not coming. The second paragraph. In this regard, your kind attention is drawn and to state that no online portal facility is available now under WBIS 2013. At present, only online Mongosri application submit online facility is prevailing in our portal. Under the above circumstances, you are requested to kindly look into the issue sympathetically and to take appropriate action as deemed fit and and to intimate us if any further action can be taken from our end for the settlement of the issue. Now, my lord, why we asked them to within 7 days, had they been coming to us with only with this, we have specifically indicated in the report also, my lord, that is page 6 of the report. If your lordship kindly takes up.
Yes.
Paragraph 13.
13.
On 21st October, we have requested them, that is Hooghly, our DIC Hooghly has reported them, that to the unit to apply through online. But no request came from the unit to avail the portal within the stipulated time period. They have to come, they have to give their number, because that opening ID number will ultimately go into their mobile number.
Mr. Ganguly, on the in the communication dated 21st of October, you have said you are requested to apply your claim in online portal and submit hard copy. They say they had submitted hard copy, but online. No, online portal was not available at that point.
It was not available.
Your other Sris were there.
My lord,
Bangla Sri.
My lord, they had to come. We ought to have generated, my lord. Why
should they? I mean,
this letter came on the 1st of the next month. That is 1st of November, we received this letter.
What a flimsy approach from the state, Mr. Ganguly. You gave them 7 days. They applied on the last of that 7th day. On the 7th day, actually, they said your portal is not open. It's open for some other Sri, Bangla Sri. And I am not being able to furnish it online. But they had already given you an offline.
That letter we have received on 1st of November, 22.
Maybe.
That means after 7 days.
You
Lord,
did not
whatsoever.
say there that I have opened up the online portal for
I have
you.
not opened. Had they been coming to us, we have.
This reason you have refused.
My lord, because if I open in general, all people who are, it has to be open for all. If we open in general, then ultimately what will happen, my lord? At least 50 other companies are 100.
It was open for what period? Between what periods?
It closed before this. That is admitted position. At that point of time, it was not, online was no more there. That is admitted position.
I don't understand. The scheme was valid from when to when?
The scheme was valid.
Let us get the dates clear first.
April 2013 to March 2018. That is at page 22
of
of the writ petition, your lordship.
I'm sorry, please give the dates again. April 22?
April 1st, April 2013 to March 31, 2018. Page 22 of the writ petition. And we applied, your lordship, on March 28, 2017.
You applied by that offline. No
That
online.
offline. The form
That
was
point
there,
of-
your lordship, in the scheme. In that format, we applied.
So offline was valid then.
Offline was valid then, your lordship, because online they say has come from April 1, 2018.
Yes.
January 1,
2018.
January 1, 2018, I think.
The scheme contemplated an offline application at the relevant point of time when they applied, Mr. Ganguly.
Yeah, because online was not
Because online
operative
was
at that point of time.
So they've duly applied.
My lord, but the reason
What
is,
else remains for them to do?
my lord,
Why should they submit again afresh?
My lord, that's why I pointed out, my lord, that page 14 of the report. That means who has already completed all the formalities, there we will upload it. But if not, their application was not complete at that point of time due to that gap of almost 10 months, my lord, that I have shown. My lord, their consent to operate certificate was taken much later than they have started the commercial production. And I have shown, my lord, that's why that 8B, that this was deemed to be irregular. So therefore, we can, had it been their application is complete, it was incumbent upon the GM, DIC and sub-DICs.
If the application was complete at the inception, then nothing else would be.
Nothing. That is the difficulty.
Their form was incomplete for 8B.
8B.
8B of your
And that
report.
we have indicated, they replied to this, and some other replies are also there. This gap period has not yet been explained. That is altogether a different story. But my lord, our difficulty is, my lord, kindly, my lord, appreciate, my lord, our difficulty that today, if we have to open in general for all.
Very well. You don't open. So
case specific, we opened for 7 days. That's why we asked them, because without their registered mobile number.
Why should they be special? I still don't understand. If you open it for all, what is the difficulty?
My lord, because they were my lord, for all, if we open, then our closing date is over. then it will be open for all. My lord,
Then why did you open for them in the first place? Because they had applied in time.
they applied in time. That is why we were sympathetic to consider the case.
No, I mean, there may be others also on equal footing.
My lord, no.
What no?
There others are not there. So far, my instructions are
A gap is being created between date of commencement. So this
huge gap. So this needs to be explained, because they has to have a consent to certificate, and at the same time they will
in the scheme itself.
Yes, they have commercial production started. If I'm, my lord, may I point it out that the commercial production has been started on 7th April 2016.
Yes.
And the consent, the second is they have submitted the consent to operate certificate issued by the WBPACB, which is valid from 28 February 2017 to 2021. After that, they have applied offline. But this gap from 28 from 2016 April to February 2017, this remained unexplained. Now, without consent to operate,
as per your scheme, it had to be contemporaneous.
But it has to be consent to operate is must. After that, they will start for their
start of the commercial production.
Commercial production, and we have
Here
to
the consent was obtained later.
Much later. Much later. That is almost after
So
1 year.
you opened an additional window for them, basically.
Only as we are considering their case, they have given so many representation, but so
But
far
they
my
failed to
instruction are still it is not complete. But whatever, we could have complied with all these formalities if they can at all, because we have no intention to stop a particular company, only one company.
But what else could they do? Because page 97 takes care of your page. This
they've been coming for once.
Coming means to do what?
Well, these two are required, my lord. They have to give their this Udyam Aadhaar number, which has to be put for generating
What
that
is that in your 21st October letter?
Well, that letter is very
that letter clearly says you are requested to apply
Yes,
your
yes,
claim in online portal and submit the hard copy within 7 working days to the office of the undersigned.
And
right?
that is their regional office. They could have come. What
Would have done many things. Let us not be on that. Your letter says ask them to do these two things.
Yes.
Apply online, give the hard copy within 7 days. Now, in reply, on the 7th day, they say that regarding online, your facility is not available, which you admit, yes, it was not available.
My lord, may I just indicate one thing? That application, what they were doing, that has reached us only on November, after 7 days. Though it is dated of this 21st October, as we are taking 28th October of
Yes,
the
1st November. No. Oh, you received also?
Yes.
Oh, manually it was given to you also on 1st
Yes.
So what difference does it make? If the car
For online application, these are mandatory. Without these, we cannot generate even. We cannot also generate, my lord.
What? This means?
Their number, what they want to apply, they want a number, registration number for online. That can be generated in normal course by them.
You wanted a hard copy and an online application. They say online is not available. And at page 97, they say with reference to above, this is to inform that we have submitted our subsidy claim in hard copy dated such and such. Copy is also enclosed. As at that time, no problem. So they enclose the copy of the hard copy.
Well, they enclose,
and they say I have already filed the hard copy and I am enclosing a copy with this letter also.
But
so they were 4 days late.
Well, a hard copy of that the online application, they have to upload each and every document online after this.
Online portal was not open. How could they do that?
They should have come up with the first instance. That is why we have given 7 days to open.
You cannot hold them guilty for non-compliance of an impossible clause. You ask in your letter dated 21st of October to do an impossible thing. You ask them to file online. Whereas you should have known that the online portal is not open. Your portal you don't know. And you ask them to do it online.
Well, I'm grateful, my lord, but let me
Should
put it
not
this
be.
way, my lord.
Should not be grateful.
Today, if I have to open, I have to follow the same thing that we'll have to open.
Forget today. On 21st of October, we have to see that date only. 21st of October, you say 2 things to them. You give a letter. Come within 7 days. Come with what? File an online application and give that hard copy to us. If the online application, admittedly, it was not open, the portal was not open, they could not have filed online.
Had they been trying this one and coming back to our regional office, My lord,
Coming back to regional office is not a part of your instruction in the 21st October.
My
Why
lord,
should they come and just pay obeisance to your officer? Why?
My lord, the only issue is otherwise we cannot help them out. We cannot generate it. It is our difficulty. My
They
lord.
wrote, you obtained this on, you received this on November 1st,
11th,
only 4 days after.
By
So
that
why did
time-
you act on this? They already have filed an application.
My lord, by that time, my lord, that application we can consider after this 1st January 2018. Only after coming of this online.
Opened a window for them. You said file online.
Yes, we were there to open that one. Had they been approaching within 7 days, my lord, that has the factual aspect, my lord, I have placed before your lordship, my lord.
7 days, they were not asked to approach you, Mr. Ganguly.
My lord, yes, it is
They
not
were
appearing
asked
on the
within 7 days, they were asked to file online, to place the hard copy before you. They say the online filing is not possible, your portal is not there,
My lord.
which was not functioning. So how could the rest follow?
My lord,
So what they did, the next best thing they did, I have already filed hard copy, I am enclosing a copy and your online is not open, so I cannot comply with 21st. You have given them the opportunity, but you take away the opportunity because they are 4 days late.
My lord,
That is the approach of the state. You are not an ordinary employee, Mr. Ganguly.
My lord, ultimately, even if they give a letter that won't serve, my lord, they have to come any day. We have to open it for case specific purpose. My lord,
Open what?
That portal. Otherwise, unless they
We are
come, we
coming
cannot
back
do anything.
again and again to the
My lord,
same.
that
These were not referred to in your letter.
my lord, not referred to.
To us,
I
we
admit,
open
my
a
lord.
portal.
My lord,
What ridiculous arguments, Mr. Ganguly. You are instructed and you are making the arguments
my
without
lord,
thinking.
I am just placing.
You never ask them. If you ask them, come to us, we'll do whatever you have to. They would come to us, it come to you.
My lord, in that
They would
occasion,
come to you and pray before you, please open the portal.
my lord, may I-
Because the government of West Bengal, BSNL, does not have the opportunity to open the portal. They don't have the whereabouts. BSNL, which is an online, it creates online opportunities for people. It cannot open a portal.
your position we have placed before your lordship, my lord. Then in that occasion, my lord, what we
Your
are,
officer should be jailed for this, Mr. Ganguly. For this reason, business is not happening here. They come 4 days after. You ask them to file online. Online portal is not open. Unimaginable anywhere in the world, any civilized society.
my lord,
You direct them to file online. Your portal is not open. And you are castigating them. You are refusing them a subsidy as if it is your forefathers' property.
my lord, no, not only that, my lord, ultimately we'll have to look into why this gap and all that has to be looked
Where have you
into.
communicated to them? We have to look into, place those documents. Show me.
My lord,
Show me a single letter that you have asked them to produce these documents.
several letters they are coming up with the further documents they have given. Hard copies are there, my lord. We cannot
After this.
My lord, yes, after this, there were communications were there, my lord.
Then what happened after that? They failed to satisfy your officer with sufficient
My lord, no, not
material
My
instructions.
lord, this gap has still not been explained, my lord. As to my instructions.
You explain. Your gap you explain.
No, it is not my gap. My lord, they will have to produce these two certificates. Why this has been, there is a delay. My lord, therefore, my lord, if I may suggest one thing.
Yes, now you may.
No, my lord, factual position I have to place before your lordship, my lord. Whatever has happened, even if it is our
You have
responsibility, my lord.
been able to fully dissatisfy me with the factual.
My lord,
Now,
that-
what about the
that
rest?
is there.
What is your
My
suggestion?
lord,
Come there.
If your lordship so desires, my lord, if they come with these two, if your lordship being case specific, we can only generate their number so that they may upload. My lord, but if in
Why should the others be deprived?
Well, because nobody's application is there because their online has been put.
So why should I put in case specific?
Well,
I'll put in the case. What is the case? They had applied online. The facts of the case I'll narrate. That they had applied online.
But if you have to open in general,
Mr. Ganguly, if you give this, if you give them that opportunity, you have to give to all those people who had applied offline. Why
my
not?
lord, my lord, only these people have came with this peculiar type of cases.
So then why should I put in that additional rider, case specific?
Because my lord,
the facts are case specific. The order will be case specific. This is not a judgment in rem.
my lord, that
I'm not laying down the law that government entities in all cases where online is required, they have to. The facts are clear. The facts are that they had filed offline. There were certain discrepancies which you found out as per your subsequent meeting. And then you pointed out they were given an opportunity by your letter to file online. Online portal was not open. So they approached you after 4 days, within 4 days thereafter, with this letter that hard copy is there. Thereafter correspondence was there. So in that factual premise, they will be permitted. What documents do they have to produce to get this subsidy?
in order to
I'll come back to you. Yes.
my lord, only their registered phone number And at the same time, this Udyam other number, MSME unit have a specific
Your
identification.
learned friend will give it outside by taking instruction from a client. This will take half a minute time. But this you are not granting this.
Well, that 7 days will now be extended for them.
Why this peculiar attitudes in I don't understand, Mr. Ganguly. You don't advise your clients. Yes, anyway, these two are to be given. Uddam Aadhaar number and the registered phone number.
Then we can
Lordship,
generate.
that is annexed to the writ petition. My MSME certificate is annexed to the writ petition.
No, that
The
is.
Udyam number is there.
Oh, give me the page numbers.
What is
and registered phone number is there also.
Registered phone number. It
I'll
is there.
start
It's
like
there, Your Lordship.
I'll
It is
start
there.
like Justice Shonjit Banerjee. I'm telling you, Mr. Ganguly, this is a peculiar case where, due to a registered phone number, the subsidy was refused to something like
My
that.
lord, we bow down to your lordship. Whatever, my lord, falls from your lordship, my lord, the only reason is, my lord, kindly, we cannot open for all, my lord. Kindly, this is our humble submission because that day already is much over much earlier, my lord. So this is for this particular case. We are sympathetic. That is what we are communicating. We are trying to do it out. Not that because we also have in mind that they have a application offline. Even if offline, it is there.
Nobody else applied offline.
My lord, the offline.
Can I believe it, Mr. Ganguly?
My lord, so far my instructions are there, my lord.
Can your instructor believe it even?
My lord, till now,
Ask her to sign an affidavit. I'll take it on record on Tuesday and I'll pass my. On Wednesday, I'll put her to oath. Let us state that on oath that nobody else applied. Put it on oath. I'll just put it on oath. I'll keep it on record and pass it on. That your officer says on oath that there is no other offline application. I'll take it on record. Why there should be a special case for it?
Yes, my lord, none of them has been given any opportunity. So far, I have been told, but even if there are no pending cases till now. They have says online portal is off.
Because the others chose not to come to court.
My lord, because
or do not have the means to come.
It is off. My lord, not today. It is since for last more than 2 years now. So therefore, my lord.
Yes, your phone number, registered phone number, and that.
Lordship, that is at page 20, Your Lordship. Registered phone number and my Udyam number. Lordship, the registered phone number is
WB07. This is the number.
Yes, Lordship, that is the. And mobile number is, Your Lordship, at the first column, the bottommost, left bottommost row.
We cannot submit.
What is this? Your application? Your
Lordship, this is
registration
the
certificate.
certificate, Your Lordship, the MSME. Lordship, may I just indicate a few things, Your Lordship?
Yes.
Your Lordship, my application before Your Lordship is only on the ground that my offline application, my application has been rejected not on merits but only on the fact that it has not been filed online, Your Lordship. Lordship, the scheme was operative from 13 to 18, Your Lordship. I applied in 17, Your Lordship, as per the procedure Your Lordship has seen. Lordship, several communications were there.
Ma'am, what about the discrepancy they're pointing
Lordship,
out?
I am indicating,
Yes,
Lordship.
indicate that because that is
Lordship.
the sticking point.
Lordship, every discrepancy, Lordship, but they have not rejected my application on merits. They have not rejected my application on that point that there is a gap of 10 months or
This
what.
is the new thing which is coming up in the
Lordship,
petition.
there's discrepancies, Lordship, the discrepancies which they raise, the queries they raise, I respond for about 5 years, I go on responding, Your Lordship.
Did there is this discrepancy, this gap between this
It was
commercial production
I shall see, Your Lordship, if that was there and that has been replied to. I'll just.
So after that reply, what?
10 of our report also contains.
So those were also a part of your communications. So
Lordship,
why didn't you resolve?
It has been part of my communications, Your
Then
Lordship.
what happened?
Lordship, thereafter, on October 10, 2022, Your Lordship, after almost 5 years, when they first time say that you are requested to file online and submit hard copy. Lordship, I replied, Your Lordship has seen. Lordship, now the query which they raised that.
No, this letter dated 21st of October or whatever. I mean, that was after all these.
After all this, Your Lordship. After all this. When all queries were going on, when I was responding to their queries, whatever documents they are asking for, Your Lordship. After 5 years, suddenly, Your Lordship, after my last query, Your Lordship.
Resolve this.
Lordship, just one page before that query is there, Your Lordship, at page 95, Your Lordship. The date of, in fact, that exact query, Your Lordship, is at page 95. My reply to that query. When they say that the date of commencement, that gap, the subject of the letter is confusion about date of commencement of production in UM and Udayam. So that is my letter. So we have replied, Your Lordship. After this letter, Your Lordship,
Say that the date of commencement as typed in your that certificate is wrong.
Your
You had
Lordship.
commenced earlier.
Lordship, that is what has been written here, Your Lordship.
Yes.
Which is true and actual. However, date of commencement production mentioned in certificate is totally wrong. Well, whatever, but Your Lordship, they have not rejected my application on those grounds, Your Lordship.
Even after getting this.
Even after, Your Lordship, because this letter is, Your Lordship, page 95 letter is dated July 6, 2022. Then, Your Lordship, October 21, when they give me that letter,
What is the
asking me to,
rejection, please? Show me the-
Lordship, the rejection after 28 October, I reply. Thereafter, Your Lordship, I have made several communications.
When is the last rejection?
Lordship, last rejection is, Your Lordship, at page 102, June 12, 2023. So about almost 8-9 months, I have followed up. I have kept on giving them letters. And then they have ultimately rejected my application on the ground that it is not possible to process your offline application. And Your Lordship, on my reply dated October 28 also, I have said, because they just asked me to apply online. They did not ask for my Udayam number or anything, although they have it, but they did not ask. But still, Your Lordship, I have written that you're requested to kindly look into issue and to take appropriate action as deemed fit, and to intimate us if any further action can be taken from our end for the settlement of
So,
the issue.
Mr. Ganguly, I'll set aside the only ground which you have cited. I'll say the Uddam number and the phone number are there at page 20. Act on that, give them the subsidy. If there is no other eligibility thing, because otherwise they're eligible.
Well, that gap is still,
Lordship, they may just.
So far, my instructions are
But
that.
you did not
has
deal
to be
with
cut.
that. They have given the answer, their answer.
But my lord, we have not considered that aspect of the matter. That is admitted position. We have not considered, because we have only considered that unless you come online, we cannot consider any further.
Lordship, may I suggest,
That has to be looked into. My lord.
Yes.
Lordship, they may just consider my application, which is there
They
with
also
them.
have to consider your letter dated July 6th, page 95.
Whatever queries they have raised till date, Your Lordship.
They'll give you a date of hearing if necessary.
Lordship.
Learned counsel for the petitioner content. The report filed by the state today be kept on record. Push up, it transpires from the same that as per the extant rules, online filing of the application for the subsidy scheme was mandatory. Push up, however, with regard to the second query which was raised by the court on the last occasion, the state admits that the online portal was not operating at the relevant juncture. Certain facts are relevant in the present case, the scheme in question, that is the WBSIS 2013, was operative between April 1, 2013 and March 31, 2018. The petitioner applied for such subsidy on March 28, 2017. Next para. Subsequently, there were communications and correspondence between the parties. One of the issues raised by the state was apparently that there was a gap in the commencement of commercial production by the petitioner and the consent of operation being obtained. Next para. By a letter dated July 6, 2022, annexed at page 95 of the writ petition, the petitioner had replied to the said query, giving certain explanations, which were never dealt with by the respondents. Subsequently, on October 21, 2022, the respondents communicated to the petitioner, such communication, annexed at page 96 of the writ petition, was cryptic and requested the petitioner to apply the petitioner's claim in online portal as per the WBIS-2013 and submit the hard copy within 7 working days to the office of the General Manager, District Industries Center, Hooghly, who was the author of the communication. Next para. On October 28, 2022, the petitioner wrote to the respondents, which was received by the respondents on November 1, 2022, to the effect that during the relevant period, no online portal facility was officially available under the WBIS 2013, Full stop. Next para. Insofar as hard copy is concerned, comma, the petitioner clarified in the communication that the original hard copy of the application along with relevant documents had already been filed on March 28, 2017 and enclosed a copy of the same with the petitioner's communication dated October 28, 2022. Pushed up. Next para. Subsequently, there was further communication between the parties. Pushed up. However, comma, without any resolution on the issue of the purported gap between the date of commencement and the consent of operation, comma, the respondent authorities, comma, by a communication dated June 12, 2013, intimated the petitioner that
June 12, 2023,
sorry,
Your Lordship.
June 12, 2023, June 12, 2023, comma, communicated that the portal of WBIS 2013 had already been closed and there is no scope of new registration in the portal, comma, for which it was not possible to process your offline application, process the petitioner's offline application. Full stop. Next para. Such abrupt closure of the negotiations between the parties over a prolonged period is not only absurd but also irrational. Push up. Next para. It is not the case of the respondents that the petitioner had not applied in offline mode. He had not applied for the subsidy scheme at all. Full stop. On March 28, 2017, comma, when the petitioner made its application for the subsidy, comma, not only was the scheme operative, but there was no online portal available. Full stop. As such, comma, the filing of the application for the scheme offline was perfectly legitimate at that juncture. Full stop. Next para. Subsequently, certain issues were raised by the respondents regarding which correspondence was going on between the parties. Full stop. The petitioner had in fact gave an explanation from the petitioner's end explaining such purported discrepancy which was perceived by the respondents. Full stop. Next para. The respondents, in all fairness, ought to have resolved the issues if necessary by giving an opportunity of hearing to the petitioner. Full stop. Next para. In fact, comma, by the communication dated October 21, 2022, comma, the respondents had merely asked the petitioner to make an online application on the online portal and submit the hard copy consequential thereto within 7 days. Full stop. In view of no online portal being open at that juncture, as per the WBIS 2013, comma, such request itself was not only absurd but palpably irrational. Full stop. Next para. Thus, comma, there was no scope of the petitioner to comply with the same. Full stop. The petitioner did the next best thing possible, comma, that is to write a communication, comma, which might have been a few days beyond the stipulated 7 days, comma, indicating that the online portal was not available and also indicating that a hard copy had been filed and a copy whereof was enclosed with the communication. Full stop. It was the incumbent duty of the respondents, comma, thus, comma, to consider the petitioner's application, comma, given in offline mode initially, comma, in along with all the subsequent communications and the documents furnished by the petitioners, as well as the explanations furnished by the petitioner in their written communications. Full stop. For such purpose, comma, since the respondents had kept the channel of dialogue open with the petitioner all through, comma, the respondents were to give an opportunity of hearing to the petitioner and to decide on whether the discrepancies perceived by the respondents could be resolved in order to grant the benefit of the scheme in favor of the petitioner. Full stop. Next para. Seen from such perspective, comma, the impugned rejection of the petitioner's claim under the WBIS 2013 scheme was unlawful and patently arbitrary. Full stop. Accordingly, the said impugned rejection is hereby set aside. Full stop. WPO 119 of 2024 is accordingly disposed of by rejecting the said communication of the respondents, setting aside the petitioner's application for getting the subsidy under the WPIS 2013 scheme. Push up, the respondents shall now give an opportunity of hearing to the petitioner within a fortnight from date. Full stop. The petitioner will be entitled to produce all documents and communications between the parties and to convince the respondents as to the entitlement of the petitioner under the said scheme. Push up, next para. Such entire exercise shall be concluded within a fortnight. Push up, upon such hearing being given, comma, the respondents shall decide on the entitlement of the petitioner in the light of the documents produced and the discussions made, and intimate the outcome of such decision to the petitioner. Push up, such exercise shall be concluded within a further 4 weeks from the date of the hearing. Full stop. And no rest to cause unnecessary.
Deeply grateful.
Thank you.
I'm grateful.
Thank you, sir. দুটো ছিল এই রে Mr. Mitra.
I hope that I will not.
This is that paucity of time case. Yes. Yes, I'm sorry, I disturbed you. Yes, yes, Mr. Mitra, you're saying something. Yes.
Yes. No, I hope I will not take long, my lord.
Yes.
Now, my lord, the petitioner, my lord, is a director in a company which is the respondent number 5. It is a family company. As usual, my lord, disputes in the family. They are fighting, my lord, since, my lord, about 2003-4, sometimes around then. There is a suit, there was a suit, then, my lord, now, my lord, the disputes are pending before, my lord, the National Company Law Tribunal, my lord, it's still pending. Regarding the management, the petitioner has been ousted therefrom. We are not on that. Now, my lord, suddenly he is a cancer patient. I have given documents to that effect also. Suddenly, my lord, the Demat accounts are, my lord, freezed. Now, kindly come to the documents. Promoted director. Kindly come to, my lord, page 38.
Yes. Yes, sir.
My lord, Calcutta Stock Exchange is writing to, my lord, these authorities who are, my lord, controlling this Demat account. Please note that CSE requested via its later communication to the following suspended since the year 2000 as per the records of the exchange. Companies starting the month of October 2023 to all the non-compliant suspended listed companies of CSE who failed to submit their compliance and did not approach for revocation of suspension of their companies. The Demat account of their promoted directors of the following companies are going to be freezed. As mentioned in the said communication, and subsequently CSE will follow the provisions as per the regulation 32(1) of such and such SAB delisting of equity shares regulation, read with all its amendments. Now, my lord, the company's name is, my lord, at page 39. Serial number 13.
Yes.
And amongst, my lord, the names of directors, I am, my lord, the number 3, Mihir Mohan Pai.
There are 2 petitioners.
Petitioner, yes. Mihir Mohan Pine and his wife, who is not a director, but whose, my lord, Demat account has also been, my lord, freezed.
No one in the
Now, my lord, I immediately approached, my lord, the respondent number 1 CSE. I gave a mail. I kindly come to, my lord, page 45.
Yes, 45.
Or my lord, kindly before that, kindly come to page 44 once, my lord, the document which I showed. I should show this also.
Yes.
The document which starts at page 38, kindly come to page 44, the last paragraph.
Yes.
Your good officers are requested to take necessary steps by freezing Demat accounts of the promoted directors as available, under intimation to us, and also forward us if any representation made by the concerned non-compliant companies, etc. Then, my lord, now kindly come to page 45. Or, my lord, kindly come to first page 46, where, my lord, I sent a mail, the trailing mail. You were requested to let me know the listing fees and other dues payable by the company. An early reply would be highly appreciated. Then kindly come to, my lord, the reply of, my lord, dear sir, madam, as per your request, we have checked the compliance status of your company. Second paragraph, in order to revoke the suspension of trading of shares, you can apply for revocation of suspension notice available on our website, dated 2nd August 2022, and submit the required documents declaration in accordance with the CSE checklist for revocation as available on our website, etc. Additionally, in this connection, as per notice available on our website, you are required to pay a sum of rupees 5,30,515. Kindly come towards the bottom of that, my lord, mail. Please note that the second paragraph from the bottom, my lord, the penultimate paragraph. Please note that in case of penalty is chargeable on your company as per such and such, then the amount of penalty is required to be paid along with the above mentioned outstanding dues. This calculation is valid for 7 days, etc. Now, my lord, the whole difficulty is, my lord, I cannot, my lord, give any document because I am not in control of the company. Now, it is for the board of directors. I have also given notice to them. I am agreeable to pay the money. I can pay the money. That much I can do.
As per the rules, I mean, it's probably necessary. You are a director.
I am a director, but
for revocation, if that is necessary,
I am not in control of the company, my lord. That is the difficulty. That is why the litigations are pending. And, my lord, these litigations are not litigations of, my lord, 2000, my lord, 23 or 24. I have given particulars of the litigations, my lord. Those are pending for long. Then, my lord, kindly come to one document, my lord, one further document. Kindly come to page 47. This I get from my lord, the HDFC Bank. Dear sir, this is to inform you that in accordance with SEBI circular number such and such, freeze client level suspended for debits has been executed on the following beneficial owner. First holder name, Mihir Mohan Pine. Second holder name, Purnima Pine. Now kindly come to page 49.
Yes.
Now Purnima Pine is the first holder. Her account is also, my lord, freezed.
But it's a second holder means also it's a joint account.
Yes. Yes.
So you have the entire account, I mean, that they'll have to satisfy. But both are joint accounts then.
Both are joint accounts.
How can it be segregated between you two?
The first account holder, my lord, operates the account, my lord. Second account holder, my lord, is not the operator, basically. That is why, my lord, is
But
there.
he is also the owner of the account, a joint owner of the account. Whatever is there in the account, she is also equally entitled.
Very well, my lord. Kindly, in that event, my lord, I shall place, my lord, the Security Contract Regulation Act.
Yes.
Copy.
Security Contract Regulation
Section 21.
SEBI Act আছে।
এক মিনিট দাদা।
Oh, thank you. Yes.
এটা পড়ে দেখাচ্ছি। Mm-hmm. My lord,
Yes.
এটা দিচ্ছি kindly.
I'm better placed.
Wise. My lord, kindly come to my lord, section 21A once.
Yes, Mr. Mitra, 21A.
A recognized stock exchange may delist the securities after recording the reasons therefore from any recognized stock exchange on any of the ground or grounds as may be prescribed under this act, provided that the securities of a company shall not be delisted unless the company concerned has been given a reasonable opportunity of being heard. Then a listed company or any aggrieved investor may file an appeal before the Security Appellate Control Board. This is the only provision, my lord, for delisting. My lord, there is no provision, my lord, for, my lord, suspending the operations. And my lord, in this connection, also kindly come to rule, my lord, of the 1957 rules. My lord, kindly come to rule 21.
1957 rules, this book does not have. It has, 2000 rules and 2021 rules. You are sure that those have not been amended? 1956 is the last rule.
My lord, 57.
57.
57, I don't have that. Then I
Thank you. ওই তো আছে।
ওই পাতাটা দেখে আমারটা
No,
একটু
ওইটা থেকে দিলে বোধহয় পাতাটা আমি বলে দিতে পারবো।
তো ওই you find out. Mr. Mitra. Rule 21.
Yes.
Right.
A recognized stock exchange may, without prejudice to any other action that may be taken under the Act or under any other law for the time being in force, delist any securities listed thereon on any of the following grounds in accordance with the regulation made by the Securities and Exchange Board of India, namely, the company has incurred losses during the preceding 3 consecutive years, trading in the securities of the company has remained suspended for period of more than 6 years, the securities of the company have remained infrequently traded, the company or any of its promoters or any of its directors has been convicted for failure to comply with any of the provisions of the Act or the SEBI Act 1992. The addresses of the company or any of its promoters or any of its directors are not known. Shareholders of the company held by the public has come below the minimum level.
So apparently B was the ground site.
Kindly come back to B. Trading in the securities of the company has remained suspended. No, that is not the allegation.
Starting the month, all the non-com suspended listed companies who failed to submit their compliances already.
Yes.
And did
Now, my
not.
lord, I can appreciate, my lord,
So
that
you have to be a suspended company in the first place.
That's the thing. That's not.
So trading in the securities of the company has remained suspended does not fall within that. That's not suspension of the company.
That let them suspend the trading of the shares of the company. I have nothing to do.
No, that was one of the grounds cited
Yes.
for delisting.
Let them delist, my lord. Let them do whatever they want.
Freezing of the account, you are saying there is no scope.
And my lord, eater কোন provisionটা ছিল?
In 919 bottom, we said that by rescind order delist করতে হবে, and we data set was important because 8th February was the they said that.
Now, my lord, kindly.
Consequences of compulsory delisting ছিল.
হ্যাঁ
Consequence was that they will release it. But
My lord, kindly come to একটা copy দে ওকে My lord, Security and Exchange Board of India delisting of equity shares regulation 2021, which has been referred to by them. দাঁড়ান, এটা বার করে দিই। Kindly come to chapter 5. আমার কপি আছে ওদের দিয়েছিস?
Yes.
দরকার নেই।
সব জানি
জয়ন্ত তো সব জেনে আমিও জানি। Compulsory delisting by a stock exchange. A recognized stock exchange may, by a reasoned order, delist equity shares of a company on any ground prescribed in the rules made under the SEBI Act 1956, provided that no order shall be issued under this sub-regulation unless the company has been given a reasonable opportunity of being heard. The decision regarding the compulsory delisting shall be taken by a panel to be constituted by a recognized stock exchange consisting of such and such persons. Now kindly come to my lord 34.
Page 21. Page number.
Page 21, my lord, at the bottom.
Yes.
Consequences of compulsory delisting. Where a company has been compulsorily delisted under this chapter, the company, its whole-time directors, persons responsible for ensuring compliance with the securities laws, its promoters, and the companies which are promoted by any of them shall not directly or indirectly access the security market or seek listing of any equity shares or act as an intermediary in the security market for a period of 10 years from the date of such delisting. Now, this delisting is not done. Kindly come back to their letter, my lord, at page 38. Directors are going to be freezed as mentioned in the said communication, and subsequently CAC will follow the provisions as per regulation 32(1) of chapter 5 of SEBI, regulation 2021.
So you are agreed with the freezing, which is premature. It seems. I mean, there is a provision also, apparently. So let me hear them. Yes.
My lord, prior to taking up any further document, my lord, I'll just take your lordship to page 38. This is the letter, the circular rather, my lord, which was issued by the Calcutta Stock Exchange. I'll just dated 1st January 2024, my lord. Dear sirs, please note that the CAC requested vide its letter of communication to the following suspended companies starting the month of October 2023 to all the non-compliant suspended listed companies of CAC who failed to submit their compliances and did not approach for revocation of suspension of their companies. The Demat account of their promoters, directors of the following companies are going to be freezed as mentioned in the said communication, and subsequently CAC will follow the provisions as per regulation 32(1) of chapter 5 of SEBI delisting of equity shares regulations 2021 read with all its amendments. So, my lord, the concerned company in this regard is item number 30 in this particular document, my lord. Now, what I say, my lord, is no delisting has been done in respect of that particular company. But, my lord, I am governed. In fact, the CAC has the inherent power of freezing accounts in case of promoters, directors who have defaulted in furnishing appropriate documents and information, my lord, under the listing obligations and disclosure requirements regulations 2015. I'll just hand it up to your lordship, my lord. I'm relying on regulation 98. This regulation, my lord, lays down whatever the information pertaining to the company is, that has to be supplied to the recognized stock exchange. Any and every kind of information relating to that particular company. And that is where, my lord, Regulation 98 kicks in, the liability for contravention of the Act, rules, or the regulations. Regulation 98 says, my lord, 1. The listed entity or any other companies thereof who contravenes any of the provisions of these regulations shall, in addition to liability for action in terms of the securities laws, be liable for the following actions by the respective stock exchanges in the manner specified in the circulars or guidelines issued by the board. A. Imposition of fines. B. Suspension of trading. C. Freezing of promoter group holding the designated securities as may be applicable in coordination with the depositories. D. Any other action as may be specified by the board from time to time. The manner, sub-regulation 2, my lord, the manner of revocation of action specified in clauses B and C of sub-regulation 1 shall be specified in circulars or guidelines issued by the board.
So under which provision, which of these provisions did you freeze the Demat account?
Yes, my lord, thereafter, my lord takes up regulation 30, 34 and 35 of this particular regulation.
No, this empowers you to freeze the Demat accounts?
Yes.
98 or
98.
How? 98 does not say so.
My lord, freezing of the accounts of the promoters.
Where is that?
My lord, that is regulation
Freezing
98.
of promoter group companies.
Yes.
Freezing of promoter group holding of designated securities. Freezing of promoter.
I just give you
Promoter group holding of designated securities. The Demat account falls within that.
Yes, because the securities in the Demat account are the designated securities.
All right.
So that is
You have
exactly the reason
no other way to freeze the securities except from freezing the Demat account.
Because, my lord, the listing agreement provides.
But the Demat account may contain
well, those are the securities in which the promoter director of the
entire
listed
securities,
company.
the Demat account, the entire securities in the Demat account are part of the securities, of your securities.
My lord, because it's a listed company, my lord.
Listed company.
In that case, my lord, whatever the securities pertaining to these promoters, directors, whoever are there, they are the responsible persons insofar as the listed company is concerned.
Yes.
So that is exactly the reason why, my lord, the Demat account contains the securities, and that is what is required to be frozen. And that is what is the inherent power with the recognized stock exchanges, my lord, wherein they can freeze the account.
Check regulation 34 or what?
My lord, 30, 34.
What do they say?
The difficulty, my lord, is such a voluminous regulation.
Yes.
My lord,
Difficult to manage on a phone, really, because of the small screen.
well, the iPad, the difficulty is the connectivity at
Yes,
times becomes a problem.
So if this is on the disclosure.
Yes. My lord, thereafter, this has to be read in tandem, my lord, with section 21, wherein the listing agreement, section 21 of the Securities Contracts Regulation Act. Because the listing agreement provides for this. Conditions for listing. Section 21, my lord.
Yes.
Where securities are listed on the application of any person in any recognized stock exchange, such person shall comply with the conditions of the listing agreement with that stock exchange. So, my lord, I was required to be furnished with all the relevant particulars of the company which had been listed. Now, my lord, that is exactly the reason why, my lord, I say that this was a stage prior to delisting of the securities, wherein, my lord, we have already sought for information from the company. My lord, that does not form a part of the record, of course, because perhaps the petitioners, they say that they were not a part of the management. But this is just, I'm handing up to your lordship. A notice was issued on 9th of November 2023, wherein the company was called upon to furnish the requisite particulars.
Please, I'll direct them to file a very short affidavit because they have, Mr. Vitral, not stay the freezing right now.
My lord, I will tell you. Kindly give me a 2 minutes time.
No, because they are relying on notices
I'll
given.
tell you.
These have been given to you.
I'll tell you, Lordship. What do they rely on? They do not say that the regulation which has been referred to in their letter contains this provision.
I would have come to that, my lord. I would have come to that. Because
Well,
I'm not
let
at
him
that
complete
stage.
Let him complete that. Very well. Fair. Sir.
Because I'm not at that stage of delisting as of now, my lord. These are the inherent powers with the recognized stock exchange, by dint of which, my lord, the accounts were frozen. The dematerialization accounts were frozen. So, my lord, the provisions of the delisting of equity shares regulations have not kicked
But you
in.
don't indicate in your letter dated 1st of
My lord,
January as to what are the non-compliances so that they can make good those.
my lord, that is what it's there. It's there. All the non-compliance suspended because, my lord, that is
Failed to
exactly the
submit
reason.
their compliances.
That was the letter, my lord, wherein we have sought for the compliances to be made. The listing fees, in fact, that, my lord, has also been referred to in the email which we have issued. Kindly takes up page 45.
Yes, 45.
So, my lord, that is where we say,
Right.
my lord, that the freezing part, the suspension of trading, because that is what I've shown your lordship. Regulation 98, suspension of trading was clause B, sub-regulation B, and C was the freezing of the account.
Hmm.
So, my lord, in terms here thereof, we have issued this letter because delisting, though contemplated, had not been given effect to. So, the purported contention, my lord, of regulation 34 of the delisting of equity shares regulation of 2021 has not kicked in.
Now, they were suspended under what? Because you have said you have been suspended from the exchange due to continuous non-compliances done prior to date of the suspension.
Yes.
So those non-compliances are
My
the
lord,
very
checklist revocation, my lord, these are the list which has been provided.
Hmm.
These are the list of non-compliances, my lord, which ought to have been complied with.
So that is the entire checklist. I mean,
Yes.
which of those they have not complied that you have indicated in that
My
is the
lord,
notice.
they can, it's the link is already provided there, they can always opt for it. And my lord, as it has fallen from my learned senior friend, my lord, that the issue over here is whether he's a cancer patient or not. If the compliances are made, we are ready and willing to unfreeze their account. That is what exactly my instructions are. But until unless, again, my lord, it's a listed company, I cannot make a departure in so far as the petitioners are concerned. Because he is a director.
The
Admittedly.
exact non-compliances you have to indicate.
My lord, the non-compliances, the checklist is there. That is there. It's for the public record. My lord, anybody, it's a public document.
Checklist is the total number of compliances they have to do.
They have to do.
But which of those they have not complied with? How do they know? I mean, you have to
My lord,
allege specifically.
that is how it comes in, my lord. Just the paragraph thereafter.
Yes.
Additionally, in this connection, as per notice, you are required to pay because, my lord, the listing fees are mandatory.
So they have only these payments are left. These are the non-compliances.
And the documents, my lord, because the compliances your lordship will find. That is why I referred to regulation 30, 34, 35. Because, my lord, the information, the annual report has to be there, the annual return, every the list of the shareholders, the existing directors, everything has to be complied with. Nothing has been done by the company for almost good 15, 17
Nothing
years.
means none of those documents have been given.
Because that is exactly the reason why, my lord, it is a completely non-compliant company. And that is exactly what has been laid down, my lord, in the notice of 1st January 2024. Because of the disputes, I am not, as a recognized stock exchange, my lord, I am not required to look into as to what are the disputes inter se between the directors or the shareholders.
No.
All I'm concerned with, my lord, is whether the company is compliant or not. Now, my lord, that is exactly the reason why the directors are to be held liable for in case of any non-compliances by the company.
You cannot distinguish between directors who don't have access to the.
I cannot, my lord.
Which is one of the premises of Mr.
That is the difficulty. Otherwise, if they comply, we are ready and willing to unfreeze their account.
This is all. Yes.
That is all.
Yes, Mr. Mitra.
Kindly come back to their document. The only regulation they have relied on is not, my lord, the regulation of 2021.
No, that is regarding the, then they will follow after this. And subsequently, CSE will follow the regulation, which is the delisting part probably.
No, they nowhere, my lord, have relied on 2021 regulation. Today, my learned friend is relying on this voluminous document 2021 regulation. I shall come to that regulation. But nowhere have they spoken about this.
But checklist revocation, you have asked repeatedly to
I shall
comply.
come to that. I shall come
Yes.
to that. I was on page 38.
Yes.
They have given, my lord, they have spoken about the communication subsequent will follow the provisions as per regulation 32(1) of the
They
2021.
have also said non-compliant suspended listed company who failed to submit their compliances
Absolutely.
and did not approach for revocation of suspension.
Absolutely.
Demat account of their
Absolutely.
following
My lord,
companies. are good.
question is, my lord, of my lord, the freezing.
Yes, you raise a challenge to the jurisdiction, but he cites the regulations. They need not quote the regulation or give the section even in the.
No, they need not give this.
Why should they? If
need
they have power, and
Wait,
they
wait.
have to show they have power under the.
Kindly come to, my lord. Then in that, if you kindly come to this regulation, my lord, regulation 98.
Yes.
Kindly come back. Kindly come back to, my lord, the regulation. My
Yes.
lord, kindly come to regulation 98.
Yes.
Liability for contravention of the Act, rules, or the regulations. The listed entity or any other person thereof who contravenes any of the provisions of these regulations shall, in addition to liability for action in terms of the securities law, be liable for the following action by the respective stock exchange in the manner specified in circular or guidelines issued by the board: imposition of fine, suspension of trading, freezing of promoter group holding of designated securities. Where are these?
Which are there in the Demat account, as he said.
They do not say that, my lord, in the letter, in their email. And kindly, my lord, the regulation, my lord, which 2021, the regulation kindly come to 34, where a company has been compulsorily delisted under this chapter, the company, its whole-time directors, persons responsible for ensuring compliance with the security law, its promoter, and the companies which are promoted by any of them shall not be directly or indirectly accessed to the securities market.
But why should you go to 34? 31 is there. You have to comply. They are on the compliances. Before delisting also, for non-compliance, they can, under Rule 98, Regulation 98.
Yes.
In addition, who contravenes any of the provisions of these regulations, thereby including within its fold 31 also. So you have to comply with the formality, and they have given you notices, emails.
No, that is given to the company.
Yes, you are the director of the company.
Kindly
You are also
appreciate,
liable.
kindly appreciate the difficulty, my difficulty.
But that is not accepted under this
That
chapter.
is not very well.
Law.
But freezing of promoter groups holding of designated securities. My lord, where have they said that the designated securities under this regulation, these are the other shares are also designated securities? That is, my lord, something said from the bar.
Then you could have replied to this, that these do not contain the.
They have not taken this point, my lord.
They have said they'll freeze the Demat account. And they have given you an opportunity, I mean, and did not approach.
My lord, lordship is at page.
I'm sorry, page 38 of the.
Page 38. My lord,
yes.
kindly.
Sir, আমি রেগুলেশন 30টার উপরও রিলাই করছিলাম ডিসক্লোজার অফ events or information মানে regulation 30 of the
yes
listing obligations and
no, Mr. Mitra is on something else. You had to disclose it clearly in your notice itself.
Very well.
Mr. Mitra is on that you have not.
This notice was not issued to my learned senior friend's client. This was issued to other companies, the stock brokers.
So without any notice to them, you have.
Yes. Well, that's not the issue because Malad, I have the powers to freeze. I have issued notices prior thereto to the company, which has not been replied to. Because Malad, I am required to.
With greatest of respect, my lord, my account, I may be a director. It may not be within their knowledge that there is interstate dispute between the parties, but when my account is going to be freezed, my lord,
98C, Mr. Mitra, that is there. I mean,
98, I shall come back to, my lord. For the time being, kindly come to page 38.
38, yes.
Yes. First, my lord, page 38 says are going to be freezed.
Please read from the beginning of that after the search.
Please note that CSE requested via its later communication to the following suspended companies.
Yes.
Starting the month of October 2023. To all the non-compliant suspended listed companies of CSE who failed to submit their compliances and did not approach for revocation of suspension of their companies, the Demat account of their promoters, directors of the following companies are going to be freezed. As mentioned in this said communication, and subsequently CSE will follow the provisions as per regulation 32(1) of the chapter 5 of SEBI regulation 2021.
That is a subsequence, and subsequently it will follow.
Yes.
So we stop at freezing because that is what you are agreed with.
Are going to be freezed.
And then they're frozen or freezed, whatever. You are given an
Kindly come
opportunity.
back to page 44. Kindly come to page 44.
Yes. 45.
44.
4.
The last paragraph.
Yes.
Your good officers are requested to take necessary steps by freezing Demat accounts. First, they say, hey, these accounts are going to be freezed. And my lord,
This is not a notice to you. This is to the authorities who will freeze.
Absolutely.
Say that they have not complied, therefore you freeze.
On the basis of, my lord, if I may ask myself.
Page 45 is one of those. Page 45 is one of those. Given to you.
45?
Yes.
8th February. Reply to my communication at page 43.
So that was subsequent.
Yes. Long thereafter.
What about the previous communications? Were there in previous communications?
My lord, no, and it was not, my lord, to the company there was, and that is exactly what I was handing up to your lordship, my lord, to which there had been no response.
Mr. Mithra, affidavit is necessary here. File it within a week. I mean, within a fortnight. Because only this document and you have to disclose the prior communications.
My lord, prior communications made to the company.
Of course.
And both the accounts, my lord. Even, my lord,
both accounts, yes, Mr. Mithra, because both you are joint holder in both. If they are entitled, they can freeze both. These are Demat accounts, not your pension accounts. Don't make that face, Mr. Mithra. This is the Demat account.
No. Two separate accounts, my lord. Only thing I can say.
Accounts, yes, accounts. If they're permitted to freeze both. You are joint holder. Although, yes, there are certain valid questions which are required to be gone into, Mr. Mithra. First question is, which you are justified in indicating also, that whether these Demat accounts, the entire content of the Demat accounts come within these securities, or there are other shares also.
Cannot be. If I could read out, my lord, it really implies that, yes, the transactions of this company would be stopped.
Or I could do this because there was no prior communication to the, I don't find any prior communication to the company that it will be frozen or freezed.
Well, because
regarding freezing, that's an action. You should have given a notice to them at least.
It should have been given to me also.
You say that because of the prior non-compliances, you have the power, you have done it.
Because, my lord, I am not required, because again, my lord, these are the informations which the company is supposed to provide me with. I've pointed out, my lord, regulation 30. My lord, these are the disclosure or information which the company is required to.
Opposition within a fortnight. Learned senior counsel.
Can that be slightly shorter, my lord?
2 weeks, because 1 week will go. The next week, Mr. Mithra, I suppose you won't be there also.
No.
Learned senior counsel for the petitioner raises certain arguable questions for hearing the writ petition on merits. Full stop. The action of the Calcutta Stock Exchange in freezing the Demat accounts standing in the joint names of the petitioners has been assailed in the present writ petition. Full stop. It is contended that the communication dated January 1, 2024 to the appropriate authorities directing the freezing of the accounts did not quote QUOT or refer to any of the provisions under which the Calcutta Stock Exchange proposed to freeze the accounts. Full stop. Secondly, an account has been frozen in which the petitioner number 1, who is the director of the company in question, is only a second holder. Full stop. Next para. Learned senior counsel places reliance on the provisions of section 21 capital A of the Securities Contracts within bracket Regulation bracket close Act 1956, which speaks about delisting of securities. Full stop. In the present case, delisting has not been effected, it is pointed out, but the Demat accounts have been freezed. Full stop. Next para. While on delisting, Learned senior counsel also cites Regulation 21 of the Securities Contracts within bracket regulation bracket close rules, 1957. Full stop. Next para.
Gmail forward.
Learned counsel appearing for the Calcutta Stock Exchange contends that the action of freezing has been done under regulation 98 of the SEBI within bracket SEBI within bracket listing obligations and disclosure requirements purota capse bracket closed regulations 2015 full stop. In sub-regulation within bracket 1 within bracket small c thereof the listed entity or any other person thereof who contravenes any of the provisions of the regulations, it provides, shall in addition to liability for action in terms of the securities laws, be liable inter alia to freezing of promoter group holding of designated securities, as may be applicable, in coordination with depositories. Full stop. Since the petitioner number 1, the director of the concerned company, was a joint holder of both the Demat accounts, which contain the designated securities, the action of freezing was justified, it is contended, full stop. That apart, learned counsel argues that the company was guilty of several contraventions of the provisions of the regulations, including regulation 30, since for a prolonged period, the company has not been furnishing relevant information and documents as per the extant regulations. Full stop. Next para. It is argued that previous notices were served on the company to that effect. Full stop. Next para. It is further indicated by learned counsel for the CSE that no prior hearing or notice is required to be given to the individual directors or the company before freezing. Full stop. Next para. Since certain factual aspects are also involved in the matter, insofar as what previous action was taken by the CAC before freezing the account, the respondents are directed to file their affidavit within bracket S in opposition within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed fairly at the top of the list on April 15, 2024 for hearing. Fairly at the top হচ্ছে যদি আর কিছু না টপে থাকে তাহলে এটাই টপে দিয়ে দিন আর যদি আর কিছু টপে থাকে তাহলে এটা টপে দিন
My lord, only because of the ailment, my lord, if some time can be fixed, if possible.
তাহলে যেটা এপ্রিল 15 বললাম at the top না করে তাহলে fairly at the top of the list না করে at 2 p.m.
Lordship,
3 p.m. sorry 3 p.m. কোন টাকা ফেরত দিয়ে দাও Any small matter, 2-minute matter, both sides are there. Other side?
I'm for the rest.
You're for the respondent. Your matter is short.
My matter is short.
I cannot finish within 1 minute. There is a difficulty. No, I could have called, but in 1 minute it won't be finished. That's why I'm asking for any short matter. If there is any short matter, I'll decide.
My short matter, I remember 5 miles.
Other side has to be there. Anyway, it's already over, so let us come back tomorrow. Not tomorrow, I mean.